Okay, this May 5th meeting of the Nevada State Board of Cosmetology is called to order at 9 a.m. Thank you. Okay, I'll have the roll from the board members.
Alex Leader, board member present.
Joanna Tran. Joanna Tran.
No, you just push the button once. Oh, Mike? Yeah.
Okay. Joanna Tran.
And push that blue button again.
Perry Nixdorf, Vice President.
Neil Hoffman, board member, present.
April Long, Secretary Treasurer.
Koki Booth.
Jeanette Benaldi.
And also sorry, Gary, go ahead.
Gary Landry, Executive Director.
And then if we could have the roll in Vegas as well, please, ladies and gentlemen.
If you guys could push your mic button and talk into the mic.
Yeah.
Gloria Alexander, Office Manager.
Andrew Helms, Accountant 3.
Monica Bradford, Administrative Assistant.
I was waiting for Annie as well.
We didn't hear you sign in, Annie. If you could just state it over again, if you could speak into the mic.
Annie Curtis, Chief Inspector.
Okay, so now we'll have the Pledge of Allegiance. Flag.
I have a flag on my jacket.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So that'll have to be corrected.
What's going to happen?
Have a flag.
Oh, well, yeah.
It's unusual, but there's not one in there.
Okay. Item number 3 on the agenda, the mission statement for the Nevada State Board of Cosmetology. The mission of the Nevada State Board of Cosmetology is to protect the public health, safety, and welfare through education and ensuring only qualified persons are granted licenses to perform cosmetology in the state of Nevada, and that all areas where cosmetology services are provided are kept clean, sanitary, and safe. Okay. Now would be a time for the general public to step forward and make any comments. Any comments from the public at this time? Also in Vegas, if there's anybody there who would like to speak, now's the time to step forward. Anyone? Anyone at all? Please. Okay. Seeing as there's no comments from the public, item number 5, consideration and approval of the agenda and its posting.
I'd like to make a couple of changes. I'd like to move the Executive Director's report to 20.5 and 19 to number 14.
Okay.
Wait, hold on. There's no 20.5. I mean,
Right.
you can just-
I know, but I just wanted to put the Director's report just below the NIC report.
My understanding is the director's report is on the consent agenda, so that would be something you would have to pull off the consent agenda if the rest of the board is open to doing that. Because as it stands right now, that's something that you guys are
Okay, I
have
was
already
just looking at
consented
it
to.
as for time. Does anybody else want to do that?
I can go ahead and make the motion to pull the executive director's report off of the consent agenda and then move it to the place where Koki is requested.
Second.
Okay, but we've already postponed the executive director's report a couple of times, and it's stuff we need to... Go ahead, Perry.
Okay, the way I see it, I think that Koki's request to move item number 19 after item number 13. I think that would be an appropriate item for under number 5. I think that if we want to do anything with the executive director's report, we should wait until we're considering item number 6.
Yeah, and that's fine with me. I just was wanting to get to the other issues here.
So
The issue is that the executive director's report is on a consent agenda, so you would have to pull it off of the consent agenda.
That was my motion, Miss Deputy.
Yeah, I understand that. I'm trying to. We have a motion and a second for pulling the consent agenda prior to your motion.
yeah.
The executive director's report on the consent agenda. Yes?
Yeah, but I think we should take it in order. Number 5, have Koki move number 19
Okay,
to
so
14.
all we're looking for now is the consideration approval of the agenda and its posting.
Correct.
Right, and we've had a motion to move specific items out of order. So there's a motion and a second on the floor. There's discussion, and now you need to vote on the particular motion. I believe was it just related to the consent agenda?
Yes, but I don't believe that there was a second. There was just Alex's
seconded.
motion.
You
Oh, and
seconded it,
Koki
yes.
seconded. Okay.
Yeah. So the motion now is one of. So now you have a motion to pull the executive director's report off of the consent agenda and move it to after item 20. So it would be right before comments by board members and future agenda items. Is that correct?
Correct.
So I have a question. Did you want to move the entire executive director's report or a page or
The entire report so we can get through this whole meeting today was my thought.
Okay.
I didn't mean to start a big.
That was the intent of the motion.
So there's a motion and a second. I'll have the vote then. Or, I'm sorry, discussion. Any further discussion to this? No? Okay. So I'll have that vote then. All those in favor say aye.
Aye.
Aye. Those opposed?
Nay.
That motion carries.
Are there any other changes to the agenda? Right now, as it stands, it's just the executive director's report that's
So
been
now
moved.
we have to do 19 to 14.
Yes.
I'd like to make a motion to move number 19 to 14.
I'll second that.
Any further discussion? I'll have that vote then. All those in favor say aye.
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 Those opposed? That motion carries.
Consent agenda, all you have are the minutes.
Well, so back to number 5, the consideration and approval of the agenda and its posting according to open meeting law. In the past, Deborah Blasco handled that. Is that something that Andrew is handling? Monica's handling that. Okay, so Monica, if you could let us know that the agenda has been posted according to open meeting law.
Yes, it has, Neil.
Thank you very much. I'll entertain a motion.
Mr. Chairman, I'll make a motion to approve the agenda and its posting.
I'll second.
Any further discussion? I'll have that vote then. All those in favor say aye.
Aye.
Aye. Those opposed? That motion carries. All right. Consideration approval of the consent agenda. Okay, so the minutes then. Consideration and approval of the minutes for the February 3rd, 2014 meeting of this Nevada State Board.
Mr. President, I'll make a motion to approve the minutes from our prior meeting.
Do I have a second?
I'll second.
Any further discussion? I'll have that vote then. All those in favor say aye.
Aye.
Aye. Those opposed? That motion carries. Okay, and having the executive director's report moved to item, I'm sorry,
Right under NIC.
21. So, previous to the first complaint hearing, I was told that I'm supposed to disclose things, so
We do it on every agenda item that's pertinent, so you would do it more than once. And if I could, Mr. President, I would like to wait a few minutes on number 7 and number 8, because those are both Las Vegas cases, and I want to just get confirmation that the exhibits have arrived. So if we could, when we start, it'd be nice to start with number 9, and then do 9, 10 I think is withdrawn, 11, 12, and then 7 and 8.
okay.
Gary, this would be opportune to ask them to move down.
So we can see them.
One request for staff, if you could all move over one chair, because we're not seeing part of you. So if you
Actually,
could
2 chairs.
or 2 chairs.
Starting with Annie.
In Vegas,
If Annie, if you
could
could
all
move down
move
too, and
down
I'll
to
move down
Annie's
too.
right, so we can see you. Thanks, Andrew.
We're missing Monica.
Do we have Monica present as well?
Documents from Sarah.
Sarah, this is Monica Bradford. I've checked in the back office. I really don't have a contact person, so we can go ahead. I have copies of everything as long as you state what it is that you're going to use for exhibits. I think we'll be okay.
Well, actually, someone from my office will be bringing them there. They're just probably having a few minutes to get it together. So there should be someone walking in the room with the exhibits for you, is what I'm saying. So if no one's done that yet, then they're on their way. I mean, unless you have enough copies, but...
Can they hear us, do you think?
I have a general copy, and the inspection department also has their own copies. So, like I said, if you want to go ahead and let us know what it is that you are presenting, we can go ahead and go to that document.
I think marked ones should be on their way, so I will check with them again in a few minutes. I'm not sure what's going on, but I know there was some confusion, I think, so I'll check with them in a few minutes.
From the north, okay. Ms. Bradley,
Yes.
so which item, agenda item were you interested in starting with?
I would like to skip 7 and 8 for now and do 9, 10, 11, and 12, and then go back to 7 and 8.
Was 10 withdrawn?
Yes, for the record, Number 10 is withdrawn. It was issued in error, so I will prepare a notice of withdrawal to send to the person so that they have that for their records. But item 10 should be removed from the agenda.
Okay, so item number 9, we're looking for the Nevada State Board of Cosmetology versus Jack Holmes. Is Jack Holmes present? If you'd step forward, please, sir. So as part of your case, do you have an attorney present or any witnesses here that you're going to call?
No, sir.
Just yourself?
Yes.
Okay. If you'd swear him in, please, Mr. Nelson.
Yeah.
Do solemnly swear or affirm the testimony you're about to give before this board to be the truth, the whole truth, and nothing but the truth?
I do.
Mr. President, one last thing, that we will have to swear in the inspector who's doing testimony on this case of the board
Okay.
side.
Could we have that inspector step forward, please? Oh, just, got lost in the building. I have all this.
Solemnly swear or affirm the testimony you're about to give before this board to be the truth, the whole truth?
I do.
Okay, so Mr. Holmes, the way this is going to work is Ms. Bradley is going to present the case for the state board first, and then when she's finished, it'll be your opportunity to present your side of the case, and we as a board will determine from there.
Thank you.
Okay. Ms. Bradley.
Thank you. If I could, first, the record should show that I'm showing the respondent what's been pre-marked as State's Exhibit 1. Okay. Because, yeah, normally this would be given to you at the time that the inspection. Yeah, so you should. And then. Other photos of the inspection. So I've shown the respondent what's been pre-marked as State's Exhibit 1. Mr. Holmes, do you have an objection to that being admitted so the board can see it?
No.
Okay. So I would ask that what's been pre-marked as State's Exhibit 1 be admitted.
So admitted.
For the record, it's a packet of materials regarding the case, including the complaint notice of hearing, a report of establishment, photos of the inspection, and it's all in one packet.
So admitted again.
I apologize. The complaint notice of hearing normally would have been in your board packet, but not in any of the other documents. So I do, just for the record, I have color copies there's photos at the end of your packet there. I do have color copies if anyone wants to see them. I think the black and whites are a little bit hard to see. I think I have 2 copies of the color that you could share if you'd like.
Is it a little bit less of a Rorschach than the black and white? I mean, they're kind of fuzzy.
Yeah, I have 2 copies of the color. So
Yeah, if you could bring them up, that would be lovely.
Do you have any objection, Mr. Holmes?
Yes, I was just showing it here.
No, do you have an objection to the color photos being passed around up here?
No.
Okay.
Mr. President, the respondent just answered a question, and do we know his full name, and has he been sworn in yet?
Yeah, he was sworn in, for the record. Of course, Mr. Leader.
I'm sorry, what, Ms. Tran?
To know if I can get some of the photos, or is it?
Well,
for
they
us to
should be
share?
sharing them because I only have 2 copies, and Mr. Landry also has a copy that he's sharing with Ms. Bonaldi. Okay, so I would first call Ms. Charlene Marsh. Ms. Marsh, would you please state your name and spell your last name for the record?
Charlene Marsh, M-A-R-S-H.
And who is your employer?
Nevada State Board of Cosmetology.
And what is your job title?
Field and Office Assistant 1.
And as part of your duties as Field and Office Assistant 1, did you do the inspection in this case for Pro Nails license number S11234?
Yes, I did.
And can you tell us about that inspection?
I was there on January 28th to do a re-inspection because on January 23rd, I had found multiple sanitation situations that were unacceptable. On the 28th, I went in and there were shelves in the back room were still dirty. Dirty files, buffers, drill bits at stations, dirty brush on dispensary sink, watched a client use the brush, container with nail brushes, top covered in dust, and also there was a dirty commode and trash cans that wouldn't close because they were too full. On January 23rd, when I issued the re-inspect fee, there was a back room with supplies with open storage. The shelves were dirty. Brush used to clear nail dust, wash and disinfect every use. Multiple dirty files and buffers, nail dust in drawers, brush in open container at dispensary sink. Keep instruments in closed containers and drawers when other items are stored, paper, pens, money. Wood sticks in open containers, store in closed containers. The commode was dirty. Open waste baskets with petty slippers, used cotton, and an empty plastic water bottle were found, and that was January 23rd. I was there originally and then went back on the 28th and issued the citation at that time.
So, just for the record, what was the date of the first inspection?
The first inspection was January 23rd, and I went back on the 28th for the reinspection. The 28th is the date that I issued the citation.
Okay. And were they aware after the 23rd that they should take steps to fix the items that you'd noted on the 23rd?
Yes, and I did tell them there would be a citation and a fine issued if I came back and things weren't correctly done.
And when you issued the citation, did you have a discussion with the person in charge on that day?
Yes, I did.
And what did you talk about?
Well, I always review every single sanitation situation that's noted or any problem at all, and told her that it just really had to be completed. And I also told them that I would really like to do a sanitation review with them. And Mr. Holmes did come in, and that was Tuesday, February 24th at 12. I'm sorry, at 9 a.m.
So he came in and you talked with him about the sanitation rules?
Right. Jacqueline Chandler, an inspector for our state board, as well as myself, met with him.
And what was the results of that meeting?
We tried to review, but I'm not sure that he really wanted to review the sanitation regulations, although he did take the Sani regs with him, which had also been issued to the salon prior.
And have you been back to the salon since this inspection on the 28th?
No.
And is there anything else that you'd like to tell the board regarding this case?
The first sanitation citation was delivered on September 17th, 2013. And same situations were noted again. Brushes at dispensary sink, one sitting in a tray not covered, one in the container with unknown liquid cleaner. Clean before using, store brushes in closed containers, dirty files and buffers, throw away after one use, or give to customer, can't be used a second time. Drawers at nail stations have metal instruments in open containers, clean and store in closed containers. All areas that any instrument is stored must have a dry fumigant. Toilet is dirty. Sink was dirty, clean before using, that was a dispensary sink. Dirty petty slippers in open wastebasket, receptacle at nail drying station. And label all containers. There were several containers without labels, not showing what was in the bottles that they were using. And again, that was on, the date was September 4th, 2013, that the first citation was issued for sanitation.
Okay. And so we're here today because of the second inspection that noted the same concerns, but really it was the third because there was one in September, you went on January 23rd, and then you went again on January 28th.
January 23rd was a re-inspect fee, though, and not an actual citation, but 3 visits that showed the same things.
Okay. And when you say re-inspect fee, I'm sorry, what does that mean?
Well, sometimes it's a matter of us trying to get them to comply with the sanitation regulations, and that's what I was going here versus another citation that would bring them before the board. And unfortunately, they still weren't compliant in a week, so I issued the citation.
Okay. I have no further questions for Ms. Marsh.
Mr. Holmes, if you have any questions for Ms. Marsh, now would be the time for that.
I have no questions.
Okay. Ms. Bradley,
Does the board have any questions for Ms. Marsh?
Ms. Booth.
My question, reading this letter here, it says, the cosmetology board has received information on 12814 that's single-use items. Did that come from the general public, or is that coming from you?
That was coming from inspections for routine inspections out in Fallon.
Okay, I didn't know if it was a private party that did it. Thank you.
Any other questions by the board for Ms. Marsh?
Just to be clear, there were priors on this?
The first citation was September 4th, and then January 23rd, I did an inspection, and I was going to be back out in the area, so I did a re-inspect fee.
Okay.
So that's why I went back on the 28th, and there were still problems. So that's when I issued the second citation.
Okay, so the first citation was September 4th for just more of the same of what you already saw on January 23rd. Okay, thank you.
Well, but to be clear, so you went on the 23rd, back on the 28th, and issued another citation on the 28th of January?
Well, the second citation was issued on the 28th. The first was back in September.
In September of 2013, correct. Okay.
Technically, though, I mean, a second violation isn't really a citation. That's why she's here before the board. So it's only the first sanitation violation that's a citation. And then the second offense, the person has to come before the board. So just to be clear, this incident now is not really a citation. It's a formal complaint hearing because in NAC 644-700, a second violation for sanitation comes before the board in a hearing. So you'll see that there's a report of establishment in your packet and things that make it look like a citation, but really the citation just says hearing in it rather than a dollar amount.
Thank you, Sarah.
Sarah, is there anything else you'd like to present for this case?
If I could ask one more question of Ms. Marsh.
Please.
Ms. Marsh, do you know how long this establishment's been licensed? Is it a new license?
No, they've been there a long time, and I apologize, I don't know an exact time.
I just was, and the only reason I was asking you, do you know if there's been changes? It just seems interesting to me that there's sanitation problems currently, and maybe there hadn't been in the past. I just didn't know why our first citation is in September and now in January. If they've been, do you know anything about that or no?
I imagine they may not have been as extreme. I don't have an exact explanation other than that. Okay.
Thank you very much.
Okay, Mr. Holmes, it's your turn to present your case, please.
Thank you. We've been in business here 5 years. The business itself has been in place for 12 years. And I myself, I'm a retired Washoe County employee. And as such, I have title of this for my wife, who runs the operation. She's been in practice 10 years. And 2 years ago, she was voted Fallon's best. And this year, she dropped down to number 2. And we have modified all of her procedures that she developed through the employment of 3 other cosmetology places to accommodate a better inspection. And I myself don't get in there very often, and so as such, I'm not always on top of the process that is occurring. But if you have any questions as to what has occurred in there, my wife here, Truk Holmes, manages the place. Is there any questions?
Is it for Mr. Holmes or for his wife?
From Mr. Holmes.
For Mr. Holmes? Yeah, my point is she hasn't been sworn in yet.
Oh, okay. Should I wait for her to be sworn in?
If the board has questions that will be answered by her, we can have her sworn in.
Oh, okay. She should probably be sworn in because I'd like to ask her the same question I asked him.
Mr. Nelson, if you could please.
Stand up. Raise your right hand.
Or affirm the testimony you're about to give before this board to be the truth, the whole truth, and nothing but the truth.
If we could have her state her name and spell it as well.
Yeah, my name is Truk Holmes, Truc Holmes.
Okay. I'm the public member here, Mr. Holmes, so I don't know a lot about your business, but my question to you would be is how long do you think it took the toilet to get from to that, the way the picture shows?
There were mineral stains there, and it accumulated through time. I personally tried to scrub them out and had to go out and get professional help to get the mineral stains gone.
Okay. That was going to be the same question because...
We do clean every day, every day.
And what made you get the professional help to clean the toilet?
Oh, we use on kind of bleach or some like that one. And then finally we just call and for the owner, they come to replace, and they said like a few days, and it take about more than a week.
Okay.
So
thank you.
I have a question. Mr. Holmes, do you understand the factual allegations that there are being presented here? And there's 18 of these different allegations, right? Which one of these allegations do you disagree with?
To a certain extent, all of them.
Could you go down the list one by one and determine for me what it is exactly that you disagree and how you disagree with these factual allegations that we're presenting to you?
All right. Number 4, dirty brush at dispensary sink. I don't really disagree with that a whole lot. And nail brushes was covered in dust. One manicure handles that pretty easy. gets dust all over. And single-use items, we have now installed a bucket that identifies to hold them before they were previously thrown in the garbage. I am not sure, not being there, whether or not there was one used twice or 3 times or whatever. But we now have a garbage can for those items.
And now being as of what date?
Since the last inspection, within a day or two.
As of latter part of January?
January, yes.
Okay, thank you. Next.
Okay. All sterilized instruments and sanitary disposable articles must be stored in clean, closed containers, drawers, or storage units, which must be free of other articles. I think that we do that. The fact that the inspector disagreed with us is fine. We'll modify whatever we need to come under a good inspection there. So I already covered 8 there, and then disposal. Nail files, nail buffers. It's hard to keep track of dust or whatever. First thing my wife does when she comes home at night is takes a shower, because throughout the portions of the day there's dust in the air. And so I don't have a lot of problems with sanitary conditions. I want to improve them, which we have done, to meet the minimum standards of Nevada revised statutes. Have I left anything out yet for you, sir?
Well, like on number 11, the board staff believes and therefore alleges that reuse and failure to properly dispose of a single-use item is a cost-saving or time-saving strategy. Are you trying to cut costs or time?
No, sir.
What would give us the opinion that that was the case?
We make money besides this establishment and don't worry about counting paper clips or other minor items. And as such, I feel that it wasn't a cost saver. It was perhaps an oversight on our part.
If that were the case, would that be more negligence on your part?
I'm never there.
Or on her part?
Yes.
Okay.
Mr. Holmes,
Okay,
I'm sorry, Perry.
All right, well,
I apologize.
You can have it in just a few minutes. I just want to go down the list a little bit here. Okay, all right, okay. All right. So on number 12, we allege that this is an unfair and unjust practice, method, or dealing which constitutes grounds. Okay, so it says here that we believe that you reuse and have a failure to properly dispose of these single-use items. Do you disagree with this at all? Do you believe that you don't reuse items and that we are in error?
I believe there has been items reused, yes.
Okay. Number 13, that you don't label things. This is about labeling stored tools, sponges, instruments, and stuff. Are your items labeled now, or were they then labeled? How do you deal with that?
It's easy to label, but when you use the polyp remover and your hand and hold all different bottles and they kind of the name in there with the ink, they kind of fake out. If you look at in there, it should be show you with what is it in there, because they fake it out very easy for the bottles. Now we label with the papers and we just wrote with the the tabs in there.
Got it.
So-
Thank you. All right, that's it for me.
Thank you.
Mr. Holmes, you said that you sanitize or you do what the state board minimum is,
I'm-
and that I find that a little disconcerting that you just do to the minimum. Well, can you expound on that a little bit?
That is a common phrase that I used for years while I worked with Washoe County. It didn't mean that we did just minimal. It meant that that was in accordance with minimal standards, but we always try to reach out and go higher.
Okay, so when you say that you use that you, I'm sure I also would like to know that what the official statement on that was, what he said. I don't remember the exact words you used, but that struck me as concerning, especially when it comes to single-use items. If you're just sanitizing the salon to the very minimum.
No, we're not doing that, and that was perhaps a misstatement on my part, and I apologize.
Okay. One more thing. And you did tell Mr. Nickstruff that you were using single-use items. How often is that? Is this a regular practice, or are you in a hurry, or when you don't label, you find things that are fading off bottles and whatnot? I mean, is it time-consuming just to grab a Sharpie and write acetone, or?
She doesn't understand.
I mean, the time spent. The point I'm making is that the time spent to bring the salon to minimum sanitation is so small.
Yes,
and
I agree.
There's been major. What I see here. This is a lot of issues here.
Did you have a question?
No question. No question. A question's been answered. I was just curious about the minimums. Thank you.
Ms. Bradley, did you have any questions of Mr. Holmes?
I did have a couple questions of Mr. Holmes. Mr. Holmes, do you recall meeting with Ms. Marsh at the board office?
Yes.
And her perception, I think, was that you weren't maybe as willing to talk about sanitation violations on that day. Would you agree with that assessment?
No.
Okay, so how would you characterize that meeting?
I was out of my league. I am from a different profession, and she's very busy. I'm very busy, and I felt there was some more appropriate time that could be handled.
Okay, so are you aware that as the owner of the salon, it's your responsibility to make sure all the Nevada law is followed regarding the establishment?
Yes, I do.
And so are you taking steps to become more familiar with the Nevada law so that you aren't feeling out of your realm when it comes time to talk about these sanitation violations?
Yes.
Can you tell us what you've done to become more familiar with the Nevada law?
I read through the ones that I felt were appropriate to this, and I really don't disagree with what the board here is striving to achieve, and I would support that. If I'm unable to do that, I'll close the shop.
Are you aware that infections can be transmitted through salons if improper procedures are followed?
Yes, I am.
Was it the first time that you read the statutes after you met with Ms. Marsh?
Yes.
So you hadn't read them prior?
No, I just applied for a license and was granted, and from that point on, the person in supervisory charge was running the place, which was Truk Holmes here.
Okay, and do you recall when you filled out your application for licensure that you agreed to follow all Nevada law?
Yes.
So you read that and signed it, but you just didn't do it until now?
Yes, that's true.
Okay, I have no further questions for Mr. Holmes.
Mr. Holmes, is there anything else you'd like to add for your side of the case?
No, sir.
Okay. Does any board member have any questions of either Mr. Holmes or Ms. Bradley?
Mr. President, I'd like to make a motion that the factual allegations
No, not yet.
Really?
No.
I get
Not
to
yet.
make a closing
There's
statement.
closing statements, and if
Thank
they
you.
have any other witnesses.
Thank you, Mr. Leader. Okay, Ms. Bradley?
I don't know if Mr. Holmes has any more witnesses to present, so.
No, I believe he indicated that he was finished. Mr. Holmes, you're done with your case?
Yes, I am.
Okay.
Thank you very much.
Sure. Ms. Bradley?
I would like to make a brief closing. If I could, on page 1, and I apologize for this, it says MRO Nails right above jurisdiction. If that could be corrected for the record to read pro, clearly it's a typo, and I apologize for that. So I just wanted to make sure that was clear. I believe that the testimony today and the exhibits prove that the allegations in this case have occurred, and that factual allegations 1 through 18 should be upheld by the board. It's concerning to me the list of violations that we're seeing both in September, January 23rd and January 28th, and I believe it was concerning to board staff as well. So I would ask that you find that the factual allegations 1 through 18 have been proven, as well as the violations of law, first, second, and third claims for relief. I would ask that you find that those have been proven. I think the testimony has supported that these all have occurred. It sounds like perhaps the salon is making some efforts at this point to comply with the law going forward, but it's concerning they've been open for a while and perhaps not complying, and so that's a concern for the state. And so again, I would just ask that you find that these allegations have been proven, and we would have a recommendation for discipline should that be appropriate. Thank you.
Mr. Holmes, do you have a closing statement for the board as well?
I'm at your mercy. Thank you.
Okay, thank you. Mr. Leader?
Mr. President, I'd like to make a motion that the factual allegations 1 through 18 be upheld.
Is there a second?
I'll second that.
Having a motion and a second before the board, is there any further discussion to this? Okay, I'll ask for that vote then. All those in favor say aye.
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 Those opposed? That motion carries. So I think in regards to the claims of relief, we need a motion for each claim, whether we're going to take them or not take them, or as a group collectively. Yes? Okay. Anybody?
I'd like to make a motion that we take them collectively as a group.
Is there a second to that?
I'll second.
I'm sorry, could you clarify what you mean by that? Are you saying that they've been proven or not proven?
They've been proven already, but
No, we're on the claims for relief. You have to.
I'm trying to lump them all together. How would you like me to say that?
How would you like? Are you saying that he has violated the law?
Yes.
Okay.
That the violation's been found, and we're lumping them all together. Is that what you'd like me to say?
So you should make, if you believe that the violations have been proven, you can all violations.
Okay.
1 through 3 claims for relief 1 through 3 have been proven.
One
then
through
that would be
three?
the motion.
Okay. I believe the violations have been founded, and that I'd like to lump them together 1 through 3.
And I will second that.
Any further discussion to the motion before the board?
Mr. President, just as a clarification for the violation of the law, NAC 644.4301, is that the correct
That's
violation?
correct, yes.
I apologize. I think that's a typo. I think it should be 340. I think it's 340 in the NAC and 430 in the NRS. 340, I believe, is the sanitation, and I apologize. I think Ms. Platt is looking that up for you right now.
And
That's
that,
correct. So
thank you. And so that also then corresponds with the
So we are dealing with NRS 644.
340 subsection 1.
Okay. And then NAC 430?
No, so it's NAC 340 subsection, and then it's 1. And then that is grounds for disciplinary action pursuant to NRS 644.4301A. So the NRS section is cited correctly under the first claim for relief. It is the NAC section that is, the numbers are transposed. So it should be NAC 644.340.
And NRS 644.3?
Nope.
Or
Nope.
43?
NRS is correct.
Oh, okay.
And I apologize, but if you do look at the factual allegations, the NAC cited in the factual allegations is correct. It appears there was just a typo in the claim for relief. So just so the record shows that it was properly cited multiple times on page 2.
So under the first claim for relief, you have that the respondent has violated NAC 644.340 subsection 1. And then that is grounds for relief for disciplinary action pursuant to 644.4301A. And then under the second claim for relief, you have grounds for disciplinary action pursuant to 644.4301K. And then the third claim for relief, we have 644.4301C of the NRS.
Does that clarify as you would like, Mr. Leader?
Thank you.
Koki, if it's okay with you, can I make a motion? Can I restate? Or
Well, we have a motion and a second before the board.
do we have?
I'll accept a friendly amendment. How's that?
I would just like to clarify it. So, I don't know. It's okay.
You don't want to do a friendly amendment?
No, could you just restate your motion for me so I'm clear on it? How's that?
So I think it's probably easier instead of saying that you're grouping. I think if you'd like, your motion should be that you move that the first, second, and third claims for relief have been proven.
The first, second, and third claims for relief have been proven.
With the noted change to first claim for relief to state NAC 644.340.
Thank you. Are you going to second?
And are you going to amend your second to reflect that?
Yes, I will amend my second, what she said.
Any further discussion? Okay, I'll ask for that vote. All those in favor say aye.
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 Aye. Those opposed? That motion carries. Would any board member like to propose the next motion?
Ask staff if they have any recommendation for discipline.
Oh, yes. Is there a staff recommendation for discipline?
Yeah, I believe and we can double check with Mr. Landry to make sure my memory is correct, but I believe in a previous case, the board issued a fine of $750 per violation last meeting that was very similar. Well, at least the allegations were similar as far as the violations go. So we would request that there be a $750 fine assessed for each of the violations, as well as the board costs in pursuing this matter pursuant to NRS 622-400. And also, I believe it would be appropriate for a reinspection within 30 days. And if there's a problem noted on that inspection, that I think the matter needs to be brought before the board. And I think staff at that time would want a revocation. And I believe there was another, I believe that's what we did last time.
Miss Bradley, was there a not to exceed value placed on the costs associated to today's hearing?
Yeah, normally we would do that. And so I would ask that the cost be not to exceed, I'm going to say $750. That's going to approximate, I think, more than what I've expended already, but that way the board can recover all of its costs in pursuing this matter. And again, the reason we just want to make sure that they're aware how serious this is, and that if there's problems noted, next time I think we'll be asking for more than just a fine. So I just want them to be aware of that.
Mr. President, there was a staff recommendation made for the discipline to be incurred. It encompassed 4 areas. The first is a fine of $750 for each claim of relief. There was also the issue of attorney's fees and costs associated to today's hearing not to exceed $750. There was also a suspension of 30 days. If the
I don't believe that was staff's recommendation.
that was
What I wanted was a reinspection within 30 days, and if there's problems noted, the matter would then come back to the board because it would be again a subsequent violation of the same provision. And I think that the respondent should be aware that the penalties are likely to be a lot more severe and potentially include revocation at that time.
Mr. President, I used the word suspension and it meant reinspection after 30 days and the potential for revocation. Those were the staff recommendations. My motion is to approve that.
Do I have a second?
I'll second.
Having a motion and a second before the board, is there any further discussion?
I just want to make sure. I think Mr. Leader said an inspection after 30 days, and we said within 30 days. So I just want to make sure what you meant so that it's clear for the order and for the respondent as well.
I'll clarify my motion to include the word within 30 days.
I'll change mine and clarify. Thank you.
So I have a motion and a second. Any further discussion?
I have one question.
Absolutely.
Penalty-wise, what boundaries do we have?
So NRS 644.430 subsection 2 authorizes the board, if it determines that a violation has occurred, to refuse to issue a renewal license, revoke or suspend a license, place a licensee on probation for a specified period, impose a fine not to exceed $2,000, or take any combination of the actions.
Thank you.
Just for the board's information, that's on page 4 under discipline authorized, and that would be in every complaint, so you can always find it there.
Okay, so having a motion and a second before the board, and seem to be no further discussion, I'll take that vote now. All those in favor say aye.
Aye.
Aye. Those opposed? That motion carries. Mr. Holmes, you'll be notified by the State Board and contacted with regards to the, how you proceed from this point forward. Thank you so much for your time. We appreciate it.
Mr. President, just as a clarification of Ms. Bradley, when do we expect Mr. Holmes to receive the order and the date with which payment would be then made? Approximately.
The orders usually take me it's usually about 30 days to get the orders out. It depends on what else is happening for me. And then I send them to the board office where they're sent out. But that does remind me that we should include in the order a date that fine amount is due. So that way the respondent knows, as well as if it's not paid, we know when it's actually late.
And Mr. President, I would suggest then 30 days from the date of the receipt of the order. Is that then correct?
Yeah, that's normal. I mean, we normally say the order is effective upon receipt or within 15 days of mailing. So 30 days from then would be.
So we're looking at roughly July 15th?
On or about. Yeah, that sounds correct.
Even say July 15th is the due date if you'd like. We can put that in the order. The fine amount is due on July 15th, on or before July 15th, as well as the cost amount.
And then to clarify, the reinspection would occur between June 15th and July 15th?
Yes.
Yes.
Then I would like to then suggest that the order reflect July 15th, 2014. Make that in a motion form. So I would like to make a motion that the order reflect the July 15th, 2014 deadline date.
I'll second that.
For the payment of the fine.
Right. So a motion and a second. Any discussion?
I think that will make it quite easy for accounting and to account for staff as well.
Okay. All those in favor?
Aye.
Aye.
Aye. Those opposed? That motion carries. Thank you, Mr. Holmes. So no 10, so agenda item 11, Rachel Gilmore. Ms. Gilmore, if you'd stay standing, please, we'll have you sworn in before we get started. Thank you.
I would like the record to reflect that I am showing Ms. Gilmore what's been pre-marked as State's Exhibit 1 for the record.
Miss Bradley, what's going on?
She's just showing her. She's just showing her.
Oh, okay. Oh, before we enter it into the record. Okay.
I've shown Ms. Gilmore what has been pre-marked as State's Exhibit 1, and so I would now ask Ms. Gilmore if she has any objection to this being admitted as State's Exhibit 1.
No.
So admitted.
Oh, and you just need to turn that on. I did.
Hopefully everyone has a copy of Exhibit 1 now.
Yes, we do. Thank you.
I would now call Ms. Charlene Marsh. Ms. Marsh, would you please state your name and spell your last name for the record?
Charlene Marsh, M-A-R-S-H.
And would you again state your employer and job title?
Nevada State Board of Cosmetology, Field and Office Assistant 1.
And as part of your duties as Field and Office Assistant 1, did you issue the citation in this case CM-243?
Yes, I did.
And can you tell us about that?
That was a routine inspection on January 16, and when I walked into the Master Touch Beauty Salon, Rachel was working on a client on a perm, and her license was not posted.
And was her license current on that day?
Yes.
And did you talk to Ms. Gilmore that day?
Yes, briefly, because she was busy with her client.
Okay, and what did she tell you?
She just said she didn't have her license with her.
Okay. And then you issued the citation?
I did.
And that's a first offense?
It is.
And was the establishment also cited for this?
No.
No. Okay.
Just not posted. The license wasn't posted for Rachel, so that's not a citation for the salon because she's current on her license.
Okay. Is there anything else you'd like to tell the board regarding this citation?
She had just moved into that salon and had closed another one, and she stated that she didn't have her license. That's all.
Okay. And I should note that for the record, Ms. Marsh was previously sworn, but I don't know that we said that before she started testifying. Thank you. I have no further questions for Ms. Marsh.
Ms. Moore, do you have any questions for Ms. Marsh?
No.
Okay. Ms. Bradley?
Do any board members have questions for Ms. Marsh?
Do any board members have any questions for Ms. Marsh? Okay.
I would have no further questions and no further witnesses, so I would rest at this time. Thank you.
Okay, Ms. Moore, it's your opportunity to present your case, if you would, please.
Okay. I have been a salon owner since 2004 to 2013, December of 2013. I have had no problems with any support of putting it up, like putting up my licensing or anything. I have never been cited for this before, and I do not deny that it was not posted at the time. I had it on the premises, and when she came up to talk to me, I had mentioned that I don't know where my license is at the moment. I know it's on the premises, and it was on the premises. I just didn't have time at that moment to go and look for it. I had just moved in. That was actually my first day in the new salon. I have closed my salon due to financial hardships, and so I just wanted to apologize to the board. I have had no run-ins with the board at all over any little tiny things, such as putting paint on something or not emptying a garbage can or something like that. But I uphold my salon up to standards and above, and I just am looking for leniency right now. I'm not denying that it wasn't posted, but it was on the premises the entire time. And as soon as she left and I had a moment to get it, I put it up.
Able to find it.
So I had no way to prove it. And when I talked to her in the back room, she said, "You can contest this." And so I am here to try to get at least leniency on the matter.
Any board members?
Does Ms. Bradley have any questions before we ask? Or
No, I have no questions for Ms. Gilmore. Thank you.
Ms. Gilmore, you indicated that you did not have time to look for your license. What is it that you were doing while the
I
inspector
was
was
in the
there?
middle of a permit section, so I was rolling it and getting it prepared to go. And so I was
So was there a chemical on your client's hair at that time?
I was getting ready to start all that process. It was in the middle of that process.
There was a chemical on your client's hair at that time? Thank you.
Ms. Long.
Where was your license? I mean, where did you find it?
It was in a box in the back room.
And you had
'Cause
just
I
moved?
still had more boxes in the front, and I thought, oh, I better move this out of here because I need to put it back there. And so I took it in the back room, and it was in a top box.
So you were just
But-
moving into a new salon, still in packing stages?
Yes.
Okay. And your license was valid at the time?
Yes. And then there's a photo in this packet of that where it is. And
Thank you.
Can I ask you the question about the perm, because I wasn't clear on that? You were applying product to the hair, or you just had rolled it? You made two statements there that you were in the process of rolling.
I'm not sure at the time where I am, like where I was at the time she came in, honestly. I am not positive where I was in the stage of the perm. I'm thinking over and over. I don't remember the exact moment what I was doing at that time. So she may know I'm not sure what I was doing at that exact moment.
Thank you.
Ms. Marsh, do you happen to recall?
I apologize. I don't. I do know she was working on a perm, and I know there were clients waiting.
Thank you.
Is there anything else that you'd like to add, please?
Thank you.
Okay. Ms. Bradley, would you like to make a closing statement?
I would just submit that based on the testimony of both witnesses, it does seem that the license was not posted at the time Ms. Marsh entered the salon, and I would ask the board to uphold the citation. Thank you.
And would you like to make a closing statement as well?
I'm just here looking for some leniency on this matter. Thank you.
Okay. I'll entertain a motion.
Mr. President, I'll make a motion that regarding citation CM 243, the alleged violation of NRS 644.290 is in fact true and correct.
And I'll second that motion.
Any discussion? I'll entertain a vote then. All those in favor say aye.
Aye.
Aye. All those opposed? That motion carries.
Mr. President, I'd like to at this time make a motion to waive the fine associated with this violation.
Is there a second?
I'll second.
Any further discussion? I'll have that vote, please. All those in favor say aye.
Aye.
Aye. Those opposed?
Nay.
That motion carries. That was 2 nays. Mr. Nixdorf and Ms. Benaldi, yes? Yeah.
So just for the record, Ms. Gilmore, the board has upheld the citation. You will get an order in the mail that tells you that. They have voted to waive the fine, so you won't have to pay a fine. But just so you know, this does count as a first violation, so if it happens again, it would be a second, and the fine is more, just so you're aware of that.
Thank you.
Okay. Thank you.
Thanks for your honesty.
Okay, Ms. Bradley, do you want to do number 12 and then jump back to 7 and 8?
That would be great, and I do
Okay.
believe they have the exhibits in Las Vegas. Maybe they can verify that for us.
Yes, I do, Sarah.
Thank you very much.
Thank you, Monica. Okay. Adriana Mahara.
I believe she's at a salon in Reno, so.
So for the record, was she duly... Okay. Go ahead, Sarah.
So Ms. Mahara is not here? Not as far as I can. Thank you. Well, I guess it would be up to the board if you want to give her a little bit of time to appear. I don't know if she's contacted the board office, if we have any information.
It's not come to my attention that she's had any contact. I'll ask staff if they've received any contact in the Las Vegas office.
I've received no contact from her.
Mr. President, I did want to just ask a quick question on the answer in the consent decree. I was trying to figure out, the signature of the respondent indicated that she did not receive a renewal letter and therefore didn't realize that her license had expired. Is that renewal letter a courtesy that's sent?
It's absolutely a courtesy.
And is there any other indicator on her license that would have shown that her license expired?
I believe there's an expiration date, as there is on all licenses, as far as I know.
Before we get into the merits of this case.
Well, I'm not asking the merits. I'm just asking.
Oh, you're asking about exhibits regarding the case.
This was the document that we received. I just wanted to clarify if there was an indicator by her own. She's written it.
I understand.
And I just didn't understand it, and so I was just asking.
So at this time, this would be considered part of the case, and so she would have had an opportunity to discuss that here. So since she's not here, we have to go through some steps to make sure that that notice was in fact proper in this case, and that she's had, whether or not she's had an opportunity to contact the board. So hold your questions.
So this
for a
wasn't
moment.
the notice?
Hold your question.
The notice of today's citation appeal is what we're talking about. So what I was just debating, and I was going to ask Mr. Hoffman what he preferred, we can go ahead and go forward on this case, and I can prove service, and we can go ahead and do it in her absence, or we can move to the 2 Las Vegas cases to give her a few more minutes to arrive if perhaps she's been delayed. I don't know what you would prefer.
I'd rather prefer to proceed. We've all managed to make ourselves present and available here. So,
Okay.
and as long as she was duly,
Yes.
the certified mail and all the proper contact procedures were followed, I see no reason why we can't continue forward.
Okay, then if I may, and I'm not sure she's prepared exactly for this, but could I call Ms. Bradford? I believe she's the one that sends the notice letter out.
Yes, Ms. Bradley.
And I believe she would need
I
to be...
have the notice, and I also have the confirmation from USPS.com that the letter was delivered.
Thank you. Let's have you be sworn in first, and then I'll just ask you a couple quick questions about that for the record. Thank you so much. And I believe we may need Ms. Chandler also sworn.
Okay.
Ms. Bradford, if you would stand and raise your right hand to...
You'd stand, Ms. Bradford, and raise your right hand. Do you and each of you solemnly swear or affirm the testimony you're about to give before this board to be the truth, the whole truth, and nothing but the truth?
I do.
Right. And so I will, for the record, note that, or disclose that Ms. Chandler and I have a personal relationship, so I will be recusing myself from this case.
Is there a vice chair?
That'd be me. All right. So,
I would first call Ms. Bradford if I could.
okay.
Thank you,
Would
Mr.
please do that?
Nixdorf. Thank you. Ms. Bradford, would you please state your name and spell your last name for the record?
Monica Bradford, Bradford.
And Ms. Bradford, who is your employer?
The Nevada State Board of Cosmetology.
And what is your job title?
Administrative Assistant.
And as part of your duties as administrative assistant, did you send the notice regarding the citation appeal to Ms. Mehara in this case?
I did.
And can you tell us what address that was sent to for the record?
The address that I had on record was 3835 Wixom Drive, number B, in Reno, Nevada, 89503.
And is that the address that is shown in the board's records for Ms. Mehara?
Yes.
And you sent the notice out, and do you know if that notice was received or what the status of that mailing is?
I sent it both certified and regular mail, and with the certification, I asked for a verification, which I went to the Postal Service's website, USPS.com, and I placed the article number in the search box and received a verification that the letter was delivered.
Okay, so the letter has been delivered then?
According to their site.
And can you tell us what date it was delivered? Just because what I've got here shows that on March 8th, it was still notice left. It didn't show that it had been delivered yet.
Show delivered March 21st, 2014 at 2:43 p.m.
Thank you very much, Ms. Bradford. Based on Ms. Bradford's testimony, I would ask that the board find that Ms. Mehara has been given proper legal notice of the citation appeal pending, and I would ask that we proceed in her absence.
Can I get a motion for that?
I'll motion to proceed in her absence.
That notice has been given.
That notice has properly been given, and to proceed in her absence.
I'll second that.
Okay. Can I get a vote? Any discussion?
Mr. Vice Chair, I had a question that, Ms. Bradley, just because there's notice that it was delivered, is that notice of Ms. Mehara's receipt? Is that the same? Is that the mutually inclusive of one?
Well, I think Ms. Platt is prepared to answer that for you, but I would remind you that Ms. Bradford's testimony was she sent it regular mail and certified mail, and that the certified mail was delivered, and we could double check with her, but I don't believe from her testimony that the regular mail has been returned. And I think Ms. Platt has an answer to your question.
Yeah, so notice would have been proper. It's the fact that it was mailed and delivered to the last known address. You'd presume that she's received it.
And will there be an issue if she's not at that address?
Well, The duty of the board and staff is to mail it to the last known address on file with the board. So she's under a duty pursuant to, I believe, your statutes to notify the board when she does have a change of address. So it's on her to update you when she does move, if she does move. So we've heard testimony that that Ms. Bradford mailed it to the last known address that you have on file, which
Thank
is
you.
proper.
Any other discussion? Okay, then I'll call for a vote. All those in favor, say aye.
Aye.
Aye. All those, that was unanimous. Any nays? And one recusal. Okay, motion carries.
Thank you, Mr. Nixdorf. Because this is a citation appeal and it's Ms. Mehara who is actually asked to be here today to appeal this citation, unless the board would like me to provide testimony by Ms. Chandler, I would ask that the board find that the citation has been upheld by Ms. Mehara's failure to appear today. We've shown that she has been given legal notice of today's hearing. She's the one that requested it. It is now 10:20, excuse me. 10:20 in the morning, and she's not present. So I would ask that you uphold the citation due to her failure to appear. And there is an NAC provision that allows you to continue in a person's absence and find everything true if they're not here. But I think particularly when it's a citation appeal and they've actually requested it, it's not that we've requested them to come. They've requested to appeal the citation, and they're not here.
So I'll entertain a motion to uphold this citation in her absence.
I will make a motion that that service has been upheld. We find that she was served properly according to. Okay, so it wouldn't be held per her request, and that.
Right now, you're just
and
trying
we're
to
just upholding the citation.
Yeah, so we've already had a motion for notice that it's proper. So right now we're just on whether or not you'd like to proceed to uphold the citation.
Yes, let's proceed to uphold the citation.
For the record, I think you can also uphold the fine amount that's assessed. And also, just for the record, NAC 644.495 is the NAC that deals with a person's failure to appear. So it says that if a party fails to appear at a hearing scheduled by the board and no continuance has been requested or granted, the board may hear testimony on witnesses who have appeared and proceed to consider it on the basis of the evidence before it. And then NRS 622A, I think it's 290, has a provision that talks about if a person does not contest the allegations, the board can consider it true in the person's absence to appear. So we don't actually have to call witnesses. But I do have an exhibit I could admit if you'd like.
Would you like to ask staff if a request has been granted, if a continuance has been requested?
That I think we had them all say that they hadn't heard anything, but just for the record, has there been a continuance requested or granted by Ms. Mehara?
This is Monica Bradford. I have not received any notification or communication from Ms. Mehara.
Okay, so we have a motion from April to uphold the citation. Can we get a second?
Second.
Any discussion?
Mr. Vice Chair, I have a question of the inspector. This was an individual citation, even though the box for establishment was checked.
So,
Yeah. And so I just had a quick question. Was the establishment cited for this?
So if you'd like to go into that, we need to have the motion withdrawn because that's going towards the substance of the citation.
Okay. I thought that's what we were.
What we were doing is right now the motion is to uphold the citation because she's not here. She asked to be here. She's not here. We don't need to hear evidence. You can if you like, and then we wouldn't proceed in that motion.
But I thought if the motion was on the table and I just had a quick question about it, then can't.
If you have questions on the citation, then it's probably better to put on the evidence so that the record is clear.
I would have a problem voting on upholding the citation without having the question answered.
Then the proper course would be to actually hear the evidence about the citation. Because right now you're just, the motion is to accept everything in the citation as true and correct.
And I'm accepting that. I just am asking if the establishment was also cited.
And I believe you heard that case at the last meeting. Yeah.
And that's where I was going. Thank you.
Just so the record's clear, the NRS provision that allows us to decide in the person's absence without providing testimony and evidence is NRS 622A.350, which says that if a party fails to appear, I get to make an offer of proof that the absent party was given sufficient notice, and then you can accept everything that's been presented as true. And so the citation currently has been issued by staff, and so you're free to accept that as true pursuant to 622A.350, given that Ms. Mehar is not here.
I just want to say, she admits that she did it and that she didn't contest it. So I don't know, and she didn't show up. So
can I know what the board has? Because I was under the impression that you did not have any exhibits. You just had the letter noticing her for the.
We have the citation.
Okay, I didn't think that you were going to have that going forward. So I have exhibits here, and maybe we should just admit the exhibit just so the record's clear.
Can I withdraw my motion because we've got a motion stand a second on the table?
Don't worry about that, but just so that we have it in the record, just in case, I would like to admit Exhibit 1, and it's proof of mailing from the USPS regarding this citation letter that was sent by Ms. Bradford. It's the letter signed by Ms. Bradford, the answer and consent decree, the citation, again, the answer and consent decree that's not been filled out yet, a copy of a printout from the Versa system, the report of establishment, and I would ask that all be admitted as State's Exhibit 1, given that we've had some references to it and it hasn't been admitted yet.
So admitted.
And if anyone needs a copy of it, please let me know. I do have extras.
Okay, so everybody had enough time to look over what they need to see? All right, let's call for a vote. All those in favor, say aye.
Aye.
Aye. All those opposed, say nay. Motion carries.
With one recusal.
With one recusal. Okay, now,
Ms. Bradley, did you need them to uphold the fine amount as well?
I think that was part of the motion.
Well, I thought the motion was to uphold the citation. I'm not sure if you specified the fine amount. So to be clear, perhaps we should have a motion to also uphold the fine amount. And then that way the order will be very clear. Thank you.
I will make a motion to uphold the fine in the amount of, I believe it's $200 for Ms. Mehar's citation.
Is that an amendment to the previous motion?
No, this is an additional motion.
so we have a motion to uphold the fine of $200.
I'll
Can I get a second? Koki seconds. Any discussion? Call for a vote. All those in favor, say aye.
Aye.
Aye. All those opposed, say nay. Motion carries.
With one recusal. Thank you.
With one recusal.
Restroom break, please.
So let's go ahead and have a 10-minute recess. My gavel's over there, otherwise I'd smack it. Okay, let's call the meeting back to order at 10:44 a.m. Didn't have the authoritative. Okay, so back up to item number 7, formal complaint and hearing. Derek Liu, Famous Nails. Mr. Liu? Is Mr. Liu present in Vegas? Should be able to.
Can they hear us in Vegas?
Mr. Hoffman, this is Monica. He is here. He's just not in the room.
Okay, so let's move to item number 8 then. Is Connie Pena available? Miss Pena, are you there in Vegas? Annie waved.
Mr. Liu is present if you'd like to proceed.
Okay, so back to item number 7 then. Mr. Liu, if you could step forward, please. Let's get ourselves moving, shall we? So before we get started, if you gentlemen would remain standing so Mr. Nelson could swear you in.
If you'd each raise your right hands. Do you and each of you solemnly swear or affirm the testimony you're about to give before this board to be the truth, the whole truth, and nothing but the truth?
I do.
I do. I do.
Thank you. Mr. Liu, I believe there's been some exhibits walked over there, and if we could, Exhibit 1 is the complaint and notice of hearing. Do you have that before you?
Yes, I'm presenting it to him right now.
Thank you. I just wanted to know if you had any objection to that being admitted so that the board could look at it, and also that way it's in our record.
Yes.
You've seen that, Mr. Liu?
Yes.
And do you have an objection to that being admitted so the board can look at it?
Yes.
Is it okay for them to see it, or are you objecting to them seeing it?
My employees say they left the use buffer on the nail table and they give the fine. And I wasn't there at the time.
Mr. Liu, right now we just want to know if you are okay with the document that you have before you titled Complaint Notice of Hearing is okay to give to the board members right now.
Yes.
Thank you. Also, you should have...
So admitted.
Thank you. Also, you should have something that's labeled Exhibit 2, and it's a copy of a letter that was sent to you on November 21st, 2013. Also in Exhibit 2 is a citation, answer and consent decree, report of establishment, and a printout from the board computer system, as well as some photos taken on the day of that inspection. Do you have an exhibit to the board, an objection to the board looking at what's labeled Exhibit 2?
I was not there at the time. I don't know what going on there.
Mr. Liu, right now we're doing some preliminary matters regarding some of the documents that you have before you. And right now all we want to know is whether or not the documents labeled Exhibit 2. Do you have a copy of that before you?
I have on front of me right here.
Okay. Is it okay if the board admits Exhibit 2 and looks at those documents? Or do you have do you prefer them not to see those?
Should our inspector really be counseling him?
No.
That's Mr.
Jeff
Green.
Okay, Mr. Green,
Yes.
it's okay?
Yes.
Okay.
Okay, so
So admitted.
thank you.
Mr. Liu, do you understand what we're asking?
Yes.
Mr. Liu, if you had an interpreter, would this whole proceeding be easier for you?
Yes, please. With interpreter is better for me.
Did he ask for one?
Well, I don't.
Any interpreter. Need interpreter.
Do you have someone there that could help you interpret?
I need interpreter.
No, it's your duty to bring one. I'm asking if you have someone there that could help you with this.
I don't have anyone help me.
Okay, so if he hasn't brought somebody and he's having a hard time understanding, should we just continue this?
Miss Bradley?
Yeah.
I guess that would be a decision for the board to make.
I believe that we should. If he can't understand what's going on, we can't really,
So, Mr. Liu, it sounds like the board, they're going to maybe make a motion to move this hearing to another date, but you'll need to bring someone to help you interpret if that's what you need.
Do you understand, Mr. Liu?
So I'll entertain a motion.
I make a motion that we postpone this hearing until Mr. Liu can bring an interpreter with him.
Is there a second?
I'll second.
Motion and a second before the board. Is there any further discussion? I'll take that vote. All those in favor, say aye.
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 Those opposed?
Nay.
So that was Mr. Leader and Ms. Benaldi with the nays.
And board members, if I could ask for the exhibits back, that will save me from copying them again next time. So I believe I've only given you 1 and 2.
Well, they didn't make it all the way down. They're actually going back now. That motion carries, by the way.
That's my bad. I'm sorry.
So, Mr. Liu, we'll see you next time. Thank you. And please remember to bring an interpreter with you. Thank you.
Mr. President, maybe they could just leave their mic light on if they're sitting there.
Yeah, but the problem with the mic on is that the video camera is switching back and forth constantly. So, okay. Item number 8, Miss Connie Pena, are you there? This is the United States calling. Are we reaching you? Okay. It would have taken 45 minutes or longer. Yeah. So.
I look like they're ready to be sworn.
Okay.
If do you and each of you solemnly swear or affirm the testimony you're about to give before this board to be the truth, the whole truth, and nothing but the truth?
Microphone's on, please.
I do. I do.
Excellent. Thank you. So, Ms. Pena, what we'll do is we'll have Ms. Bradley present her side of the case first, and after that time, you'll be able to present your side of the case as well, and we'll go from there, okay? Thank you.
Ms. Pena, I believe that you should have in front of you an exhibit marked Exhibit 1 for Mia Bella, and it's the complaint and notice of hearing. Do you have that there?
Yes, I do.
Do you have any objection to that being admitted into the record so that the board can see it?
No, I do not.
Thank you.
So admitted.
Okay. And Ms. Pena, there's also an Exhibit 2 that should be, it starts off with the mail receipt printout from the post office, and then there's a letter to you regarding this case, and then a printout from the board's computer system. And then about halfway through, there's a report of establishment that's dated January 10, 2014. The citation C14-800, that's the case number, and the citation number is PF-223, and that's dated January 8, 2014. And then there's the answer and consent decree following that. So do you have those documents there in Las Vegas?
Oops, I currently have them in my possession now. The documents that I received weren't complete the way they are now. I was explaining to Ms. Hayes that just a little while ago. I just received last week in the mail, certified, which I signed for, the complete documents. But she did drop them off personally. I think it was 2.5 weeks ago.
Okay.
But I have them in my possession now, and I have had the time to review them.
Thank you. Yeah, because you should have received the complaint and notice of hearing maybe more than a week ago, and then if you want any other documents, you can request those. Normally those aren't sent to you unless you ask, but you do have them all now.
Yeah, she did let me know that when she dropped by and visited 2 weeks ago. I told her I haven't received anything in the mail, so she did make it. She dropped it off personally, actually, and we also received it last week in the mail.
Thank you. So do you have an objection to the board looking at Exhibit 2?
Not at all.
Thank you.
So admitted.
Ms. Bradley, on your Exhibit 1 in the page 3, the violation of the law, is that also going to be corrected to NAC 644.340, subsection 1I?
Yes, please. We should change number 3 to read, so on page 3, the first claim for relief, it's on line 18. It should really be 340 instead of 430. And then also, there was an amended complaint and notice of hearing sent to Ms. Pena because there's an error on page 2 where it says Famous Nails, and it should say Mia Bella Salon and Day Spa. So I believe the one that she received, because it was sent to her again with the correction, I think I just have a copy here today of the old. That was the only change made. So on page 2 on your copy, line 24 should read Mia Bella Salon and Day Spa instead of Famous Nails. Ms. Pena, do you have any objection to those changes being made to the complaint?
No, I do not.
Thank you. So I would ask that the record be reflected and the board members make those changes where appropriate.
So reflected. Thank you.
I would now call Ms. Hayes Fitzgerald. Ms. Fitzgerald, would you please state your name and spell your last name for the record?
Pamela Hayes Fitzgerald. My whole name or just the last name?
Last name, please.
Fitzgerald. Fitzgerald.
Thank you. And who is your employer?
Nevada State Board of Cosmetology.
And what is your job title?
I'm a field inspector 2.
And as part of your duties as a field inspector too, did you do the inspection of Mia Bella Salon and Day Spa that's brought us here today?
Yes, ma'am.
And can you tell us what date that inspection was?
It was January the 10th, 2014.
Thank you. And why did you go there on the 10th to do an inspection?
On January the 8th, 2014, we received an anonymous complaint alleging the unsanitary conditions in the salon, alleging unsanitary instruments, implements in the waxing room. As I approached the waxing room, I found stained and used cotton balls, waxing strips, and what appeared to be blood on a piece of cotton inside of a closed container with tweezers, which contaminated the tweezers because there was blood on the cotton. I also found the waxing pots in unsanitary condition for public use. The waxing pots had a heavy buildup present. I have photographs, actually. And so at that time, the complaint was valid, so I issued citation PF 223 was issued to the owner for violating the above NRS 644-340.
And was this a second citation for sanitation violations for this salon?
Yes, ma'am.
And so that's why we're here today?
Yes, ma'am.
And what else can you tell us about this inspection? Is there anything else that you noted? I just didn't know if you told us all the things you observed already. I think you did, but I wasn't sure if there was anything else you wanted to add.
I also issued citations for 2 unlicensed people working in the salon.
Okay. And so you said there were used waxing strips, used cotton balls, and those are both single-use items. Is that true?
Yes, ma'am.
And when you say the waxing pots were in unsanitary condition, I think you said you have photos. I don't believe the board has seen those. Can you describe what you saw to us? What do you mean by that, the buildup?
Well, the wax pots were, first of all, they didn't have lids on them. So when I walked in the room, around the actual pots was a lot of brown, pink, I'm assuming it's old wax that had not been removed. And on one of the waxing pots was a piece of wax strip that was stuck on the pot, and the lid was wax buildup, yellow, brown. It just doesn't look very nice.
And when you say there were no lids on the wax pots, should there always be lids on them, or what's appropriate?
Well, if they're not in use, they should be covered if they're not in use. Yes, ma'am.
So that way things don't go into them?
So, right.
Okay.
Like hair and cotton balls and waxing strips.
Okay. And then the different colors you saw, were there different kinds of wax in the one pot, or that's maybe just remnants of the old kind?
Well, one looks kind of pinky orange and the other is like really dark brown. Okay. Like chocolate brown, molasses syrup brown.
And was that unusual when you've looked at other waxing pots?
Well, yeah. Because I've never seen it that dark. Okay. And I was told it was called chocolate wax.
Okay. So perhaps there's more than one kind mixing in the pot then?
Possibly.
Okay. Is there anything else you'd like to tell the board regarding this inspection?
The salon license had expired in August the 1st, 2013.
So when you went in there,
that was another citation.
It was when you did the inspection, the establishment had an expired license.
Yes, ma'am.
And it was still operating and open.
Yes, ma'am.
And you said that was another citation. So was that a different number then than the one that you issued for this?
Yes, ma'am. According to NRS 644-430.1, in reference to NAC 644-380, the citation I issued for the license being expired was PF 221.
Okay. Well,
for an expired salon license.
Okay. So that's helpful information, but let's try to stick to what we've alleged here, and I apologize for that, but the only allegations we have before the board in this case what citation numbers did you issue, just for the record?
Well, Well, this particular, you mean all of these citations or just the particular case we're talking about?
The particular case that we're talking about.
Is PF 223. So there's no citation because, there's no fining system when it's a second offense. So that's why we're here to do the complaint.
Okay. Yes, PF 223. And then I think in number 9, if you look at the complaint, those were the ones that you did for the unlicensed individuals. Is that true?
Yes, and the expired salon. Yes.
Okay,
Yes.
I see.
Okay.
I know.
As board members, we only have PF 223. That's the singular citation I have.
Well, and again, it's not a citation.
Well, that's the one we're going.
Under the law, a second violation of sanitation brings the person to a hearing. So what you have today are the repeated sanitation violations, which is violations of NAC 644340. So that's the hearing that we have. And so I would ask you to try to stick to the hearing that we have before you. Thank you, Ms. Fitzgerald. I have no further questions.
Ms. Pena, do you have any questions for Ms. Fitzgerald?
I don't have any questions, no. I'm just waiting to speak or to let you guys speak so I could have my moment as well.
Excellent, thank you. Ms. Bradley, do you have anything further for your case?
I have no further questions, and if the board has questions for Ms. Fitzgerald, I think now the time would be. Thank you.
Ms. Long.
Hi, Ms. Fitzgerald. What was the first?
Hi, Ms. April.
How are you? When was the first citation?
For sanitation.
For
We're talking about sanitation.
For sanitation?
Yes, for sanitation.
Sanitation was written on May the 23rd, 2013 by Diana Ball.
And what was that for?
Yes.
Do we know what that was for?
Sanitation.
For sanitation. Do we know specifically what it was for without going into too much chazarai?
It was for an exhaust vent that had not been in the restroom that was missing.
Okay.
At the time when Miss Ball had went on 5-1, they were given a compliance to repair, and they had not repaired. So that's how this citation DB 81 came about.
Okay. Thank you so much for that information. I appreciate it.
Okay.
Any other questions for Ms. Fitzgerald? Ms. Bradley.
We would rest at this time.
Okay, Ms. Pena, now it's your opportunity to call any witnesses, question anybody what you would like to, or present your case. Thank you.
Thank you. Good morning. I don't have any witnesses. This is the first time I'm even presented with the actual photographs. I was out of the country at that time. Unfortunately, I was in the middle of selling my salon. I mean, I have proof of that. It was all over Craigslist. I have quite a few people that came forward to buy. I entered a partnership verbal agreement / contract agreement where it was going to lead to sales of, and she was going to be the manager. She was in charge. She was there that day. I was out of the country, and she was supposed to be in charge of all managing, even when it came to paperwork. She was supposed to have everything in order. When I did get cited, as soon as I got back into the country, I resolved everything that was outstanding, fines that Ms. Fitzgerald let me know, Connie, your license was expired. I had no clue it was expired because she was supposed to be in charge of all management. So I paid for that immediately. The waxing room, I really can't say anything about that. She was in charge at the moment. I can't even pull forward at this point because that entire deal has been canceled because of what happened. I was actually to the point where I was just going to close my salon after this happened. I spoke to Ms. Fitzgerald. She helped me get everything back on track. There is one picture that I'm seeing here that is a personal box use. I don't know whose it is, but this isn't ours. It looks like there is one wax here that we use that is called chocolate wax. I think it's smooth and easy. I could see the green. I know I could pull it up because I bought it at the hair show. It's called chocolate wax. I'm sure a lot of you guys have heard of it.
Okay.
There's another one that's
sorry to interrupt you. We don't have those photos in front of us, and they haven't been admitted as evidence. So
Correct. I just saw him today too, so I'm barely providing my defense right now as we speak. I just got everything present. There's 5 photographs here. One, I know for a fact, does not get used in our salon. This is somebody's personal box use. I don't know what it was doing there. There's another, well, I guess I can't even keep talking about it because you don't have the pictures in hand. Like I said, I wasn't there. I wasn't managing my salon at that time. I was selling the salon, and I had an agreement to this young lady, Yahaira Crawford Maris Lopez, that was supposed to be in charge of taking over the salon and having everything to the T. I haven't had a problem. There was an exhaust fan problem. When I first moved into that salon, I took over it, and we had that issue fixed. So I don't know what else I could say at this point about that. I apologize. I didn't come very prepared today.
So what you were just previously stating is that so the exhaust fan, that was the citation that was issued on the 23rd of 2013 with Inspector Ball?
Correct. I haven't had a problem since, and since this issue, I've been personally managing the salon. Actually, it was closed for almost about a month and a half when we got cited. I've done a lot of remodeling. Ms. Fitzgerald has been in 2 times, and she has seen the salon. The wax room has completely been changed over to another room. Everything's different, completely different. This was a rude awakening for me. I wasn't there overseeing my location because I was going to sell, and I thought the lady was going to oversee all these details. And unfortunately, because it was in my name, I have to pay for this. So I do respectfully request that you please put that into consideration.
Thank you. Ms. Bradley.
Thank you.
Ms. Pena, have you had a chance to review the factual allegations in the complaint?
I have.
And do you
yes, I have.
Do you dispute any of the facts listed? There's facts 1 through 16.
What page?
It's page 2 of the complaint. The factual allegations start on, there's number 1, and then 16, it ends on page 3.
I actually do, where like I said, I didn't get a chance to.
Well, this was sent to you in the mail. Did you not receive this?
I just received it. Not even a week and a half ago, but I just had a chance to review it. She personally dropped it off, and then a week and a half ago, I got it certified where I personally signed for it, and I opened it, and I reviewed it, and I was actually mentioning to Ms. Hayes this morning, do I need my attorney present because I don't have enough time. I didn't have enough time to contract him within the past week and a half, so she made it a point to me that we were just going to review the wax allegations.
It's a complaint and notice of hearing, so the board can revoke the license if they want to today. So if you need to consult with your attorney, then you should do that, and perhaps you should request a continuance from the board. My records show that the complaint and notice of hearing was sent to you on the 4th day of April. So it seems surprising to me that it would have only been received a week and a half ago. But if you need to consult with your attorney, then you need to request that the board continue the case so that you can do that.
I'd like to request a continuance.
I'll entertain a motion.
I'd make a motion that we grant Ms. Pena a continuance so she can have her attorney present.
I'll second that.
Having a motion and a second before the board, is there any further discussion? I'll take that vote then. All those in favor say aye.
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 Those opposed? That motion carries. Okay, Ms. Pena, thank you for your time. We'll see you again.
Thank you. Okay, thank you.
Just so you know, Ms. Pena, you'll be receiving an updated notice of the next hearing, and so it's sent out 30 days prior, so you'll want to keep an eye on it. But I believe the next board meeting is in August, so you should be receiving that notification in July. But you can always show your attorney the complaint that you have right now.
Okay, I will. And then by that time, it gives me enough chance to get copies of all photographs that were taken.
Yeah, I mean, if you want discovery, you can request that, or your attorney can. That's something you should ask for prior to the hearing. We'll show you at the hearing all the exhibits we plan to admit, but normally if you want to see them ahead of time, you should ask for that, and your attorney should know that as well. Also, just so you know, my phone number and contact information is in the complaint, so if your attorney wants to call me, that would be fine. If you go to page 6, my direct phone number is there. And so your attorney can contact me at any time and we can talk about the case, okay?
Thank you, Ms. Bradley.
And also, do we have a correct mailing address for you? It sounds like you said, I have here 442.
I'm sorry. You do it just because I was closed for almost 2 months, a month and a half, month and 45 days, something like that. That's probably why I didn't get it. There was still a renter that would come in and out. I'm going to find out what happened to all the mail, but yes, you do. And now I'm getting everything because we're back in business.
Okay, thank you.
Thank you.
That's fine. I'll just take them and I'm going to toss them. Yeah, I'm right
Okay. Item number 13 on the agenda, the annual evaluation of the Executive Director, Gary Landry.
Just so the board knows, I submitted a self-evaluation, and I don't think I need to speak on the issues and all, but anyway, I put the things that have occurred over the course of the past year, and it's for the board's evaluation and review.
Mr. President, are you welcoming comments or questions?
Please, absolutely.
Thank you. Mr. Landry, I just wanted to double check under the third header, the financial, in the savings to the board for the travel and expenses. I know that the board was very curious or interested in having the southern location be the office location, I think 60% of the time. And I'm just putting it out there to the board members that perhaps there could even be more of a savings if we allow Mr. Landry to spend the majority of his time during this 2015 cycle, the January through June legislative cycle, if we prioritize Mr. Landry's office in the north. So perhaps it wouldn't be the 60% of the time in the south for the first 6 months of that legislative year, because then I think we could save even a little bit more money with unneeded travel back and forth.
Is there a way we can make that at Mr. Landry's discretion for those first 6 months, at his best practice discretion?
Well, I'm happy to do that. I just would like the board to know that if he makes that discretionary judgment, it may be different than what the board's intention of having a 60% of your time down south. And so it would be my suggestion that the board allow Mr. Landry to spend the majority of the legislative session in the north of the state during that January through June cycle.
Wouldn't that be something we would have to agendize and put on the next on the next board meeting to take up and make a decision on, since it's not on this agenda?
Yeah, I was wondering where that was in the evaluation. I'm looking at it now.
Well, it's on page 1, and it's talking about the savings.
Yeah,
and I don't know why you'd have to agendize something to just make something a discretionary judgment of the executive director to prioritize his time in the north where the legislature is meeting.
Okay, well, I'll tell you that on page 1, there is no discussion of where the executive director is located. And I believe at a previous board meeting, the board did vote to say that the primary location is 60%. So I'm not saying it's inappropriate to give him that discretion, but I don't know that that's on the agenda, at least under this topic. I don't see it on here. And normally you would want to have a clear and complete agenda that's going to include all the things you'll be talking about. So if you're going to allow him to change his location. I think that should be an action item because it was an action item before, and it's not on the agenda that way today.
I'm not changing his location. I'm asking him to please prioritize the North during the legislative sessions for an enhanced financial savings.
Thank you, Mr. Leader. Any further comments, questions, cares, concerns?
Mr. Landry, I think you did an outstanding job. I'm pleased with your presentation of your self-evaluation, as well as the actual work that it took to make this all happen. So just want to express that I think you're doing a great job.
I'll second that.
I had a comment.
Ms. Booth.
I just wanted to comment that I think your writing is outstanding. I'd like to see some improvement in details, like some of our meetings aren't, it seems like nobody's gone ahead to find out some of the issues that could come up. So I think the details have been a little bit lacking, and I'd like to see the improvement of that. I also, one of the things that was brought up in here was the where you gave everybody a survey. I'm sorry, I couldn't think of the word there. I would like to see a staff survey done by an outside source, because I think it's kind of tough when you're being surveyed by your supervisor. Personally, I just would like to see an outside source. I don't know if anybody agrees with me on that, but I would like to see that. I'd also like to see us as a team work closer together. And I bring up the Christmas party where the board members were excluded from that. And I think when you have a team, you have to have a whole team, not 3/4 of a team. And so I'd like to see maybe a little more work on bringing the board and staff together, because we all have to work together. And sometimes, as we found out, we do have to work together without a director. So it's important that we all can work together. And that's my comment.
And Ms. Booth, just so I understand, I'm going to take each one of your recommendations and put them as board agenda items so that the board can vote on that and give me direction on that at the next meeting.
Thank you.
Perfect, Mr. Landry. Thank you. Any other further comments? Do we need to take an action with item number 13 at all?
You do, either approving or disallowing an increase in salary.
Oh.
Well, my comment on that is that we gave you an increase in salary early on that I thought we should be giving you at this meeting. So I would suggest that we hold off on the increase in salary until next year.
I'll second that.
Mr. Nixdorf, was that in the form of a motion?
It wasn't. It was just a comment, but we can. It was just a comment for discussion.
Okay. Any other board members with any other comments?
I'd like to
Ms. Benaldi.
say something about that. Didn't we just have a discussion about what a great job he's doing?
Yeah,
I believe
absolutely.
so, yes.
That's what I thought.
Yeah, but that
So
doesn't
wouldn't
necessarily
that-
mean that every time somebody does a good job that we give them a pay increase. Come on, I'd be getting pay increases every single day.
Well,
I just
maybe
think
not
it's,
every day.
All right, Sunday's excluded.
Okay. Having no further discussion, I'll entertain a motion from anyone, please.
Well, if I could just, I think there's a couple things you're doing here. So there's an evaluation that's been prepared by Mr. Landry. So it sounds like you may want to approve that as written or make some changes to it, and that would be fine. Because I just want to make sure we have something for his file, because that's part of what a performance review is. And so that should be maybe approved. And then it sounds like there's also the question of a salary. So I think they're two separate things we're talking about, just so that we're all clear on that.
Thank you, Ms. Bradley.
So I'll make a motion that we accept the self-review and grade it as an A+, or however we grade that.
Is there a second?
And does that mean we're going to go and listen and do?
So far, we're just discussing the self-evaluation. We haven't discussed any salary increase or maintenance thus far. So I have a motion. Is there a second?
I'll second.
Having a motion and a second before the board, is there any further discussion?
Yes, I'd like to review this salary increase. Okay, so I'm just not really clear about it. It was presented at our last meeting.
With all due respect, that would be maybe the next subject when we make that. Right now, all we're doing is we're just accepting
All right.
his performance review and grading and giving him a well done on it and accepting that.
And an A+ attaboy, or however we do that. Correct. So a motion and a second before the board. Any further discussion? All those in favor say aye.
Aye.
Aye. Those opposed? That motion carries. Mr. Nixdorf.
All right, so I would like to propose that since that we do not give him a salary increase this year because he's already gotten his salary increase shortly after he was hired on, and that we do that next time.
Is there a second?
Second that.
So there's a motion and a second before the board. Any discussion?
Is that, Mr. Nixdorf, to consider for next time, or is that an autumn?
Consider.
Ms. Booth, would you amend your motion to be consider also?
I amend my motion to be considered also.
Okay.
And when would that next consideration be?
Probably the next annual evaluation, I would imagine.
And that would be
1 year from now?
Yeah, 2015.
I believe Mr. Landry started working for the board in April of last year. And so.
And then we did the increase, and then, I'm sorry.
I just want to say, so normally the annual review is every year, so it'll be roughly a year from now.
And the increase, yeah, it was pretty quick. Okay, that's what I need to know. Thank you.
Ms. Benaldi, did you have any further questions?
Absolutely. Okay, so when we hired Mr. Landry, we hired him for a base salary. It was within what timing, can you refresh my memory, that we gave him an increase? It was 3 months.
It was after the first 3 months. It was a 3-month evaluation that the board had submitted that I submit to. At that time, I did a self-evaluation on a 3-month evaluation, and the board granted a pay increase.
So just in general, Mr. Landry, could you tell me how much time you spend at the board office daily?
From a daily standpoint, we work 4 10-hour days, so that's what you spend during the day. You, as any executive, you do certainly spend that time outside of that. I do get compensated for travel whenever I'm on official board business outside the normal time frames, for weekend work and all. But I mean, I work whatever's necessary. It doesn't matter what the schedule is. You just work till it's what's necessary to get the job done.
Are you compensated for gas for your travel back and forth?
Yes, I am.
Is there a car allowance?
There's no car allowance, but the compensation is based on GSA schedule, so that it's not just a straight gas reimbursement. It's for gas, wear and tear on the car, oil, tires. It's all built into that rate. And it's the same rate that board members receive also, and that any member who's employed by the state follows that same GSA schedule.
Is your current salary include all the benefits listed, like this number that you have in here? Does it include all the insurance and all the different benefits?
It does not. The benefits are beyond that. There's a state contribution to retirement, as well as a personal contribution. It's all the same benefits package that every employee in the state would have.
Because you did state later on in the other employee review that there was a whole package, and then there was a little bit of a difference there. So I'd like to revisit this, but I need a little bit more information. So what you're saying is we cannot vote on it, or we can't revisit it next board meeting?
What we can do is you can vote for or against my motion, and if my motion fails, then we would present another motion that would grant him a pay increase.
Okay, thank you.
And Mr. Landry, just for clarification, could you tell me what percentage your benefit package is of your salary?
I'm not sure the exact percentage, but as a state employee, your benefits package equals about anywhere between 35 to 50%, depending. It's a little. you have a higher percentage if you make less money because there's a bigger benefit to you. The higher your pay, the less your percentage benefit is.
Oh, and Jeanette, when I do sign checks and I do sign his timesheets and whatnot, his travel is usually spot on consistent. It's the same every single month when he drives up and back. So it's the same amount of miles, the same amount of cost. It has never changed, except if he's on a trip or whatnot. So I could definitely affirm that.
Okay, so there's a motion and a second before the board. For the record, Perry, could you please restate your motion?
My motion is to not grant a pay raise this period and to consider, and because we gave him a pay raise already this year, and that we would then consider at the next review raising his salary.
And then also the second from Ms. Booth, I believe it was, yes?
I agree. A second.
Okay. So any further discussion? I'll take that vote then. All those in favor say aye.
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 And those opposed?
Nay.
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 So that's 4-3, so that motion carries. Yeah, so we had.
Could we see a show of hands?
A show of hands. So the ayes, and then the nays. 1, 2, 3. Yeah, so it's 4-3.
I apologize. It's just hard to hear sometimes.
Huh? Item number 14 on the agenda: discussion of the revised employee handbook, job descriptions, career planning, and staff training. Mr. Landry.
It's me, I think.
Yes, we were going to move number 19.
So we're going to move 19 to 14?
That was...
Okay, I'm sorry, Gary. Discussion of the executive director hiring process? Ms. Booth?
First of all, I'd like to again compliment Mr. Landry on his writing. He does an excellent job. When I started out doing this process, I didn't know a whole lot, but again, I went to the HR director of Boulder City and asked him to go over it and see if he agreed with some of my changes or not. The recommendation, the very first one, let's see. The very first one, this was not a recommendation, but this is one that I saw that when we were working together that we had a lot of trouble because the staff didn't know what their position was supposed to be. We didn't know what our position was supposed to be. My recommendation is that the president, like right now would be Neil, that he would be the liaison person. So if they had a problem there, they needed something, they could go to Neil. Neil could also appoint someone to go there and visit the board each week, or the staff each week, and make sure they had all the supplies and everything that they needed.
So whomever the president of the board designates.
Right. Yes, and they would be that liaison person, so we were working again as more of a team. And then the second thing, this was recommended to me by the HR director of the state of Nevada, and the HR director for the convention center, and the HR director for the city of Boulder. And that is that we have the opportunity for the next board that's here to have a headhunter come in and do the process for us instead of trying to get staff to do us. And I think we weren't, we didn't have it in our rules, so we couldn't do something like that, but it would be a lot easier and it wouldn't take time away from staff, and that seemed to be a major issue. So my recommendation is that we have in there that the next board could hire a headhunter company. And I gave kind of one of the ones. This is a person that the CPS is one that the state of Nevada lady gave me. And then on number 11, this also, take this out of the hands of staff and hire a company that does the investigation of it. And I've listed it, the candidate overview, employment verification. They actually go and visit their previous employers, and criminal, civil, and news media. And then they give you back a packet. I actually got to see one. It's probably about 3/4 of an inch thick. It runs about $3,000. And again, that takes away from staff having to do this and spend their time on it, because it is quite timely to get this information in. And those were other than that, Gary did a great job. Those were all the corrections that I had.
Thank you, Ms. Booth.
So, just as a matter of clarification, I don't know if anybody for the board or if any of the office staff know, do we have any idea offhand what we spent going through the entire process with Mr. Landry to hire him? Do we have a ballpark for that with anyone? Because that would be information that might be part and parcel to this whole discussion about the recruitment of the next executive director, which is kind of...
And Neil, they don't have to. It would be the board's discretion if they went with a headhunter or if they went with staff. It's not.
I'm just curious because
it's an and/or situation, so that they would have it, because it probably at that time they need to check with staff to find out how busy they were, because they may have the time.
Okay.
Yeah. On your specific question, Mr. President, I'm not aware of what the cost was for that entire process, but we can get that and report that to you at the next board meeting or even in my weekly updates.
Actually, the weekly update would be great. Just as a point of clarification, because I know we had the initial application process, one meeting to filter through the applications, another meeting to actually decide who the finalists were going to be, and then another meeting to have the finalists show up and actually do the interviews to hire an executive director, and then you were hired at that time. So just as a point of clarification cost-wise. Thank you.
A thought I had, and I don't know if it's relevant or helpful, but I saw in the employee manual, there's the deputy executive director. So it could be that that person is also helpful maybe in the recruitment. The only issue, I guess, could be is if that person wants to apply for it. But I mean, I just thought certainly a deputy executive director would be maybe an important person to help while there's a vacancy and or get the recruitment out, you know.
And this was, like I said, this was recommended by 3 HR directors, just simply so you have an option, so that if we get stuck in a position where we don't have staff time, it's strictly just an option that you do. Although I think I would recommend that, and again, it's an option if you want to do the background check by somebody else, but I think that's a lot of work to do a background check on somebody. And I think with staff doing their everyday job, that really should be sent out. But again, that's an option.
Okay. Any further questions of Ms. Booth?
Are you actually going to be making a motion that you change these items that are presented here to do that?
I am.
Could we get that very clearly defined? Do you have it in writing? Did you prepare anything?
Do you have one of these down there? Has somebody passed one to you?
Oh, that's right there. Here it is. Okay.
I'm sorry.
Sorry. I just didn't pass it along. Sorry
I'm
about
sorry.
that.
I have one for Alex. I'm sorry, Alex, I stole yours.
Do we have enough down there? I have one in my hand here.
Joanne, get one as well.
Okay, I make a motion that...
I apologize. I had one. Normally, I would keep an attachment to review, but it's okay. I passed it down. Alex has one now.
All right. Can you just give me a minute, please?
Sure.
Of course.
And just looking over Ms. Booth's recommendations, I think they're all very good recommendations, and it does give the option for the next board. Again, it wouldn't necessarily, it could be this board, but it doesn't necessarily mean that this board would be the one acting upon this. But when the time does come where the board sees fit to have another executive director, it would give some guidance that at that time the board could agendize and make modifications to the document for the people who would be serving at that time. But I think having outside consultant in this area in particular is probably a good idea, at least as Ms. Booth's saying, to have it as an option.
How are we doing, Mr. Nixdorf?
It's all good. I just happened to notice the little typo under number 11. The board should be may. I think it's good. I think as long as these words "may" is in there, I'm good with this.
I don't know how the state does background checks, but it might be something to pursue as well. I don't know if it would be less expensive or how they do it, but I know anytime a director level position, for example, in state government is hired, there is a background done. I don't know that it's a fingerprint. I'm fingerprinted for my job, and so our office does it a little differently. But I just thought it's an option because I know the state does do this for many employees.
So we should put fingerprint in there under
no, I don't know that you need to do a fingerprint for this job. I mean, it's up to the board. You could, But
they do check criminal records in
you can do it like it's with a driver's license. I think the police department can do a check by running the name to see what comes back. I don't know how the state does it. I just thought maybe there's something HR has that would help us in that regard, and maybe we could ask them to give us that name or information. Just a thought. Not that Gleason wouldn't work, but
that's what's in here is the person that does the background check that was about $3,000. That's one of the things they get into is the criminal side of it. They actually go and check records and stuff like that.
They do that for state employees as well. I mean, especially the higher level positions, they do that.
Excuse me. We currently do use an outside agency. It's called Employer Links. The expense to us is pretty nominal. And there, it takes about a week or two on average.
Thank you. I didn't know that.
So, Koki, I think you did a great job on this. I think it's, I think it gives us a bit more leeway at the time when that happens to pursue different directions. So I think it's good.
So may I make my motion now?
Well, just hang on a second. Sorry, I'm going to interrupt you. Mr. Helms, so if the outside agency that we're using, do you know if they do a fingerprint check as well, since we're discussing it?
It is an option. There's certain items, I think they check about like 10 or 20 different things, and that is an option. We don't currently do that, though. So,
as an example, if we wanted to make that part of a motion to make it that we did do a fingerprint background check, we could do that then, yes? That's an option with them,
correct.
yes? Perfect,
yes,
thank you.
It is an option, correct.
Okay, Ms. Booth, you were saying, sorry, I didn't.
Well, and I'd like to add under number 11, fingerprint, because I think if it's an option, why not do it? I know I have to, just to be a broker for a real estate license, I have to be fingerprinted, so... And so we'll add fingerprint to number 11, if that's okay.
If we add fingerprint, can we take out Gleason and Associates?
Oh yeah, that's in brackets. That's just a name that does it that the state gave me.
Okay.
These are just some names that were given to me. They're not to be in the final.
All right. So if this isn't supposed to be in the final, then let's cross it out.
I'll clear that out. Clear that up too. The bracketed information was just for the board members. So I'll make my motion now with that information in it.
Okay.
Okay, so I'll entertain that motion then.
I'd like to make a motion on the recruitment of the executive director, all items in red to be approved except for the items that are bracketed. Those are to be removed. Any spelling errors to be corrected. And under number 11 to add fingerprint to the executive director check. Credit check.
Is there a second?
I'll second that.
Okay.
The only thing I want to add is I believe fingerprints takes a little bit longer than a police DMV type check. So not that they don't check criminal. I'm just saying I think there's like a 2 to 3 month window to get the fingerprint reports back. So I know at the AG's office, when I'm hired, day one, you actually get your fingerprints done in the office and then they send them out and they tell you if there's a problem, you'll know in a couple months. And so I just want to say that if we're going to require the executive director be fingerprint checked, then you're not going to actually have that back probably until they're already on board. So I don't know.
Well, we can jump off that bridge when we get there, but for now, right.
Manual doesn't say that you're going to hire them waiting for that. So that's the only thing. I think that may be why you hadn't done it in the past, because it takes a little bit longer.
Because it's more of a time
constraint. Well, you send it to the FBI and to the state criminal repository, and so it just takes a while to get the response. So I was just thinking of that as we talked about it, and I realized you could be in a position of hiring someone and then getting it back. And maybe there's nothing wrong with that. I'm just saying maybe this would need to be updated then to reflect something to that.
I think they're going a lot faster now. When I first got my broker's license, it was taking people a lot longer. Now, last time one was done, it took about 2 weeks. So,
well, there could be mitigating circumstances. What if we just put optional by it? So in case that, let's say somebody had to leave immediately and we needed somebody post haste.
We'll put optional.
Would you like to
I'll
amend?
amend my motion to put optional by fingerprint.
And Mr. Nixdorf, you want to amend your second? Okay. Any further discussion before the board? Motion? No? Okay, I'll take that vote. All those in favor say aye.
Aye.
Aye. Aye. Those opposed? That motion carries. Okay, now number 14. Yes? Is that right?
Yes.
Discussion of the revised employee handbook, job descriptions, career planning, and staff training. Mr. Landry.
Yeah, I want to really commend the management team. This was very much a team effort in going through. We've combined the state employee handbook and the existing, with revisions, employee handbook that we had previous, and put them into one document. So we'd be in conformance with all of the state regulations. They cover things that we hadn't covered in the past, and the state employee handbook calls out specific statutes within the state laws, the NRS, that pertain to employment and to your rights as an employee. So that's I want to commend staff on that. The management team in particular. We had several meetings, went over this in pretty good detail, and tried always to be fair and impartial for the benefit of the employee. One thing that we're adding on to, my recommendation to the board would be to take these up as 3 separate motions and votes: the employee handbook, the career planning guide, and then the training, because you could approve or disapprove any of those. The employee handbook is really kind of a day-to-day operations manual on what the rights are for the employees, what rights they have if they're going to be faced with bereavement, if they're going to be faced with extended sick time, family medical leave, the HIPAA laws, all of that. So all these administrative things that we have to do. The other 2 sections are things that have not been done at the board previously that I feel are very important for staff, and that one is career planning, so that we have a one-on-one session with each staff member and let them know, you sit in this position today, these are the advancements you can make, and in order to do that, in order to get to those advanced positions, that ties into the career, to the training courses. There would be certain required courses if you wish to be promoted to the next level, say from Inspector 1 to Inspector 2 or Inspector 2 to Inspector 3. You would take certain courses in management. You take advanced courses in investigative techniques. Though each of the career training is specific to the employee themselves, or to that position, I shouldn't say, not to the employee. So that's what we did as a team, and I think it's a good first effort for us, and I await board comments.
And I'd just like to say, on behalf of the board, thank you so very much to the office staff and especially the management team for putting forth so much work. You guys are asked to do a lot of extra stuff, and you accomplish it. So thank you.
So, Mr. Landry, could you please clarify for me those 3 different areas and by pages? Because this is all...
To the end. All of this at the end.
Yeah. So... Oh, got it. Okay. Got it. Okay, so I have one comment. I think you did maybe I have 2. One is I think you did an outstanding job overall on this thing. I went through it and I felt I knew a lot and if I was starting for you, I would be very well informed. My only concern was under the job titles and all of these, all your job title descriptions. My concern was a little bit when it says responsible to, and you have 2 people they're responsible to. I tend to feel it should be like a singular flow. So I was wondering if you could clarify for me why you did that and what that's about.
Sure. The reason behind that is we wouldn't necessarily have a 3-level position at all times. For instance, in inspection teams, you may actually have an Inspector 1 that could report to an Inspector 2 or an Inspector 3, depends on who's there. When people go through their careers and say an Inspector 3 retires, that doesn't automatically mean that the Inspector 2 gets promoted to Inspector 3. So that reporting assignment would then go to the next person in line from a management perspective, and that's the reason why we included it. It's not, I agree with you on a single line of command. You report to one person, that's the person you're responsible to, but I tried to cover all cases and situations. If someone had to leave unexpectedly, if someone retired, if someone was out sick, and they had to be, reporting requirements that were shuffled around. That's why they're dual reporting for those particular positions.
I just felt it was a little bit confusing because to me it would make sense to me that if your chief inspector 2 wasn't there and that the chief inspector 1 would take over 3, however that works, right? That's sort of an automatic thing that it's the next person in line that you then report to. So this looks to me like they have the potential of reporting to 2 people.
And we would clear that up on an individual basis. But for instance, say someone was an inspector one was reporting to an inspector 3. That person decides to leave. We may go some years before an inspector 2 is eligible to be promoted up to an inspector 3 position. The positions in the past have been more or less longevity based, and what we're doing is looking at qualifications, experience based, the longevity, the performance, blending that all into a promotion. You don't have to wait. This doesn't wait on a new inspector 3 position, quote, being opened. When you're eligible for inspector 3, you would have the ability to apply for that position, that you would apply to be moved up, not that it opens up. The only thing that would have to open up would be the budgetary requirements. We're always going to fall within, the budgets, and if there are budget dollars not available to support that promotion, then you wouldn't be able to receive that promotion. That would be the only restriction.
Thank you.
I had a question, and it's just on the word bachelor in here. I was reading this through with the inspectors, and I know, so I try to go out into the public world here and find out. To be a Henderson Police officer, you do not have to have a bachelor's degree. My concern with having this in, and it would go out into the public, is that maybe somebody, because you get down to the third sentence when you see an or. If the bachelor's degree just stated preferred but not required, because I'd hate to see really good candidates turn away from reading what the job description was because they thought they had to have a bachelor's degree or equivalent in a major criminal justice or health administration. So I'd like to see it open up so that they would get down to that or and see that there'd be a possibility, because I think there'd be some good candidates out there without a bachelor's.
And we as you said, the way it's written in the handbook, we don't require that. We would be very clear on any job postings. These are not, this is part of the handbook. So this is once someone's hired, they get this handbook to know what their duties and responsibilities, what their rights and privileges are. But I agree with you 100%. Any job that does not require a specific degree, we'd be very explicit in our job description when we post it to make sure we get the broadest net thrown out there for the best candidates.
Okay, if that was my only concern is going through this. Thank you.
I agree with Ms. Booth. I definitely would like to see the word bachelor's degree preferred, particularly on page 99 of 131, where I think it's the educational attainment of the deputy executive director. I would definitely like to see the or closely related fields rather than just being degreed, particularly on that one. When we move to page 7, it's the history of the Board of Cosmetology. I mentioned this to Mr. Landry over the phone. Because we're repeating the mission of the statement on the history of the Board of Cosmetology, I want to remind the board that in the 4th sentence that we protect the health, safety, and welfare of the customers receiving services and the industry practitioners through education and ensuring only qualified persons are granted licenses to perform cosmetology in the state of Nevada.
I agree with Mr. Leader, and I was remiss in not doing that in my opening comments. On page 7 and on page 8, the words education and were added to the 4th sentence, as Mr. Leader says, under the history of Board of Cosmetology, and it was also added to the 2nd line under organizational structure, where we talk about minimum education and training standards.
Thank you. On page 46, I just want to check with Mrs. Blasco's replacement. I'm so used to saying Ms. Blasco. Andrew,
Andrew Helms.
Is there a reporting policy in place for the 240 hours so we kind of know when people are getting up to 180, 200, 220?
For the for
Family
which position was
illness.
this? I'm sorry.
It's on page 46. It's the sick leave.
Yes, I'm sorry.
The capping out at
Yes.
the 240. What is the policy to report that so somebody just doesn't find out that they're at 240? When do we start keeping a record of that?
We currently use a third-party system called Paylocity, and each employee has a login in which they can go in and check their pay stubs. It's also the employee's responsibility to maintain their own timesheets, which they submit every 2 weeks to me, at which time I would either let their supervisor know or the person themselves.
So there is a procedure in place to monitor the ever-increasing number of sick hours? Yes? Is that a yes? Okay, I can't hear him.
Can you not hear me?
Yeah, no. Okay, you said yes.
Can you hear me?
Yeah.
Yes.
Now we can. For some reason, earlier you were not being audible. I don't know why.
Oh. Yes, that is the correct procedure. There is a policy in place.
And then finally, Mr. Landry, were you able to have Monica include the current step and grade applicable to this date? So because all of the positions do record the grade, and so without the current grade step position, it's hard to determine the accuracy of those.
I will have that added into the back of the employee handbook. And as I explained previously, that does change. It has not changed in recent past because there's been a kind of a freeze on increases due to cost of living. But that was the practice prior to that. And those grade steps will be revised. As they get revised, I'll make sure we keep up to date with the handbook and have the most current grade step designation in there.
Thank you.
I had one more question here I forgot to bring up. I apologize. On the organizational chart, the board isn't on here, and I just think that it's important to have so that the employees know where the board is on here. I just think it would be important, and again, it goes back to my working together as a whole team, so that would be a recommendation I'd like to make.
I can accomplish that's a Visio document. I can add the entire board as I have a direct reporting relationship with them and put that in the organization.
Yes, thank you.
Any further discussion?
I just wanted to add one thing. I've reviewed the manual, and I think it's well done as well. I remember the previous versions, and I think it's much improved from my perspective. The only thing, and Mr. Landry and I discussed this maybe a week or so ago, I think in our office, well, I know this is true. In our office, we have deputies that are personnel and employment law focused. And in the past, I know one of them did offer to review the previous manual just to see what their thoughts are regarding it. And so we talked about that. And I think if the board would like that to happen, that might be a good idea that one of those deputies review it. And just if there's any concerns or anything they'd like to talk to Mr. Landry about. Because one thing and I'm not an expert in employment law, but I know we're in an at-will state. And we want to make sure that we're not, guaranteeing things or somehow setting up contracts when we don't mean to. But at the same time, we want to have a helpful and good manual for our employees. So if the board would be okay with that, I think that would be a good idea.
I'd like to make that motion if I can, because I think that's a great idea to have the handbook reviewed, and I'm sure Mr. Landry would appreciate that.
So would you like to make, I believe the original recommendation was for 3 separate motions. We're talking about the employee handbook, job descriptions, and career planning, as well as...
Yeah, the employee handbook would include the job descriptions, but we'd have a motion to accept the employee handbook or reject it or revise it. The second would be the career planning that you'd want to accept or reject.
And then the staff training.
And the staff training, yes.
Okay. Ms. Booth.
Okay. The employee handbook, career, and what was the third one?
The training.
Training.
Staff training.
And before we approve this handbook, I'd like to see it go before the, have it reviewed and then bring it back to the board for approval after it's been reviewed, in case we need to make some other changes to it. That would be my motion.
I'll second that motion.
Any further discussion?
Yeah, I think we should approve it pending the outcome of that. So I think that it should be an approved item that we don't bring back here unless we get a negative or a change that is required from that review.
I think we heard from board members that had little minor typographical corrections, and Mr. Landry did indicate that he has made corrections to the document, which all of us are looking at an original. My preference is to observe Ms. Booth's motion.
I have just one question. Is it going to hold up anything by waiting until August? I mean, is this something we can function with, or?
I know, I mean, from the comments I've gotten back, the board has generally approved this. There's nothing that I can see that would be, there's nothing catastrophic. The only thing, we've incorporated the employee handbook from the state, so there are some provisions that would provide clarity to staff a little bit on some of those areas. We could take this as as an approval as written, and we could come back with changes. We can have it come before the board again with all the finalized changes. The changes that you've mentioned are all pretty minor.
Well,
I would like to just make sure that we get this in staff's hands as soon as possible, because it does cover some areas that were holes before. We didn't address those.
Well, dealing with contract law, this is my concern, what I heard Sarah say. When you deal with contract law, and this is an at-will state, if we put something in there that could come back and bite us in the hiney, then it probably would have been beneficial to wait and to have it reviewed. So that's just my concern. I think that Sarah brought up a really valid point, and I think if the employees knew this was going to be, maybe there might be some changes, but it's not the law yet, so you wouldn't have a contractual agreement.
I think the current policy actually, what I meant was by allowing a person, for example, to appeal their termination to the board, which is in the current manual, that's where that came in, those thoughts of the grievance procedure and allowing someone to appeal their termination. I'm not saying those are bad things, but I know when I talked to a colleague about it before, they kind of said, well, why are you doing that? Because in the regular state system for 284, there is more protection for employees than you guys are actually required to have, because you don't fall under 284. You're not a general fund agency. So that was all. So she was just saying, are we making guarantees that we don't need to make? Doesn't mean you can't. You should just be aware of what guarantees you're adding that maybe aren't required. That was kind of the intent. And like I said, this was probably a year or so. It was when we still had Mr. Gimno here. It was a discussion that one of the deputies in our office had raised. And so I said, yeah, I think we would probably like you to look at the manual. And again, this one is much improved over that one. But so I guess my thought is, I think the concerns she noted, you probably currently have anyway. And I'm not sure they're really concerns. I mean, they may be, they may not be.
So, Mr. Landry, you'd prefer that this handbook be approved so that you can pass it out? Because if we don't approve it, then we're not going to pass it out until after the next meeting, correct?
That's correct. I could, I can give a kind of an in-between compromise. I could discuss it with staff and letting them know it's in draft condition, that, we're waiting on the August meeting to get approval of that. I don't mind doing that. But I just want to make sure that when it talks about other areas that we currently don't we don't have a policy, we don't have anything in place, we kind of it's kind of make it up as you go if it's not written down. I just want to make sure that I give them some assurance that these are some areas that we're cleaning up and clearing up. In particular, the career planning and the training. So if those, I don't think have to, unless Ms. Bradley says otherwise, I don't think those would be held up by any, it doesn't affect that will, because you're just talking about doing career planning and training. If we could get those approved and just hold off on the approval on the handbook itself until then, or give it tacit, whatever motion you want to have.
I can amend my motion to do just exactly that. And that the handbook will be, they can review it in a draft form. That's amendment to my motion.
Mr. Leader, will you amend your second?
No, I know I won't.
So are you going to withdraw your second?
I will withdraw it.
Okay. Do I have a second to Ms. Booth's motion?
I'll second.
So I have a motion and a second before the board. Any further discussion?
I'd like to have Ms. Booth restate her motion so that I'm clear on it, because I'm confused.
Okay. The employee handbook will go to the AG's office for review, and the employees may look at it in a draft form. The career planning and the training will go forward with that. That's an approval to just go forward with that. Where the law applies in the employee handbook, that will be sent to the AG's office before it's approved, and that will come.
Pending final review for the next board
Yes.
meeting.
Pending final review for the next board meeting.
I'd be more comfortable if we separated that out and made those into separate motions. The handbook, the career planning, and the training as separate
Okay.
motions instead of all in one motion.
I'll make the first motion with the employee handbook.
But before you start, so you need to withdraw your motion.
Draw my motion.
And April needs to
Withdraw
withdraw
my
her
second.
second. Okay.
Okay. The first motion will be that the employee handbook go to the AG's office for review, and in the meantime, it can be reviewed as in draft form, and that it will be at our next meeting, it will be presented for final review.
Did you want to second that still?
And I will second that.
Okay. Any further discussion for the motion before the current motion before the board? Okay, I'll take that vote then. All those in favor say aye.
Aye.
Aye. Aye.
Aye.
Those opposed? That motion carries.
The second motion would be that the career training and the, I keep getting messed up on this. Career planning and training go forward as they're written.
But we were going to separate those two as well in agenda items.
Okay.
Or I'm sorry, in motions.
Okay, so motion number, that
So the
the
next motion will be for career planning
career
solely.
planning will go forward as written.
Is there a second to that?
I'll second that.
Having a motion and a second before the board, any further discussion? I'll take that vote then. All those in favor say aye.
Aye.
Aye. Those opposed? That motion carries.
The last motion will be on training. That will go forward as written.
I'll second that.
Motion and a second before the board. Any further discussion? I'll have that vote. Those in favor say aye.
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 Those opposed? That motion carries. I think we're going to do lunch. So it is 12:07. An hour, Mr. Landry? All right. So 1:07. Thank you. So apologies to you guys down in the south. It's entirely my fault. I was checking my eyeliner, so that's what took me so long. Okay, so a little bit later than we had planned on. It is 1:22, and we'll call this meeting back to order for the Nevada State Board of Cosmetology. Monica, there was some discussion about a moment for comments from down in the south with regards to a previous agenda item. Did you want to take that away?
Neil, actually, I had a couple of people come and ask me who said that there was public comments allowed, which were next to that agenda item, and they would like to go ahead and take advantage of that.
Yeah, please, if they'd like to step forward. We would like to remind them that they need to keep their discussion to about a 3-minute interval, if they can at all help that, and towards the topic.
Hello, my name is Lou Suarez, and I represent Euphoria Institute. And I just had a comment on number 13, which was the evaluation of...
Excuse me, could you just a little bit slower, and could you spell and state your name for the record, please?
My first name is Lou, L-U, and the last name is S-U-A-R-E-Z.
Thank you.
So getting back to what I was saying, it's a little discerning that, that you on the board sit and comment on what a great job Gary has done, but yet you don't feel that he's entitled to any kind of increase in his salary, and I disagree with that. And I'll tell you why. He's helping the schools with many different things. The most important thing coming up is gainful employment, and he's making it so that we can go ahead and get our students licensed in a faster manner than the prior administration. The prior administration, it took anywhere from 4 to 6 months to get licensed. So any student that graduated in March or April, it was really a challenge to get them placed by the appropriate time, which at that time was September 15th. Even though they've moved it forward now to the beginning of November, end of October, it's still a challenge. And I just don't understand your thought process to that. His vision is to make the state board more user-friendly. His vision is to make it so that it's easier for the stylist, to come in and they can register online. And there's just so many things that he's doing that's so positive. And I think your time frame of that you gave him a raise a year this year is incorrect. If I remember correctly, he came on board in April. You gave him a raise in July of 2013. And if you choose to not increase his salary, he's going to go almost 22 months without a raise. And I don't want to lose him as our executive director for the State Board of Cosmetology of Nevada. I really am happy that he's there. He's great to work with. He's approachable, and I just wanted to say that. Thank you.
Thank you so much. We appreciate your comments. And again, if you could please state and spell your first and last name for the record. Thank you.
Benita Williams, that's Benita Williams, and I'm with the Euphoria Institute as well, the Summerlin campus. And I want to also concur with Lou Suarez as well regarding Gary. I must say that he has become very progressive for us. Some states are still paper trailing it, and we are definitely on the move towards electronic applications. That's cutting down a lot of manual work for our board, which is for our students to be able to come in. I mean, that didn't happen by itself. That was a direct lead by Mr. Landry. He has been progressive with that, and we're very respectful of him. He respects us, and it shows every day that our students come to the board, and his staff work diligent to help us in retention, gainful employment, all of that. And gainful employment is going to affect every last person in this room, as well as in Carson City, if we are progressive in helping our students get employed and repay their debt. So I must say I am strongly in favor of Mr. Landry receiving a salary increase. Thank you.
Thank you so much. And please, for the record, state your first and last name and spell. Thank you.
Sure, it's Sonia, Sonya, Petrie, Petrie. Excuse me, I'm with Euphoria Institute as well, the Regional Director of Admissions and Career Services for the schools. My whole thing when we were listening to what we were during that item point was that if you look at the timing, I mean, if I didn't get a raise for 22 months after doing a great job, I'd be a little frustrated. I don't think it's fair. If he got, again, we go with the timeline, right, that Ms. Suarez mentioned, that's 22 months without a salary increase. And again, I just don't think that's right. And I won't reiterate what everybody said, but Gary has been such a blessing. You know, directly involved with career placement for our students. You know, when it was taking 4 to 6 months to get them placed, I mean, they get distracted, they go onto the strip, they get a job, and they're not doing what they spent the money to and their passion. You know, so now we're looking at, in some time frame, those students are in and out in 4 weeks. And anytime we have a problem, the other day we had one, I sent Gary an email, he responded within 2 minutes, and he solved the problem. You know, he is, and I think it was one thing when everybody was sitting up at the board saying, oh yeah, he did a great job. He's not doing a good job, he's doing a phenomenal job. And I think he needs to be recognized for that. I just think it's a shame. 22 months without a raise it's just a shame. That's it. Thanks.
Thank you so much. Is there anybody else that would like to? Okay. For the record, please, sir, state your name and spell it. Thank you.
Mark Gicola, DECOLA. I represent Euphoria Institute as well. And I would just like to echo the sentiments of everyone that's spoken ahead of me in terms of just approachability in the ability to communicate with the board. The level of improvement that we've seen since Gary has been working there is exponential. I've lived here and worked with the board for 15 years as a licensee in this state, and it's really refreshing. And I think, you know, to echo their sentiments again, that 22 months without a pay increase it's absurd, especially when everyone on the board will sit there and say what a great job he's doing. To not, you know, say it with cash, as I'd like to say, is kind of a slap in the face for someone who is doing such a great job. So that's all I'd like to say. Thank you.
Thank you.
You're not planning to go without a raise, are you?
Hello, I'm Gail, Gail Moore, employed by Expertise Cosmetology Institute. And I will agree that Gary has done a tremendous job, but he did make the statement talking about our economic hardships. And if I could ask the staff members of the actual Board of Cosmetology that are our inspectors and our managers, when is the last time that they had a pay increase? Do I have an answer?
Well, it all depends on their level of employment, where they are in the grade of pay that they have for the specific position. So it varies employee to employee. I don't know that anybody could answer the same question. And that's also something
what we're saying is...
Well, I understand what you're saying.
He hasn't had a raise. But it's okay for him to have a raise in 22 or in a year, but it's not all right for the staff who keeps that office going. I mean, I understand. I went through the whole hiring process, and I was the only one here for every interview that they had, and I think you made an excellent choice. But at the same time, everybody should have the same opportunity to get a pay raise.
I understand that, but we're just trying to keep the discussion about the specific agenda item with regards to the raise for the executive director.
To do with it? I mean, how could you not think that?
The executive director is the one that is responsible for all the employees underneath him with regards to other employees getting raises, if that's what you're asking. Beyond that.
Okay, I have been licensed since 1974, and I've seen this board go up and I've seen it go down, and I've seen tremendous upscales since I've been in the business. And I go back a long way. And I know that our office staff is what makes this state board run. So and I was always taught that I would never do anything as a boss I wouldn't expect my employees to do. So he should be concerned about his employees that are really helping him look good.
Well, thank you for the comments. I do believe that he does do that as an executive director. Thank you.
Jan Garrett D. Simone from SECTA, so I'm coming from a different perspective from the public high school setting. But I wanted to thank Landry and staff today because the website is so user-friendly now. It's so helpful. And today I registered, or I should say I did my first completion form, and it was like heaven. And so we only do that once a year, so I know we're totally different. But to all of you, thank you. And Mr. Landry, you are outstanding. So thank you very much.
Thank you.
We need her name for the record. I don't think we had that in the spelling. I'm sorry, ma'am. If you could come back and give that to us.
Oh, I didn't spell it. I apologize. It's Jan Garrett D. Simone, so it's Jan. Last name Garrett hyphen capital DE capital S as in Sam IMONE.
Thank you.
I apologize. Thank you.
Are there any further comments? Okay. Agenda item 15.
I don't know if, before we move on, does anyone want to reopen the agenda item 13, annual evaluation of Executive Director Gary Landry, based on any of the public comments? You certainly don't have to, but you're certainly able to if you like. You've approved the written appraisal form, and you opted earlier to defer a raise to, I guess, a year from now approximately. So I just, before we move on, I think we should make sure that the board is ready to move on.
Would anybody like to make a comment?
I think just to reiterate, it was a 4-3 vote. It wasn't a unanimous vote. So it was a 4-3 vote for Mr. Landry's raise or not thereof.
So I guess what I'm saying is it was a close vote, and if someone wanted to reopen it, you could ask that it be reopened, and it could be that people want to change their opinion based on the comment. Maybe they don't. I just want to make sure that because it was an oversight, and I apologize to the public that we didn't call for public comment on number 13, because that was the intention. It wasn't that we didn't intend to do that, so I apologize for that. I'll take the blame because I'm used to doing public comment at the beginning and at the end, so I didn't prompt Mr. Hoffman to do that. So I'll be better going forward.
Wouldn't that be my fault then?
But I'm supposed to make sure you do what the agenda says, so it's my fault.
At any rate, okay. Any further discussion?
Yes, this is Lou Suarez again, back from in the South from Euphoria Institute. I would propose that you revisit it in July, and then it would be exactly 1 year from once you gave him his original increase.
Thank you.
Thank you.
Is there any board member who would like to propose that as a future agenda item?
That would be me, definitely. Again, I'd like to revisit it. I think it begs for, the public is, all about it. I see huge potential, and I do not want to risk losing this man.
Okay, so when we get to agenda item 21, we'll put it on the agenda at that time. Ms. Bradley, does that work for you?
Yeah,
I mean, if that's Ms. Benaldi's intention to talk about it next time and not to bring it up again today.
We have the agenda item 21 for future agenda items, so we can add it on.
If that's what her intention is, that it be discussed in August.
Yes, it is.
Okay. Agenda item 15, the proposed financial budget for 2015. Mr. Landry? Oh, I'm sorry, Andrew.
Yes. Can you hear me?
Yes.
Okay, good. Did you want me to just go over the executive summary? Or do you want Gary to do it?
Why don't you go ahead and take it?
Okay. So you'll see here in the executive summary, there's a few items that are outstanding on the budget just because they're quite a difference from last year's budget. If you want to read through it and then ask me any questions after that, or...
That would be perfect. Thank you.
Okay.
Everybody got the same page number? Okay, Andrew, go ahead.
So the first item is computer equipment software. There's a bigger increase in that because we're moving from our Versa system to GL Solutions. The reason for that is it's basically a reallocation of the depreciation expense. We can't depreciate the GL Solutions just because it's what's referred to as SaaS, Software as a Service. You can't depreciate that, so instead we had to take Versa. We're estimating to take Versa off the depreciation expense since that was a software that we purchased, and then GL Solutions we cannot depreciate. So that's just a reallocation of the expenses. Number two was the hired rater, so we increased the rater expense. That's probably one of the most significant increases from the prior year's budget, and that's because we're no longer using staff for the raters for the training and all that, because it's actually cheaper to hire the raters when you factor in not only salary but also benefits packages and all that. This is the cheaper route. Number three is salaries. The increase is due to some staff members retiring, salary increases. For in-state travel airfare, that's going to increase. We're just estimating based on the legislative session coming up. Hopefully we'll be able to take the expenses down to a minimum, but we're anticipating worst case scenario. And that is pretty much that. Total cash did increase by the number you see there. That's it.
Do you know offhand how many employees are retiring?
Am I allowed to say that? I'm not sure if I'm...
Is that... I guess I should ask if that was a valid question I could ask.
I'm not... I mean, I don't know that anyone's put in their notice.
No one has put in the notice, and I don't... Because it would be a particular staff discussion. I don't think it would be appropriate at this time because it wasn't agendized, and the person who would be, any of the people we would discuss this about.
Oh, okay. All right. So never mind then.
My understanding, just based on the wording of the budget, there was a thought that there could be some folks wanting to retire or make some changes. So those costs are a little bit higher than normal just because you may need to hire someone to train, while someone else is on their way out. So I don't know that to my knowledge, there's nothing definite. It was just, this could happen, so we're going to be prepared for it.
And was there any comments from the public? Okay.
I have a comment
Mm-hmm.
on budget. I just have some questions. I'd like some clarification on the equipment rental. What is it that we're renting for this amount of money? There's not a line item here.
It's
Copier?
Yeah, the equipment repair and rental. We have copier rentals, and we also have the repair of any of the technologies we employ. So either desktops, screens, replacing keyboards and mice. We typically just put a budget item in for that. It's not an exact expense, but that's our estimate based on prior years.
Okay, and the exams were so much more this February than they were in January. And what was that due to?
The exams themselves are based strictly on when people show up. So we don't. It's really on when the graduating classes come to us. So
Okay.
that if you look at the state month by month, there might be some pretty wild fluctuations
Yeah.
based on the people when they're completing schooling. But the overall for the number of students that we're licensing has remained pretty consistent and on an upward trend.
That's good. There was a $6,000 difference almost, so I was just wondering about that. And then there was a couple. One, bear with me.
And you're looking at the actual monthly.
Yeah.
The monthlies. That's not part of the budget piece. The budget piece
Okay.
is for next year. Yes.
Sorry.
Oh, I'm sorry. I was just explaining the comments were being made about a monthly recap by our CPA. The CPA financials, and not about the budget. The CPA financials relate to previous months that we've already gone through.
Right.
All of the budget items and all the budget numbers are for fiscal year 2015, starting July 1.
So this is separate than the budget discussion.
Correct.
And Gary, also, doesn't the computer equipment software projection here also reflect what we approved before for the new implementations that we're going to be doing in the office?
It won't show the capital expenditure, but it does show any of the approved software. Like Andrew was saying, there's a difference between, at just a very high level, Versa we bought as a software package. We own the package. GL Solutions is a monthly fee. So instead of buying it at a large cost and depreciating it down, you can expense 100% of the software service. So it's an accounting differential, and that's why we wanted to explain a little bit about what was going on, because it does show to be a much larger number, but there is the writing off the last part of Versa and then moving to an expense schedule for GL Solutions.
I just wanted to make sure we had on record that was previously talked about and that we approved that.
Any further discussion? Any comments from the public at all? Monica, is there anybody stepping forward to want to talk to us?
Not at the moment, Neil.
Okay. Do I need to entertain a motion?
I make a motion to approve the budget.
Is there a second?
I'll second.
Having a motion and a second before the board, any further discussion from the board? Okay, I'll have that vote then. All those in favor say aye.
Aye.
Aye. Those opposed? That motion carries.
Thank you, Andrew. Great job.
Number 16 on the agenda, discussion for proposed changes to Nevada Revised Statutes, Chapter 644 of the Law Subcommittee.
Actually, 16 is the NIC annual conference proposal. 17 is the next.
That's not what mine says.
20 is that number. 16 is 20 on our, what we have.
Oh, yours looks different than mine.
Yeah.
My
This is mine. Yeah, I do too.
Okay, so if it's
Here, look at mine.
It's different on the paper.
okay, so number 16 would be the NIC 2016 annual conference proposal. Apparently, I have the wrong paper in front of me. The board will consider authorizing Executive Director Landry to submit proposal for hosting the NIC conference in 2016 in the state of Nevada.
This is similar to to what we did last time when we proposed to have Nevada host, and I shouldn't say host, put a proposal together to encourage NIC to attend their annual convention and annual conference within the state of Nevada. There's no money commitment. There's no there's time commitment on my part to put together a presentation, but this is similar to what we did before. We did hold a regional conference, an all regions conference that was pretty widely attended by people around the United States. This would be to hold the annual national conference, which has more participation, probably 225 to 275 people. This proposal, like I said, all I'm asking is to have permission to make a presentation to them. There's no other commitment beyond that.
Mr. Landry, are you excited about putting together a proposal?
I am, because I think I learned a lot my first presentation and the first time I attended the NIC National Conference, and understand what it takes to get a proposal pushed through. And so I'd be very excited to pitch this again and do it from a more economic standpoint, because there's a lot of economics factors that make Las Vegas a very not Las Vegas, but the state of Nevada, Reno, or Las Vegas, a very good place to hold a conference.
And do you feel that hosting the conference will propel the gold standard of Nevada to the other state boards in the nation?
I think any state that hosts the annual conference, it helps bring that state up as far as in the eyes of NIC. And for that same reason, I volunteered to chair the Standards and Best Practice Committee at NIC to do that same thing, to drive a national standard for all of the profession.
Is there an encouraging that the entire board attend the conference?
The attendance at any NIC meeting is really a personal decision, both on schedule, time, ability for the person to be there, and interest. And I wouldn't foster any personal opinions on that particular point.
I attended the last meeting with Mr. Landry, and it was a very exciting meeting. People were very excited to be here in Nevada. They, asked if any other board members were going to be there. They were very taken back with the presentation that Mr. Landry had made. His was definitely far and above the other presentations, albeit well executed by all. But I have to say, Mr. Landry's he had a standing ovation. He was well received. It was very exciting to see that kind of participation from everybody, because he really did reach out to people and ask them to participate in his, in his presentation. It was very interactive, and you didn't see that in a lot of other presentations, which was really refreshing. It was I met a lot of people. A lot of people had a great feedback, and they're looking forward to coming back to Nevada. They did express that they enjoyed their time here, not just because it was, Las Vegas, but actually because we really did show them a great experience and a great time here in Nevada to be able to host something like this, and they were really willing to come back. So it was very well received here, and at the last meeting it was enjoyable, and a lot of information was exchanged. I definitely felt more comfortable about what they do and how they influence us, and I definitely encouraged other board members to come. They were definitely asking, hey, where is everybody? So I just said, everybody, this is voluntary. Everybody has families and commitments and whatnot, and we hope to have them here next time. So
all right, so I'll make a motion that we allow Mr. Landry to do that, to propose to the NIC that we host the annual convention.
I'll second that.
Having a motion and a second before the board, is there any further discussion from the board members?
Well, Mr. President, in addition to making the proposal, I do agree that we should actually host the conference in the event the proposal is accepted.
Okay. All right. Having no further discussion, I'll take that vote. Then all those in favor, say aye. Aye. Those opposed? That motion carries. Carry forth, Mr. Landry. Carry forth. Okay. Let's see here. Make sure that we're on the right thing. Item number 17, discussion for proposed changes to the Nevada Revised Statutes, Chapter 644, the Law Subcommittee. Mr. Nixdorf. I think that's your wheelhouse, yes?
I do believe so. So over the last year or so, we've been meeting regularly to discuss changes to the NRSs in particular. And you have before you all the changes that we felt were appropriate and prudent to do. And I'm just looking for you to approve these changes so that we can propose them and see what the legislature does with our work.
And so just as a point of clarification, anything written in blue is a new added item and anything in red is struck?
That is correct.
Correct, okay.
I have a question of Mr. Nixdorf.
Ms. Booth?
When we had the meeting up in Las Vegas, several of the schools brought forward about changing the hours from 18 to 16, which everybody agreed to that. And there was some talk about changing the esthetician to 900 hours, which didn't leave a lot for the schools. Is the esthetician going forward?
There's nothing going forward that isn't in this document.
Okay. I just wanted to make it clear to everybody in Las Vegas that that part we did not carry forward, so that was their only real complaint.
That's it. The only thing we did was reduce the total number of hours.
Great. Thank you.
Has there been any kind of, I talk with the schools on how many hours it actually is broken down, because there's always like certain amount of hours for perm, certain amount of hours for this and that. And one of the challenges we had before was law review, and they were not passing the law. And so when we have this 1,800 hours, and now the students are just being trained how to pass the law, and now we're thinking about reducing those hours, I just can't buy that.
Part of the reason that we were reducing the hours is it makes it a little bit more compliant with all the other states, so that we have a bit of reciprocity with everyone, and that leads to a more cohesive national standard. And all of the items that you're discussing there would be NAC stuff. So if the legislature sees fit to agree with us that this be so, then we still have to go through and rewrite all those hours and all the requirements to conform to that. Now those would be written out in the NACs. And we'd be sure to make sure that they could pass the law exam for sure.
Yeah, I think there's several other points I want to make, but I'll come back.
Well, please. That's what we're here for.
Now would be the time.
Yeah, now's the time.
One suggestion I would make, just so that it might be easier for everyone to step through. There's a pretty large group of laws. Just a suggestion to step through and step through each one, see if there's comments from the public, comments from the board, and move them through. I would propose to you maybe easier to move them through one at a time than to do them all as a group. There may be too many changes.
Okay, we could totally do that.
Right, but so the subcommittee meetings were designed to streamline this so that when this comes before the board, we can then approve it and move it forward to the legislative session.
Correct.
Next year.
That was the idea of the committee. That way we didn't discuss it all and bring it all out here, because the concept of having a subcommittee is that all the work be done there and all the discussion be done there, and then it comes here for the final approval, and pretty much all the work is done on it.
My only comment
if
on
you'd
that.
like to discuss the hours, I'd be happy to do that. That's not a
The
problem.
only reason I brought the hours up, because that was one of the things that they brought to us last time when we were in Las Vegas. That seemed to be the major thing they were concerned about, mostly the schools. And I agreed with them on it. That's why I wanted to clarify that the esthetician hadn't been changed to 900, and that would be a total of 16, and it would stay the same way.
Correct. That was we had only. It was only the total number of hours of 1,600 that we were changing, if I remember right. Let me just double check where was that. Here we go.
My only concern, excuse me. My only concern on the going through them as a large group. I just want to be particularly cautious and careful that because I've been working with the legislators for quite a while now, I'm speaking with each one of the members of the Commerce and Labor Committee. I just want to make sure that the entire board, because not the entire board did not all sit for all these meetings, that they hear if there's any support and or objection to any of these, that they hear it as a board before they instruct me to either move forward with it with the legislature or not. I just want to be, I'm really cautious on that one particular point.
Well, and that's what I was going to say as well, because this agenda item is for public comment. And so I thought that Mr. Landry's suggestion was to kind of go through it in order. That way, if those in the public wanted to comment on any of the proposed changes in order, they could. And then also, it would also allow board members who weren't on the subcommittee, if they had questions or concerns, to do the same thing.
Yeah, but isn't the time when, so we streamlined this with the subcommittee meeting and then allowed that time for people to make comments then as well, too.
I know you did, but
So-
I mean, it's just
Entire board was
agendized.
on the committee.
Well, normally, and I don't believe, I mean, so all 7 of you were there, and so there was always a quorum of board members at every subcommittee meeting?
No.
There was always a quorum, but there was not every board
necessarily.
member
There wasn't
there.
always
Everybody
a quorum.
can be invited to the subcommittee meeting, but the subcommittee consists of the individuals that were appointed to the subcommittee.
Which
And
was
so-
everybody on the board.
Okay, so then it was a subcommittee of 7.
Yes.
Right.
And at one time or another, every board member has been to, I think, at least one subcommittee meeting or another. So,
Okay, my memory, we talked about this last time, and it was not
trying
7 people.
Yeah, I'm not trying to argue the point, but the whole purpose of streamlining this was so we could move it forward.
The way that subcommittees work, just so everyone's aware, the subcommittee does a lot of extensive work. They do a lot of extensive discussion, and they come back with recommendations for the full board. And the full board is to consider the recommendations. If the full board wants to talk about sections on here, that's appropriate. And I think what Mr. Landry is suggesting is to make sure that the public is able to have input to all of these sections. It's important that we at least offer that to them. I realize it won't be done maybe as quickly as we like, but I do think we have plenty of time to do that today so that they're all on board with the changes.
Of course, which is what we were going to do at the appropriate point.
So here's what I'm willing to do on this, and first we'll take off. I will go through and summarize the different sections that are that we covered. And if anybody would wish to discuss the details of those sections, let me know and we'll discuss those details. We'll start off with Koki's commentary on the, this would be involving NRS 644.200, cosmetologist qualifications for examination. The only change that was made was under Section 5A, training of at least 1,600 hours instead of 1,800 hours. That would be the only change to hours for qualifications of examination that we discussed.
Although I appreciate substandard and below our normal gold standard that we try to aim for, I think that this is a challenge for me unless I see the numbers of hours that are going to be dictated to those 1,600 hours, because that's a total of 5 weeks, which I thought Mr. Jimno had when he was sitting with us. The 5 weeks were dictated to, or dedicated, I should say, to law review. And I'm just concerned because I know that that's been a big challenge for most of these students is learning the law. And that's where they've been, falling short up until recently. So now that 5 weeks, I'd like to know where it's going to go. That's all I'm saying. Maybe the schools could address that.
Well, the comment that we had, this was originally brought to us by a school, and we gave them, we brought it up early in the meetings, and then there was lots of time that went by before we brought it up for discussion. And from the schools that were there, nobody seemed to believe that it would dramatically affect the outcome of the pass or fail rate. This was we discussed this one pretty extensively to see how it would affect that. So I don't know.
So you're saying there were schools present at the meeting?
Absolutely.
Huh. Okay. Yeah, they're there now, and there's nobody that's commenting. So.
If anybody from the school would like to step forward and make a comment now,
Yes, we have several.
Okay, we will remind you.
1 second, we're going to ask one at a time.
Yes, and we would remind you to try and keep the comments under 3 minutes if we could, please, per person, and state your first and last name and spell them for the record, please. Thank you.
Hello, once again, my name is Gail, Gail Moore, Moore, with Expertise Cosmetology. And at the last meeting, it was I that brought up the fact that we were going to lower our educational standards. Well, just in the past year and a half, we have raised the educational standards of our nail technicians and our estheticians. So if you add the 9 and the 6, we get 15. Now we're given an hour for hair. And the concept is right. The law is not as easy to learn as it was at one time because it has gotten more in depth about sanitation, disinfection. It's just gotten bigger as we've grown as a business and as a field. So has the rest of our training. Our books are twice the size they were. Every 2 years we get a new book. Every 2 years we have to learn how to do it again. So lowering the hours was not brought up by any of the schools in the South. And I know it was brought up by somebody in the North because they're going across the border to get their license. You know, it just doesn't make sense why one person should have the say of the rest of the schools, because we don't agree with lowering our standards when we've raised the rest of them.
Thank you.
Hi, my name is Christina Bair. My last name is Bair. I'm a student at the Aveda Institute. I just wanted to say that the estheticians are already at 900 hours. That hasn't been lowered at all, and I don't think that was up for discussion. But I know there are people at the school that had actually graduated a few years ago that had gone for less hours, and they were actually jealous that we had so many hours because they felt that they were filled in. So I think that lowering the hours is probably not a good concept because there is, like with the law and everything, there's a lot that you have to remember. And I know as an esthetician, nervous, sorry. I know as an esthetician, with the laws and everything, it is a little more complicated because I know a lot of the questions are based off of like a cosmetologist's perspective. So there's not a whole lot that pertains to aesthetics when it comes to our testing. There's a lot of like, I'm trying to think of how to word it. There's like a big broad spectrum that goes on. And so like the law is probably like the biggest concern. And I think if anything that there should be more hours put towards learning the law as opposed to reducing hours in general. And that's it.
Thank you very much.
John, last name Davis. Due to the fact that I come from a state and most of our neighboring states, we have hours that range around 1,500 to 1,600 hours. When you were speaking about learning Nevada law, excuse me, let me take a breath here. The same people who are taking those same tests throughout the whole nation, with that 5 weeks of time, I think that more has to be done with the educators on teaching Nevada law, because you must have and pass Indiana law, Illinois law, Ohio law, and anyone else who has those same amount of hours. So I think that it would be a good thing to bring the hours down to a standard that most of us have at about 15 or 16. You know what? You can disagree with me. That's what America's built on. See, so you should be up here speaking to the board themselves also. You have a public time.
Thank you, sir.
Good afternoon. John Greco, Academy of Hair Design. John, last name Grieco. I would like to just comment on the 1,800 hours. We believe here in the state of Nevada, we put out a good product with our students, but dropping in another 200 hours would really challenge the students to not only accomplish this quicker, but I think it would be more detrimental to the finished product. We pride ourselves on graduating a quality student. Less hours would make it that much tougher. I'm leaving it right now myself. My daughter is at about 1,700 hours, and she's about to graduate in about another 100 hours at the end of this month. And right now, she's just hitting her stride, getting the speed and getting the experience to become an accomplished cosmetologist. 100 hours ago, I don't think she was ready for the field. Just this past Saturday, she had 5 clients in one day. She's getting her speed and her confidence, and she's good. She's above average, 95-plus student in her grades and her attendance. Our feeling is that with the advancement of the hours the last couple years with manicuring and also aesthetics, we'd have to bring that back down to accomplish and balance this. Our hair design is at 1,200 hours. I just think we're just doing our state and our schools a disservice. I'm looking at also at this particular book this morning, and I was looking at our graduation rates and pass-fail rates as far as the board is concerned. We're at about 40% failure as of right now at 1,800 hours. So I think we're just dumbing ourselves down. Let's not worry about what the rest of the country is doing. Let's just worry about ourselves and putting out a good product. Let the government decide. If the government decides to eventually make it at 1,600 hours, then fine, we comply. But right now, let's just continue doing what we do best and educate our students. It's about education. It's not about speed to market. The other thing too is, if they fail and they don't become a licensed professional, they're still stuck with those loans. In addition to that, the more they know, the more they're going to make. The more they're going to make, they're going to be able to repay their loans. That's my feeling. Thank you very much for your time.
Thank you, sir.
Benita Williams. I'm WILLIAMS. I'm with Euphoria Institute. I come from a state of 1550 hours, so I think there's a confusion between quality and quantity, and I think that you can get both. As far as hours are concerned, I don't think that I'm any less qualified because I only had to acquire 1,550 hours versus 1,800 hours. I think it's the quality of the education that is delivered, and when it's delivered the way it's supposed to be, then I think that you're going to get, your pass rates are going to be better. So, if they're not passing at 1,800 hours, you're probably going to have a problem at 1,500 hours. So again, it goes back to the quality of the education and the time spent, and maybe looking towards the educator to make sure that those laws and rules are delivered effectively, and testing our students to make sure that our students are getting what they need as far as pass rate. And I have to say this, Euphorias are not at 40% pass rate. We're much higher than that. And I think, again, it speaks to the quality of the education that we deliver. Thank you.
Thank you.
Hello, my name is Sakina Abdul Halim. I hope you're ready. ABDUL apostrophe H or hyphen, sorry, HALIM. I am a student at Aveda Institute. I am in the SDology program. The 900 hours is extremely crucial because I am from Washington State. I believe their required hours are 500. I went in on a personal experience. I went in to get a waxing service. Not only did that young woman not know what she was doing, but she was fresh out of school, so I had more confidence in her abilities. I realize now that that extra 400 hours that we get over other states gives us a competitive edge, so that should make Las Vegas and the city of Las Vegas very proud, because we can work pretty much anywhere and it doesn't limit us as to where we want to go. Most estheticians would like to have that freedom. I think this is a great state. That's why I decided to go to school here, because of the hours I could receive. Also with the testing, just bringing up again with state boards and everything, most things in there do not comply with what aesthetics are taught. So when we learn the laws, it's kind of harder for us because the hairstylists get that background of why they need to do the law the certain way, and we as estheticians do not. So it's kind of like going into something blindly and just being like, okay, test on it. It's kind of hard. So maybe if the board decided to break the tests up, maybe make different books for each person or chapters, so that way if they are the same laws, we know what laws comply to us, so then maybe there's a higher pass rate. I guess that's pretty much all I have to say, but I really don't want you guys to move the 900 hours. I think that's so needed. It's so necessary. We are dealing with skin. We're dealing with bodily fluids. We need to have as much protection for ourselves and for our guests. So thank you so much.
Thank you. Okay, having no further comment from the public, we'll move on to the next part of this agenda item. Mr. Nixdorf.
Okay. Is there any discussion to make changes from the board?
Perry, when we had the meeting in Las Vegas, everybody was for the 1,600 hours. I mean,
there's always some. I mean, everyone has their opinions based on their own personal
Well,
experiences.
this is just what I wanted to ask the board, because I think everything else, everybody really agrees with. This was the one point that people have some issues with, is maybe making just the hours agenda item in August, just to discuss that portion of it. So anybody that wanted to come in and talk about the hours change could.
The other thing I'd like to remind you is that this is not the last time it's going to be discussed. There's plenty of time to discuss this in front of the legislature. We're only making recommendations, and the legislature does what it will eventually do. And by no means, by us passing this, does it make it law. There's lots and lots of discussion that's going to happen.
Okay, I'm good with that.
The only thing I would add too is, and Mr. Landry may know the exact date. I believe the date to submit a bill draft request to the governor's office is rapidly approaching.
Right.
And so if you're going to submit it that way, we don't have, I don't think, until August. However, if a legislator is going to carry it, you will have maybe a little bit more time. But even then, I know they start submitting their requests in the summer.
Right. That's why this is at this meeting. We did all these meetings all of last year, and now's the time to have either approve this to move forward, or we discuss it and make a few changes and then move it forward. And that's what we're here for. And if you just approve this as a packet and say it's all good. Like I said, it's not going to be the last time it gets discussed, and we fully believe that some of the items in here the legislature won't agree with, or maybe they will. Maybe they'll make other changes. There's lots of public discussion going to be happening on all of these items in very great detail once it gets to the legislature. This is nothing more than a recommendation on our part that the legislature look at these things. And they may look at this and say, we're not ready to do this because we have other importances, and they may never look at any of this stuff.
Thank you, Perry.
And one of the things I do want to make mention is that, I have been working very closely with the Commerce and Labor Committee members in both the Senate and the Assembly side. And Perry's exactly right. The steps that we have to go through, the things that we need to do, there's a lot of change that will occur from now until the time it becomes law. The one thing I will say is, if I do get pushback, if I do get some changes that are recommended, that either a legislative sponsor or the governor's office speaks with me about, I would definitely bring that back up to the board for reconsideration, so that you will be kept in the loop about what changes are going on. And if it occurs in between board meetings, then part of my weekly report will be to keep everyone up to date, because this is a very tricky process. There's, it's when you go through the process, start to finish, you really respect the amount of effort that has to go into it to get anything passed. So that would be my only recommendation, is that we will, no matter what you approve today, I will keep you informed on changes that occur from the legislators.
Mr. Landry, we've spoken several times about transitioning the infection control into infection prevention terminology. And so I'm noticing, as I'm going through some of the proposed law changes, that the infection prevention isn't necessarily the dialogue that's being used. And so is it appropriate then to introduce that at this stage, so as this document moves itself forward, that the infection prevention, the terminology of infection prevention is starting to be used?
Any board member can propose any change that garners 4 votes.
Yes, is the answer to your question. If you want to change the wording, now would be the time, because we want to have everything all together so that when it goes before the LCB, it's ready to go. The last time we tried to submit some law, it was not finalized, let's just say. So yeah, if you want to change the wording, I think now would be the time.
So just as a matter of formality for the folks in Las Vegas, there is a movement towards the use of infection control as a replacement for sanitization and sterilization. And in the state of Nevada, we have noticed that the terminology infection prevention is actually moving in the direction of new terminology for infection control. So as part of the proposed changes to the NRS Chapter 644, I would like the Law Review Committee to begin taking a look at looking at the proposed changes of infection control to infection prevention or infection control and prevention.
Thank you. I think you make a good point on that, and part of the reason that we had all these discussions is to try to incorporate all of those things. We are not going to be meeting for quite some time because these changes are rather comprehensive, and if we were to make that change, we could probably discuss it now, I think. I don't know if we can or not because we wouldn't have noticed and properly agendized. We want to talk about changing the terminology and replacing sanitizing or words that refer to sanitation with infection control. Right?
It's actually taking your infection control terminology and moving it forward into infection prevention.
Yes.
Prevention, okay.
Where you just change the word control to prevention. And I think we don't want to say we're trying to control infections. I want to think we're trying to prevent it. It sounds to me like you're behind the 8 ball when you say control.
Right.
So if we just took that word and changed it wherever there was control to prevention, I think that would work.
Yeah, I like the idea of discussing this, Mr. Leader. However, I'm not sure as far as discussing it without an agendize. Can you?
Well, right now what your agenda says is that you're going to discuss proposed changes to Nevada Revised Statutes, Chapter 644 from the Law Subcommittee. So it sounds like this isn't something that the Law Subcommittee has discussed.
That is correct.
But I mean, if this is an updating in the language, I don't know. It's not really something you can take action on today, but it could be something that we could discuss on May 19th.
Yeah.
I mean, because normally, if it hasn't already been discussed, we don't want to add it now, and it's not on the agenda. So I'm thinking May 19th would be the best bet.
I think that would be good because that'll give us a chance to go through and look at exactly where each of those items are and give us an exact discussion. I think that would be good. So we'll put this on the May 19th.
Yes, but I have a question. If we do not address this issue today with regards to moving it forward to going to the legislature, do we put ourselves behind and thereby have to hold on to it until 2017?
I don't think that would matter on this particular case. I'll bet that the legislature, that we could slip this in because it's not a change in intent or a change in anything except terminology. And I don't think that would be an issue to bring it in behind, or in late, I should say.
Right, but we're also proposing other changes as well, too.
Right,
so.
and those are all here, you see. And so if we just come in and say, oh, by the way, we wanted to make some changes in terminology, I don't see how that'll be a problem, but I don't know. I can't second guess what the legislature will do. But I think that it would be a mistake on our part to discuss it now, and we would have to discuss it at the next meeting.
My suggestion, it is agendized today for discussing the changes that have gone through the Law Subcommittee. So today you could take action on any of those. The new topic, the infection prevention topic, I agree with Mr. Nixdorf because it was not agendized on any of the Law Subcommittees and because we've not discussed it and it's not listed on today's agenda, I would definitely put it off, that particular topic, until the May 19th, and I will get some feedback from our lobbyist on what that means, just so you know, as going through with the legislators, anytime you open up any section of the law that we propose and we get a legislator that opens it up, that doesn't necessarily mean it goes through the way that we want it to or that sponsor wants it to. Things happen in committee, things change around. So every piece that you open up, you're exposing that piece of the code to be changed by some legislator in whatever direction. Just as a caution, I've been cautioned by Ms. Bells on that particular topic that, when you open up a section of the code, you need to be very, very cautious, because I would say infection control hits many, many areas, and those will all be up for discussion amongst the legislative committee.
And I would say I think this is a pretty extensive list already. And my thought is, whenever you're submitting a bill to amend your chapter, they're already going to be looking at the chapter. So, I guess my thought is I don't like to be worried, and maybe I'm just naive and hopeful, but I like to think we need to do the right thing and have the law read the way it should. And if the legislators have some different ideas, then that's their prerogative and why they're elected to those jobs. But I guess my thought is I would advise you as your attorney, let's do the right thing. And if we think that needs to be changed and updated, then let's do it. Even if maybe they'll scrutinize other sections harder, maybe that's going to end up being good. I don't know. I like to be positive about it and not be afraid.
Okay, so then I'll entertain a motion with regards to shelving this agenda item for
No. We're going to
not
go
shelving.
Through,
I'm sorry, that's
we're
wrong.
We're just going to add the infection prevention to next meeting as an agenda item and discuss that, and that'll give us a chance to go through the law book and find each individual reference for that to make that change and bring that.
Also, if I could mention and this goes along the line of what we're saying, at the NIC meeting, they did ask us to try to look at any vernacular changes, any terminology changes to coincide with the most popular, books and textbooks and states that had their similar vernaculars. That not only makes it easier to have that concurrent vernacular with reciprocity and lawmaking, but also Milady, one of the biggest textbook companies around right now that is pretty much the standard for most schools, has stepped up and have engaged themselves and offered assistance in looking at what the terminology that they're using as kind of a baseline for across many states that many states are using. So if we could kind of maybe take a look at the other states and what they're using and change our vernacular and use something similar, if not equivalent, not only is that going to help with lawmaking, it will also help with education and easier reciprocity for people who want to cross those state boundaries.
Okay.
So just quickly, Mr. Landry, I had mentioned then that I would prepare you a position paper for the purpose of how to effectively use infection prevention.
Okay.
And so I'll prepare
that
for that 19th, the board meeting, or for the law review meeting on the
that'll
May
be a board meeting.
The full board meeting on May 19th.
Oh, okay. Thank you.
And if I could, if it's appropriate, I have a couple just questions or thoughts as I read through some of these changes. So just one thing to make sure the whole board is aware, because I don't know how much you all know. Some of these have proposed numbers, and they may not be that, just so you know.
We're aware of that.
Okay, because I think it's written well and great. I just want to make sure everyone knows that those numbers, LCB is going to codify it how they codify it. And so those numbers may change. And I noticed there's a few spots where those numbers are referred to in other places, which again is great, but it may change.
What numbers are you referring to?
For example, on page 2, NRS 644.0241, and it defines cosmetology apprentice, and it's an added provision. That one is going to get its own number when they codify. It may be that. I'm not saying it won't. I just want you all to know that a change like that might change based on the codification. The other thought I had is if we go to page 1 of 1, it looks like it's I'm at agenda item 17-03, places of business, NRS 644.130. And the only reason I bring this up is I noticed in another spot we wanted to ask for email addresses, and I didn't know if you wanted to add that to 130, because right now, technically the way it's written, all they have to give you is their name, places of business, date, number of license, etc. It's implied in number 2, they've also given you your home address and telephone number, but it's actually never explicitly required, which I think is interesting. So we may want to add that to number 1, that they have to give you a telephone number and their home address. And then in number 2, we're saying we're going to keep that confidential. And then I just didn't know if getting email address is something we want to do going forward. Maybe it is. And so this would be a wonderful place to add that, perhaps. I saw that mentioned, I think, on the threading establishment registration. It said email address.
It was on the threading license or the registrant.
Yeah. And so that's just something I noted here, maybe to add. Another thing is if I go to the next page on mine, which is 17-04, approving of the devices, the banning of a device. The only thought I have, and the legislators may have a similar thought, how do we know when something's banned, what's the procedure? So it might be nice to add a sentence at the end of this that says something to the effect that the board will establish regulations regarding the process to ban a device. That way, eventually the public will know very clearly, what steps we're going to take, how they can find out what the list is. Because if we're saying they can't have them in there and they can get disciplined for that, which I think we want to say eventually, which is good, it's helpful for them to know, of course, what's banned and what's the process and how they'll know.
I was under the impression that something like that would be handled under NAC.
It would, but I think normally you can only make regulations in the areas the legislature's told you. So my suggestion would be at the end of that provision, just say the board will adopt regulations regarding the process to ban a device under this section. That way it's very clear that you have the authority to make regulations on that process, and then we can go ahead and do that so it's very clear to the public. If we go to 17-11, it's license renewal. Number 3, I think, says department, and it probably should say board in 2 places. So I just thought I would bring that up. It's, again, a minor change, and they would find it, I'm sure. But and then that's all I have. So thank you.
Not bad for all this stuff that we did. That you only have that.
Yeah, not much at all.
Any further discussion on the agenda item for the board?
Right, so yeah, let's go. I'll go through this really quick for the benefit of. So if I can keep all this stuff in order here, for the benefit of the people that are here as well. Okay, so we're going to go with agenda item 1701. What we were trying to do here is to create regulations that allowed apprenticeships to be more than just cosmetologist apprentice. So we created apprenticeships for estheticians and hair designer and all the other items that that are not cosmetology, so that everyone has an ability to go through an apprenticeship. We did not change the way the apprenticeship worked. All the hours that we put in for the apprenticeships, for all the various subcategories, were all based on current hours that were doubled, so that nothing has changed in that respect. It's merely a way to allow apprenticeships to be done by all branches of cosmetology independently of the cosmetology field. All right, then let's see here. Get that out of the way. So that was 1701. So we have hair designer, we have nail technologist, and all the wording that goes with that. Then we have, we changed a bit of the wording for cosmetologist to cosmetology professional. And instead of, we'd have, instead of cosmetologists, it was we just changed some wording in there to make that clearer. All right, so then we have 1702. This was kind of administrative. We no longer have a secretary. So it says notice to board of change of location versus secretary. And then on 1703, the board shall keep a record containing the name of known places of business, because we now have duplicate licenses that can be issued. So we needed a place to put the duplicate license business names.
Could I ask a quick question about 17-02, the change of location? I did have a note here, and perhaps it's addressed elsewhere. A home address, because here we're saying they have 30 days to let you know about their place of business change. And I think if we look at NRS 644-130, it's implied that they give you a home address, but actually not required. And my thought is, just so when I'm noticing folks for hearings, not businesses, especially like the private individuals, should we also have a provision that requires them to notify the board of a home address change? And I'm not sure, let me double check here, but I don't know that we have it right after this. So maybe we should say every license, change of her place of business or home address as designated in the board records, if we don't have that elsewhere. Because I know 130 implies it, but I don't think it says there's an update required.
I agree with that. I mean, we had that just today. Somebody's mail went to their closed salon, and, she put down as her, address to contact her. It would also be kind of nice, because a lot of people are students and living, in apartment situations and whatnot, to have, even just a permanent address like somebody's parents' house or a home that they own, regardless, that may stand as a backup address. Emails aren't always completely.
Yeah, because usually for most professional licenses, they have to tell you where they're working and where they live. And then they usually designate the place they want notices sent to, if that's an option. And I'm just thinking, most of the time, probably, for example, a nail technologist working at an establishment isn't going to have their personal mail go to the salon, but the owner might. And so I guess it would depend on who you are. And so I just thought, as I was looking at it, I noted down, is there a window to let you know about a new home address?
Well,
I think I don't think it's ever any harm having more than one address down to be able to contact people, especially when in the case of a violation or we're trying to get information to a licensee or establishment owner.
So, Sarah, how was it that you would add?
Perhaps we can add where it says, right now it says notify the board of the new place of business. We could just say within 30 days after changing his or her place of business or residence or home residence as designated in the records of the board, notify the board of the new place of business or home residence.
So add the words or home residence behind business?
Yeah, twice.
Twice.
Yeah, that's my thought. That way it's clear that they have 30 days to let you know about a new home address and a new business address. I think a P.O. box is fine. We just,
that's
thought
just
is
an alternate address.
Yeah, my thought is I don't know that we have to specify that, but my thought, so maybe we shouldn't say home, but personal mailing address maybe? Yeah, because that's all we want. We just want to be able to make sure that if we need to have a hearing or, they're doing a citation appeal, whatever it is, we have a good address for them and they have an obligation to give us that good address. So let's say after business, say, or personal mailing address. And so each time, if they change one or the other, they have to let you know.
Okay, so can I get a motion for this?
I'd love to entertain a motion.
Mr. President, I will make a motion to adopt the change to NRS 644.300 to include personal mailing address.
Is there a second?
I'll second.
Any further discussion? I'll have that vote then. All those in favor say aye.
Aye.
Aye. Those opposed? That motion carries.
Okay, so on 1703 places. Okay, 1704 approval of devices. You wanted to add some terminology that... allows us to make
Mr. President, I'd like to make a motion to include in NRS 644.095 that the board reserves the right to devise a policy that enables them to determine whether a ban to a device used in cosmetology should be necessary.
Is there a second?
I'll second.
I think it should be more specific to regulations.
Definitely.
So the board, I think it should say the board shall adopt regulations regarding the process to ban a device. I think that's what the legislature would want to see, is my thought. But
yeah, I think so too.
So, Mr. President, I'll amend my motion to include the recommended verbiage from Ms. Bradley.
And does the second reflect that as well?
Yes.
Thank you. Any further discussion? I'll call for that vote now. All those in favor say aye.
Aye.
Aye. Those opposed? That motion carries.
And if we're going to go through the changes that I had and or the public one by one, could we go back to 1703? Did the board want to add the email address and also in number 1 a requirement that the home address and telephone number be provided? Because right now, like I said, it's actually just implied that you have a home address and telephone number, but it's never specifically required. In number 1, it's a little bit strange. And then there's no mention, of course, of email addresses because this was added in 1933. Looks like.
I'll make a motion to add the email address to I think it's the NRS 644.130, agenda item 1703 for place of business. To add email address in addition to.
Where would you add that at? Let's see here.
We would add it at, it would come at the end. It would say, number 2, it would be 644.130. 2, the board may disclose information contained in the record pursuant to subsection 1 to any licensing board or agency that is investigating a licensee there at the end.
No, it would be a number 1. So the board shall keep a record containing the name, known places of business, and then how about after that, email address, telephone number, and personal mailing address.
That's good.
And then in number 2B, we would say, except information concerning the home and work address and telephone number and email address, because I think the email address should be confidential, my thought is, unless they want you to give it out. And I know there's other provisions that say that in the NRS, that emails are confidential.
Okay. So I amend my motion to the suggested verbiage that Ms. Bradley has given us.
I'll second that.
Okay, in a second. Any further discussion? All right, I'll call for that vote now. All those in favor say aye.
Aye.
Those opposed? That motion carries.
Okay. 1705, deposit of fees. Again, we no longer have a treasurer, so we scratch treasurer and put the word board in there. Agenda item number 1706. This is in an effort to prevent some unregulated practice of cosmetology by advertising in Craigslist and so on and so forth. So this is regulations designed to be able for us to control that by defining advertising and such. And this is what the biggest change here is that it's going to require anybody who advertises to put their license number on all their advertisements.
I think that's a good tie into the proposed item that we're going to be able to do weddings.
Correct.
And this and that.
That's what this was intended to curb.
Yeah, I think I was there with that.
Yeah.
Mr. Chair, were you expecting business cards and service menus to be forms of advertising?
Yes, absolutely.
Yes. Is that clearly stated in those proposed changes?
It talks about advertising means any written, electronic, or graphic representation designed to elicit enrollment or the sale of goods or services, and includes signs, displays, circulars, brochures, recruitment materials, and any other form of online television or radio presentations. It doesn't specifically say business cards.
I know that normally in other areas that I work in, it is considered an advertisement, but perhaps you can add business cards. Would that make it clearer?
I'm more interested in the service menus. than I am in the business cards being specifically mentioned.
And also maybe social media would be a very...
Yeah. To me, the brochures would cover the service menus. So in my thought process, it doesn't say anything about a person's Facebook page, for instance, specifically, except that it's electronic or graphic representation.
I think social media would be a very fashion forward, if you will, move on this part, because there's never been really a mention of that in here.
Yeah.
I think social media is only going to keep expanding, and to exclude that when we can easily include it sure wouldn't hurt.
But it's not excluded in that it means it's written or electronic, which would totally encompass that. So anytime you're advertising electronically.
And I would add the intent, from what Mr. Nixdorf is saying, the intent is the reason why we put any form of online television or radio presentation, as well as all the other provisions. Mm-hmm. We tried to make as big a blanket as we could. We're going to cut our regulations that would come after this law is put in place would speak to the specifics of. We'd probably list everything you could possibly think of in the regulations. But our intent is that any way that a professional is trying to solicit or offer services for anything within this profession, you'd tie a business license, not a business license, a board license to, so that we could make sure that, just as Ms. Benaldi has said, when we start having wedding services, if this all passes through the legislature and through this board, that you'd be making sure that licensed professionals are performing those services and not unlicensed activities.
Perhaps, though, Mr. Leader, if you don't think it's clear enough, maybe service menus is something that should be added. I would think it was a brochure, but I don't know. I'm not in the field. And business cards is not specifically included, although I think it's, I think it's advertising. It's a written representation designed to elicit enrollment. But, if members of the board think it should be more clear, perhaps service menus and business cards could be added after brochures, for example.
I actually think it's clear, but of course I served on the committees.
Yeah, you could get really carried away and start listing every single item here that you could possibly think of, and I don't think that's the intent of the law. And I think if it needs to be somewhat broad, and then we'll specify it in NAC. And I think it's very clear as far as the intent of this is.
Well, normally, it's just normally if you're going to define it in the NRS, you don't also define it in the NAC. Normally, the NAC is providing clarification on the NRS. So I'm not sure how it would look to specify further in the NAC, given that you have a definition. Right. You could say not limited to, or something includes but is not limited to signs, displays. That way it's a little broader. I'm mostly just thinking if we have unlicensed or improper advertising, how am I going to argue it before the board and or a court if it should get there? So maybe it should say includes but is not limited to signs, displays, circulars, brochures, recruitment materials. That way it's clear that we don't mean only the things listed, but it would need to be like those things.
I am inclined to agree with Ms. Bradley, and then that way, as things manifest themselves that may not be on this list, they could still be included in the general intent of the law review committee.
I think so. I agree as well. So where would we add that to under advertising means instead? So advertising includes.
I'd say where it says I thought and includes but is not limited to would be perfect. So in that third line there, and includes but is not limited to signs, displays, circulars, brochures. That way we're giving our list, but we're saying it doesn't include everything under the sun in our list.
Okay, let's do that.
Okay, so is there a motion?
Mr. President, I'd make a motion that we adopt the phrase "but not limited to" into the proposed changes to NRS 644.0203 advertising.
Is there a second?
I'll second.
Having a motion and a second before the board, is there any further discussion?
And then, Mr. President, I still am a little, as I think about it, I still would like to include service menus also, because really that is the way that we show the list of services that we're offering. And so in aesthetics particularly, the service menu would be a clear indicator if they were trying to peel the skin. We would see that on the service menu. It would. I am inclined to say that most of our licensed establishments operate off of a service menu, and I still would think that that would be a key phrase to include in that list.
Where would you propose to add that?
It's irrelevant. I mean, where, just somewhere within that list of 5.
After recruitment materials, service menus, and any form.
I tend to think that that'd be the most, the best. That would be the best placement.
Okay, so does the motion and the second reflect those?
I made that motion, so yes, it would reflect.
And the second?
I make that a motion too, or no.
You're amending your motion to, yes, thank you. Any further discussion? All right, I'll have that vote then. All those in favor say aye.
Aye.
Aye. Those opposed? That motion carries. Is there another section, Perry?
Yeah, we're working through it. We 1707, we discussed barbering. We want to open this up for the legislature to take a look at, and there's some reciprocity, you might say, going on in here where we clarified, because a lot of people are not very clear on what a barber can and can't do. So anyway, so we made some changes there to make it clearer, because some of the things we did is we took some of their language out of their book and added it to our language so that it's clear on both sides, because in order for you to read the law and understand what was in the barbering laws, we referred to the barbering laws in our book, and yet we didn't put a definition for it or show what that was. So you literally had to come out of our book and go get their book to read what it was that they were talking about. And so this was more or less a clarification, so that all of the information was in our book. So that's what this was all about.
And I understand the concern there, but I would just add, and this is just something to think about, the legislature generally prefers to refer to an NRS section by NRS section, because if that section's amended, that way this automatically is updated. Does that make sense? So right now it says any person that engages in a practice that violates NRS 643-190, they don't have to come to your chapter and amend it. They can just amend it all there. So that's the only thing I would offer. That's why it's like that. I understand it's a pain to look in 2 places. But it's just so that if that one's updated, yours is also updated.
Sure.
So I'm not sure, maybe what's new here, but it might be maybe if it comes down to it, if the legislators are asking, it could be a good idea for us to know what specific new things you're adding, because I think they'd be more inclined to leave the reference as it is and just add the new things that you want to add. Does that make sense?
Sure. The way I see it, we need to give them something to cut to. The other thing that is new, the applicant is a barber registered. What we did is a cosmetologist qualifications for exam. We upped the number of hours that a barber must spend for training, because it said if the applicant is a barber registered pursuant to 643 of NRS, they needed 400 hours, and we gave it 600 hours. And that was the only change there.
And the other change, just to remind you, Mr. Nixdorf, the other change was if a barber was applying for a hair designer license, they would not require any additional hours.
Correct.
Instead of the hours that are required now. And I would just ask the board president, to ask for public comment on this one in particular, because we did receive quite a bit of public comment at the last law subcommittee meeting.
Yes, we did. I can't. Where did we put that under?
It's at the very end under C, at the very last page, page 3 of 3.
Where?
Is a barber registered pursuant to 643 of NRS, and it wiped out 400 hours and specialized training approved.
Yes, got it. Yes, that is correct. I remember now.
And also, Mr. Nick Storff, if you want to consider under 5A, you'd want to make that adjustment to be consistent with 1,600 hours if you're going to change the hours. Is that correct? Training of at least 1,600 hours instead of 18? Is that correct?
Yes. Okay. Wait. I'm
Tell me again why we're changing the hours to be less.
It's just being Mr. President, it's just being consistent.
Yes.
It's so the NRS 644.200, item number 5, it's already been noted. It's just not re-noted on this.
Right. See, we left this one alone. If I remember right, we were talking about this a little bit. We left this alone because we don't have a that 1,600 hours has not been approved. And if we make this change here, we're making the assumption they're going to approve that. And I believe that once if the 1,600 hours is approved, that they would go through and take and change any of the references within the law to that 1,600 hours. And I didn't want to be presumptuous on this and put that in there. That's why that isn't changed in that particular space.
Oh, okay.
Change it in one place and not the,
But we're changing it in the place where it means something.
Right. It hasn't been changed into law yet, so it's under the discussion on the premise that if it changes, then those will change as well, correct?
Right.
Okay.
And they can do that?
Yes.
They would actually be required to do that if a law goes through in one section. Part of LCB's staff job is to make sure that anywhere where that's referenced in any way, that there's consistency throughout the law. And that's why it's an even bigger job than, when we present something that appears very small, they're checking through the entire law to make sure there's no conflict.
And so to speak to what Mr. Landry said before, is there anybody down in Vegas that has any comment from the public that they'd like to step forward and make? Keeping in mind, again, that we're going to try and keep it to a 3-minute interval, and then your first and last name spoken and spelled. If you'd like to step forward, now's the time.
Hi, Mark DiCola from Euphoria Institute, DE, capital COLA. In referencing the barber sitting and testing for a hair designer's license without the need for any additional hours, I sat at the law review subcommittee meeting, and I think there's some people that are going to come behind me to speak to this, but I go to a barber shop to get my hair cut actually every 2 weeks, and I've had dialogue with my barber about like what they've learned in school, and to say that what a barber learns in school is in a direct translation into what they could do as a hair designer is completely wrong. Just because they sat for 1,200 hours or however many hours they got, they didn't learn things that a hair designer needs to know. So I completely disagree with a barber being able to test as a hair designer without the need for any additional hours in cosmetology.
Thank you.
Thank you.
Anybody else?
Good afternoon. John, last name Davis. Possessing 4 licenses in the state of Indiana and at the present moment 3 in Nevada. That includes barber instructor, Cosmo instructor, cosmetologist, and barbering. Yes, there are going to be some things that the barbers do not learn in detail, such as what a Cosmo would learn. What would happen is that the barbers do not do all of the same. They do not take all of the same type of classes that one another has. So what happens in the state is if you're going to go in and have a barber, a registered barber in Nevada, have to go back to school to get more hours to be a cosmetologist here, then what you need to do is the same thing with a hair designer. They don't do the hot work that we do. They don't do all of the chemicals. It seems as if some people up there have hair coloring. The most hair coloring that a barber usually does is applying a temporary rinse or using sprays. Whereas sometimes when you're working with highlight, high lift, those things are very, very intricate. So I believe that both the barber going to get a hair designer's license or a Cosmo license needs to be cross-trained in the areas that they did not have. Thank you.
Thank you, sir. Any further comments from the public?
Mr. President, perhaps those two commentators could offer a solution to the number of hours. The hours were 400, and both of those commentators suggested that there still be hours. Did they offer a solution? Perhaps 200, 100?
John Davis again. Excuse me. I was working on the crossovering in Indiana. What we were doing was basically between the two books, there are about 5 chapters that are not taught either from the Cosmos aspect or the barbering aspect. They would have to have at least, if I was going to be doing hair designing, because we did not have it in Indiana, we only had a basic Cosmo license. If we were going to do it, I think that a barber should have to go back to school for at least 300 to 400 hours to learn the applications of all tints and toners, the chemicals behind them, the texturizing services, the chemical draping, and how to use marcelling irons. It is not an easy thing to go from a clip curling iron. It is not an easy thing to go from one type of a curling iron to using hot works, where you have to be able to go in and be able to temper an iron, test an iron, and applying it to someone's hair. So what we did was we had about a 400-hour program that was implemented in Indiana. Well, they were looking into it for crossovers.
Mr. Leader, does that answer your question or statement?
It does answer it. Basically, there's a recommendation that the hours not be changed. So
sounds like it, yes.
I'm sorry, that the hours not be changed? I didn't understand you.
Based on the comment that you've made,
yes,
that would not change the law. The law would stay the same for the barber to transition to a hair designer.
So, can I clarify here real quick?
That's for cosmetology,
Yeah.
but that's not for hair designing.
Let me.
Correct.
I'd like to clarify this a little bit because it's been a little while since I wrap my head around this. If you go back under 644-200, it says cosmetologist qualifications for examination. And what we had here is a situation where we had the applicant as a barber registered pursuant to NRS for 400 hours of specialized training, and that gave them the complete cosmetology qualification. But then we also had the same number of hours just to become a hair designer. And the intent here was to reduce the number for the hair designer and give you 600 hours of specialized training to be the full cosmetologist. Because we didn't feel at the time that we should have the same number of hours required for the full cosmetology, which would also include the esthetician and nails and so forth. And that's where this sort of came from. Is it just was there was a discrepancy where we were requiring the same number of hours for that. Now we did up the number of hours for the cosmetology, and at the time we felt that the license could go to hair designer because we felt that barbers, for the most part, they were going to come into a salon and they were going to do barbering inside of a salon, because right now we have special regulations that keep them from working inside of a salon, and we wanted to give a broader employment opportunity for barbers who could then work in more places. That was where the intent of this was. So I'm not necessarily opposed to adding more hours in here, but it's got to be in respect to the fact that we also have the 600 hours for the cosmetologists and not just for the hair designer.
Anyway, that's the background on that.
Okay. Any further comments?
Once again, Gail Moore, M-O-O-R-E, with Expertise Cosmetology. I have actually spoken to someone at the Barbers Board, and from one of the questions I asked them if they were ever considering giving any of our industry reciprocity with the Barbers Board. The answer was positively no. In their law, it says a cosmetologist must have, I believe it's 400 hours of continuing training to be a barber. There is nothing in the law that would allow a hair designer to go into barbering. 0 hours, 400 hours, 500 hours. Their law says cosmetology. My question is, too, why would we want to put barbers in our cosmetology salons and take away from our cosmetologists? If they want to be a cosmetologist, they need to go to cosmetology school. They need to put in their time just like everybody else did. It seems like we're trying to give away our industry to another industry entirely different. Make them go to school. Do not give barbers reciprocity into the hair designer program. I think and if I'm not mistaken, years ago, was it not 600 hours to go from barber to cosmetology, and then they reduced it to the 4? At one time, it was 600 hours. It was always 4? Okay. So I don't understand all the changes we're trying to do when it's worked for all these years.
Ms.
We're
Moore,
trying to put new laws into place that are ridiculous. I don't know, my 3 minutes are up. Bye.
No, Ms. Moore, I was just going to say as a point of clarification, the State Board is to protect the public, not any one specific industry, even the industry that we govern. Thank you. Any further comments? Okay. Is there another section, Mr. Nixdorf?
Yes.
Oh, goody.
No. Okay. All right. 1708, hair braiding. This was to a consistency thing. We added in any other tests or exams the board deems necessary to make it consistent with all the other testing and language that we have. Then we took out voter registration card, and basically we just cleaned up the language here. Then we created a shampoo technologist because we received input from the public that says they wanted to have a shampoo technologist so that we could get and bridge the gap between the school and the salon by allowing individuals to come into the salon and under the shampoo technologist umbrella be able to do some work inside the salon. This is a pretty contentious thing. Some people think it's a good thing. Some people think it's a bad thing. It's ripe with potential for abuse, but I feel personally pretty passionate about the idea that we bridge that gap so that people who are in school can come into the salon and get some training and get some experience within the salon, and that we have a little crossover with the schools. So this is what we came up with. If you want, this was contentious at the time. If you feel you want to open it up for public comment, I'd be okay with that too.
Well, let's start with the board members for sure. Does any board members have any questions of Mr. Nixdorf?
I just want to make a comment here because I agree with Perry that I think it's also an opportunity for someone that maybe can't take the cosmetology test, but yet they can take a shampoo test and be able to pass it. Or an older woman maybe that does not want to get into hair design, and they can come in and maybe work for a son or a daughter shampooing hair. But it also allows that person to know you can't go shampoo hair unless you have a license and you have to know what you're doing. And because we had one case where the person came in and they didn't realize that they couldn't do something. This way there's more clarification that they know they have to have a license to just shampoo hair.
Yeah, and also we gave it to 16 years of age in here so that somebody in school, we could have an after-school job entry. I mean,
we can be an entry-level job for people, but they may not necessarily realize that what's all involved at the age of 16 or 17, and they can come in and take a couple of hours here. What we said, 300 hours is what we gave them. And for 300 hours, they can figure out whether or not this career is for them before they invest and do their full 1,800 hours at this point. So it saves them some money if they figure out it's not for them. It's a good thing. And so we felt that all around there was a lot of advantages to this. And anyway, so it's here.
Mr. President,
Mr. Leader.
I do think that the shampoo technologist is a super nice open door for some folks into our industry. I'm just slightly concerned about the terminology practical training of at least 300 hours at a licensed school of cosmetology, only in that when I signed up for cosmetology as an esthetician for the school, I wasn't able to receive practical training until after a certain number of hours had been completed in study work. So is there an implied 300 hours of practical training? They've completed a certain percentage of the required number of hours before they could be on the floor working on a paid customer. What is that? What is the definition of that practical training, and when does that 300 hours start? And if the student is enrolled at the School of Cosmetology, are they enrolled as a shampoo technologist for the school?
Yes.
They are.
Maybe half in theory and half in practical?
So what was the intent of the Law Review Committee in terms of when did that practical training start?
But I think when we had the meeting, several of the schools were there, and it would be something we'd have to work out with the schools if this passes, is to come up with a program at that point in time, because if it doesn't pass, then we don't. But I think that's really something that we have to sit down and sit with the schools that really wanted to do this and offer this and come up with a program that way.
Exactly. So the idea is that if it were to pass, that we would sit down and just like we do for all the other licenses, we dictate that says this is this and this is so many hours of that, and you know that we would prescribe of those 300 hours, we would prescribe that 100 be this and 50 be that and 25 be that, and you know that would all be defined later, but we'd get this done first and then go from there.
But was it the intent of the Law Review Committee that the student begin practical training?
No.
Right away?
Not from ground zero. No, the intent was not that they could walk in the door and on opening day start shampooing. No.
Maybe take out practical and just use training of at least, and then let the schools figure it from there?
We could do that. That would be clearer that way.
Mr. Leader, do you have an objection to that?
I think that's an excellent suggestion, is to try to facilitate that shampoo technologist. I do think training is a good solution.
And just so the rest of the board knows that may not have attended that meeting, just like Ms. Booth was saying, the 300 hours is really also to be consistent with what we require of the schools. The students can't touch the public, can't perform practical services without 300 hours of training. So this is a consistency thing, that you would have the same 300 hours, and then they could be doing shampoos, touching the public, and doing the things that they would be trained for in this. But that's for both sides. The public would not have any contact until there was 300 hours of training.
Please make a motion.
So, Mr. President, I'd like to then make a motion for agenda item 1709, the shampoo technologist.
We have public comment down in Las Vegas.
After public comment.
I'm sorry, Alex. Oh.
Okay.
Hello, this is Gwen Bramo, last name Braimoh from Expertise Cosmetology. I wanted to go back to the hair breeder's license. I actually made it a point to attend almost every one of the law subcommittee meetings, and we as schools, and me in particular, time after time discussed about the hair braiders being grandfathered in.
I'm sorry.
I'm not quite sure.
I'm sorry if I can interrupt you for just a second. We're actually not on the hair braiding. We've moved on to the next topic.
I know, but I was here waiting to public comment, and I wanted to make sure it was on the record, because what I don't want to happen is what happened 2 years ago with the last executive director, that we as schools had to go out and lobby our own legislators to get some things changed. So it was made known with the Commerce Committee that the schools and the board should be working together. So I've expressed this, it's been overlooked, and I'm not quite sure where to go, but I will know where to go after today. But there's not a threat, and I'm not doing that because I'm not that type of a person. But what I wanted to say about the hair braiders, because it was pushed through just like it was just pushed through a few minutes ago. And what I'm saying is, if we need to take a look at the grandfathered in. I was braiding hair at 14. I have a 17-year-old daughter. They'll be going off to college next year. And I could sign an affidavit saying she was braiding hair because she can braid hair. So should we give her a license without any formal training? I'm just kind of confused about it. It seems like everybody has a personal agenda, and it should be for the safety of the public, the technicians, and the school. I know what the board responsibility is clear. But I have discussed this in the law committee, and I just wanted to make sure today that it was on record that it has been overlooked time after time. And I just wanted to put it on the record today. And I don't want to take bills, and I don't want to go to legislators and lobby my own to be arguing with state board. So if we could take a look at this grandfather clause, that how many licensees can I ask that has license to be braiding that's actively working in the salon?
Mr. Landry, do you know that number?
It's a number somewhere below 10. I think it's 6 or 8 braiders that are currently licensed within the state.
But are they working in the salon?
That I can't tell you. They when they're licensed, they will put on their place of establishment or place of business that they're working, but we don't keep tabs on who's actually working in a particular establishment. We inspect, but we don't record who's practicing in which establishment during our inspection process.
Is there any way we can just kind of find out so that we can have for future reference, that we can go back to legislators to say there's 8 licensed braiders, there's 0 working in the salon, so there's still 0 taxpayers. So it's giving them a right to advertise on Craigslist saying I'm doing braids for $200 at home, because the history of braiding, I'm for braiding. I'm for a natural hair care license. I'm for all that, because I believe that we should be assets and not liabilities. But I also do believe that we as technicians should also have the right to go to work and pay taxes, and our students should be paying back student loans.
I'd like to say something here, and if I'm saying it wrong, please somebody let me know. I got on the board, I came on the board just about the time this happened, and it was my understanding that there was a legislator that did this, and we were kind of given it to manage, so as well as the eyebrow thing. So we really didn't have input into this. It was just given to us. So that's my understanding.
No, I was actually there, and we lobbied, and we were all in Carson City with the last executive director, myself and a couple other school owners. We had to pick our battles at that time, but that grandfather clause was something that was slipped through without the schools being notified or knowing to the last minute, and they tabled it. We had to pick our battles, which we did, and we decided that we will look at it come 2015. And it was not the legislators. It was the executive director of the State Board of Cosmetology.
Gwen, just quick question.
Yes.
Quick question. If you had your way today and you could make the decision, what would you ideally like to see happen?
Thank you. I would like to see, because I would love to have a program that we taught our students more than just to braid hair, because it's more to just braiding hair. You still have to be able to have some cutting techniques, chemical techniques. The average braider, Miss April, is they color hair, they cut hair, they use chemicals around the edges. I mean, they do so many other techniques which they need the training, and they need to be educated with the sanitation. The average person has been wearing braids for years, and the hair is not kept healthy, and they don't know hair structure. You can see the loss of edges. And I'm prepared to bring documents to show what other states are doing about these braiders. I'm prepared to bring documents and pictures to show the damage that could be actually done that's permanent.
So you would like to see this? You would like to see this next. You do not want these people grandfathered in. You'd like to see an actual program for braiding implemented as a
absolutely.
In addition. Okay, I just wanted to get real clear on exactly what you wanted.
I just think it's unfair to be grandfathered in. I mean, we have students. The majority of our students are. We have 2 campuses, so we have a multicultural school. But the average student and the average African American, trust me, we've been braiding hair since we was 10, 11 years old.
Sure.
So I could say right now, my daughter's 17. I would love for her to make tons of money in college braiding hair. So if that's the case, I can help her, prepare her to pass the exam, because she could pass the practical without a problem.
Thank you.
I'm confused, and these braiders are not working in salons. I know this for a fact.
Thank you very much for clarifying. I know this cause is important to you, and I've heard you speak before. I appreciate you clarifying that for me today.
And
thank you.
Just if I could ask a question. I mean, hair braiders still have to work in salons under the law, don't they? So
under the law, yes, just like people who are doing services outside of salons are doing it illegally. We know that that's a practice.
Because I was going to say,
on.
I mean, if we have licensees doing work not in establishments, that's something that the board can follow up on. And it does look like, at least in 644-208, there's a 250-hour training education opportunity there. I mean, do we know
That's
if anyone's...
only if you haven't been braiding hair for a year. That's only if your ancestors haven't been braiding hair. So my ancestors and the average ancestor has been braiding hair. Their kids, you teach your kids how to braid hair. I've taught my kids how to braid hair. And my grandson is almost 10. He probably could do a plait. I'm serious. This is how our family history, how long we've been braiding hair.
Okay.
It's a generational thing. And I'm not for the braider's license. Don't get me wrong. I will support that license. I'm just not in support of the grandfather in.
Thank you very much.
Thank you.
How many more items in this section do we have, Mr. Nixdorf? How many?
I think, Mr. President, I was just...
6 more items? Okay, so I know, Alex, you were going to make a motion. Can we take a break? Mr. Nelson needs a break. So if we could do that for about 5-10 minutes, we're going to take a little recess, and we'll reconvene at, well, it's 18 right now, so 30. So, yeah, at 3:30. Thank you.
I'm not sure what she was asking for us to do.
She wants us to cut a section of this.
Yeah, she doesn't. She's upset about 644-209, where it says that if a person has practiced hair braiding.
Okay, let's reconvene ourselves back into session. It is 3:27, close enough to 3:30. Nevada State Board of Cosmetology.
Mr. President, I wanted to make a motion for agenda item 1709 under the shampoo technologist. There was a suggestion that the item NRS 644.201 number 5A, that the word practical just be removed in training of at least 300 hours at a licensed school of cosmetology.
I'll second that.
So we have a motion and a second before the board. Any discussion for the board members? Okay, I'll entertain that vote. All those in favor say aye.
Aye.
Aye. All those opposed? That motion carries. Mr. Nixdorf, moving right along.
Moving right along, 1710, threading. Here we added some language to add an email address, charge a fee greater than $25, went from may to must, as far as the board must, during regular business hours, inspect any facility in the state we took out the ambiguity that we could possibly not inspect threaders. And let's see here. Over here, we took out practice of cosmetology by certain licensed cosmetology professionals and registered threaders. A lot of this stuff was cleanup language to make sure everything was consistent and inclusive with all the other parts of the cosmetology field. Restrooms, we added restrooms to each cosmetological establishment facility where threading is practiced. So if they're threading in a mall or something, they still need to be within 100 feet of the toilet and so on and so forth. Added them into the walls, floors, ceiling. Basically what we did here is we went through all the different stuff. Oh, and these are NACs. I'm sorry. I'm going through the wrong stuff here. What we did is we changed a few things in the NRSs, and then you have some items here that are NAC to show you what kind of changes would be made to our NACs. So those are not necessarily what we're moving forward to the legislature. So I'm going to skip right past a lot of these pages because it's all NACs.
And right. Mr. Nixdorf, I just wanted to clarify that you had said that the board shall not charge a fee greater than $25.
Is that what?
I think I heard you say you shall charge.
Yeah, I sort of skimmed across that. It says the board shall not charge a fee greater than $25 for registering a person. Because right now it says that we don't charge any fee whatsoever. The board shall not charge a fee for registering a person is what it currently says. So we added the fees in there so that we could get some money for doing that work. All right, then license renewal. This was another big item that we felt.
Can I just make a quick comment about the fee, just so y'all know?
Yes.
That's a hot button topic, I'm sure you're aware. So it was my understanding in previous legislative sessions that the governor was vetoing any bill with a fee in it. So it's just something to keep in mind. I don't know. I mean, $25 is clearly not a lot, but I just want to let you know that the fees are highly scrutinized. I mean, I think in the past, clearly this was done without a fee at all, so it'd be nice to have some recouping of the board's costs and keeping track of this, but I just want to let you know that may be something that could be a problem, and maybe at some point the lobbyists may recommend it be removed. I don't know, so that the bill can go forward.
My discussion with the legislators, it doesn't appear as though it's going to be a big red flag, but that's only with a small group. Just to let you know, for any fee increase, to Ms. Bradley's point, any fee increase requires 2/3 approval of both the Senate and the Assembly side. So I'm not saying take it out. It's just I just want to make sure the board's aware we can move forward with this, and my recommendation would be to move forward with this, and make sure that we're equitable across all licensees and registrants. But the reality of it, it's going to be a very tough process to get through that. So I think that's what Ms. Bradley was trying to make sure that everyone's aware that just because we say it can be so, it doesn't necessarily make it so.
And I think it's like discriminating that we let everybody else has to pay a fee but one sector of the organization.
If we think that we're going to hit a snag and this has the chance to be a red flag like that, will we know before we submit?
Yes, we will.
Because something would be a shame to have something like this.
Any legislation that goes forward, there will be many, many conversations among the legislators about what they like and don't like about it. And I'll be all next year. You'll probably be getting maybe daily reports on some of the stuff that's going on because things do change pretty rapidly in the legislature.
Thank you, Mr. Landry.
Mr. Landry, how many registered threaders does the state of Nevada have at present?
That I don't know off the top of my head. I would have it's not part of our regular system. It's not in the Versa, our back office system. It's on a spreadsheet, but I can get you that number. I'll do that as a follow-up for the from this meeting.
I mean, but if there were...
If you could, please.
Are there 10?
I have no idea. I've never looked at the list. We don't inspect because it says may. We don't inspect the threaders. We have very little power. Even if we inspected, we have no finding or citation ability. So it's not a high priority for the board when we have other things that are more pressing.
Okay. License renewal, item 1711. All of this stuff is designed to give us a 4-year cycle between licenses instead of a 2-year cycle. All the fees were identical. They were just doubled. There's no real increase in fees except for the fact that you're paying for 4 years instead of 2 years. And that's what all of that is about.
And then, Mr. Nixdorf, just to clarify, under on page 2 of 3, item number 2, there just should be a $sign for 2C. They're at 200 there.
Ah, yes. Okay. Okay.
Also, this one was on page 1 of this was where I noted that it says department and it should probably say board. I mean, I think the LCB would fix that, but just so you all see that too.
Okay. Service animals, item number 1712, was modified to be more consistent with the current language for the service animals and stuff, so that the Americans with Disabilities Act. Then we had agenda item number 1713, supervision. This is in reference to all the leased spaces and stations that we have and making it a little bit more clear as far as who the supervision is, the supervising person in a salon. So that was that.
I just wondered, and this is just me, and I'm sorry, if you look at that, supervised by a person who's licensed and all the cosmetology services being performed, if we had a hair braider, for example, working in a salon, would the cosmetologist in charge then have to be licensed, or how does that work? I mean, is a cosmetology license enough to supervise a hair braider? I don't know. I just wondered.
I believe it is.
It is. Cosmetologists can do any and all services, so they can supervise a hair braider. And also, the reason why this provision is being cleaned up, if you had a hair braider and a nail tech practicing, and that's the only 2 people in the place, each of them would have to be the person in charge of that practice. So, and the reason this is important is there for citations and fining, it goes not only to the individual, but to the supervisor and to the salon. So knowing, having someone who is responsible, you can't just say the nail tech is in charge of the hair braider. Can't happen. That nail tech is in charge of the nail tech. This is mostly for small salons. It usually doesn't appear. In bigger salons, it's usually a cosmetologist in charge, so they can have all practice areas. But there are many small salons that we wanted to make sure that if someone's practicing a service, they must have someone in charge of that service who practices in that profession area.
And it could be just one person then.
Yes, it could
So
be.
if you had just one hair braider working, they could be the hair braider in charge, and then you can have, say, an esthetician in charge and a... Okay, all of a sudden it occurred to me if hair braiding is different, because we just had that discussion, did we have a problem? But okay, thank you.
All right. Then we went to plumbing. It was brought to our attention by staff that there's no requirement for shampoo sinks, and we thought we should put some shampoo bowls in as mandatory equipment, and so that's where that is.
And those changes are only to NAC. This is
That's
one area
right, there it is, NAC,
where it's
right.
just NAC, and this is just informational only, so that you would see the what the law committee discussed.
That's why you highlighted that I just didn't look at. Got it. Okay. Then this is the last 1716 is the resort license wedding services that we covered last board meeting, and that's 1715. I don't have a 1715. Do I have 1715? Oh yeah, that was the first item that we did. That was item number 1 where we changed it to 1,600 hours. So we've already covered that one. Okay, and that was it. So I would respectfully request that you approve the changes in total that will be moved forward to the legislature this year that our committee worked on.
I'd like to make a motion to move forward with the changes in total.
With the revisions that we made there.
With the revisions that were made.
And I'll second that.
I'd like to second that.
Okay, so we have a motion and 2 seconds. But previous to moving on to that, if there's any further public comment that people would like to make, or any comments from the board, let's start with the board and then we'll move to the public.
Okay.
Neil, I'd just like to bring to everyone's attention on the board, there is a movement by the U.S. Department of Education to analyze, investigate, and potentially change regulations that would have a pretty big economic impact on the schools within the state, not just in our state, but in states across the United States. They're looking at private career colleges, private career schools, which would include electricians, plumbers, cosmetologists, any post-secondary education that you get in a private institution. It's being looked at pretty hard by the Department of Education. The problem is I don't know all the details yet. They just came out with the first draft of those regulations at the last NIC regional meeting. They were showing us the 2 inches thick of regulations they're coming out with. So my request to the board would be whatever you move forward in the hours area, whichever way you decide to go, the 1,800, 1,600, whatever it is, that you would also give me some discretion that as these things change with the Department of Education, that I could get back with you and with the legislators to figure out what's going on and come back for potentially revising that one particular section. It's just, it is if it goes the way that I've heard, some of there are doom and gloom reports. It's going to have an impact, a big impact, but not a huge impact. And then there are other reports that it may or may not impact at all. So because it's an unknown at this point, my advice to the board would be do what you want to do today as far as adopting what you want, but give some variability in that particular area, and I can give you updates as they become known to me.
Mr. Landry, have you heard anything from some of the larger companies about the hours that you think they're leaning towards?
The Department of the latest that I've gotten from 3 sources who do lobbying directly with the Department of Education is they're trending towards the 1,600 hours. That is what they're doing, and the fear is that they would fund to a particular hour level and then stop funding. So in the case of Nevada, if that meant we had 1,800 hours to get the schooling for your cosmetology license, and they funded to 1,600, then you would have Title IV funds available up to 1,600. The last 200 would have to be privately funded by whatever means possible. So that it's way too early in the discussion with the Department of Education. It's a big department. There's a lot of things that go on. There'll be pressure from all the senators and representatives that we've elected for the state. But just to make it's a topic or an issue that I'm aware of, and it's changing. I can't give you a definitive on what it's going to come out to be today. I'm not that close with the Department of Education, but I do get updates from some of the lobbyists that work with them.
Mr. Landry, so it sounds like there could be a potential for a higher dropout rate.
Not necessarily a higher dropout rate, but a much lower enrollment rate if this goes through. Again, this is all supposition. There's no known facts. As soon as I get the exact copy of the draft regulations, I'll read them, and I can give a report to the board then on my weekly report to let you know what's going on.
And now will be the time for public comment. If anybody'd like to step forward, as you guys have an audience down in Vegas and we have none, if there's anybody there who'd like to step forward and make a comment about these proposed changes, please, your first and last name and spell for us. Thank you.
Thank you for giving me this opportunity. My first name is Willa, Willia. Last name is Chaney, Chaney. I just wanted to make a statement here. You know, we have sat in the audience for as long as you have, and we were told we were at, excuse me, I forgot to tell you where I'm from. I'm here from Expertise Cosmetology. And we were told if we had any objections to come to the meetings, we would be allowed to speak. Yet, I must agree, you gave us that opportunity to speak, but yet you took notice of nothing we said. You know, I hate to not be a person in this community and not having the opportunity to work with the board, but I would just like to ask one question. Why did you all take comments from us if you were not going to take it in consideration what we said?
Well, I actually feel we did. I very much appreciate the comments that were made, particularly by Ms. Bramo. It opened up a lot of insight for a lot of the decision making that I've made. With each area of public comment, I feel quite confident that I evaluated the statements and the concerns, and those did help to shape my opinion during the voting process.
But it changed nothing. That's my point. It could have shaped your opinion, but you still voted the way you had proposed to vote. You know, we were there the last time.
I had no preconceived voting intention. No, I made my vote based on the comments that were made by the other board members, by the executive director, and by the members of the public. I did not make votes that were contingent upon a preconceived idea or notion at all. My votes were made specifically based on the comments that were made here today. And I feel quite strongly that the other board members feel similarly. The comments that were made by the public were very insightful and certainly welcomed. And I don't feel I could have made a decision without the comments that the public made today.
I guess you're not understanding my question. It's still status quo. You still made the same objection. The things that we objected to, you still made the same vote. I mean, what we said didn't really mean anything that much because nothing was changed. Things still remained the same. So this is all I have to say. We certainly will be watching the bill, and we certainly will be protesting, going to our legislator and letting them know that we attended every meeting as he suggested that we do. We made our comments, but to no avail. So thank you.
Can I ask a question of Willa? Willa? And she's gone.
Thank you very much.
She's back.
Well, yes.
Yes, this is Willa again. Did you have a question for me?
Willa Janepinaldi here. I think it would be helpful if you were more specific about the question you're referring to, or the statements that you're referring to. It seems like you have something in mind.
Well, at this moment, I can say all of them. Gwen got up and made a statement about grandfathering in the Raiders. we made statements about allowing barbers to come in to this profession, to the cosmetologist profession. We made a statement about, Gail, what was your statement? I forget.
Reducing the hours.
About the hours. So all those things that we made reference to, and as I see right here, nothing was taken in consideration.
Okay. Well, I understand what you're saying, but I think you're not understanding how this process works. What we're doing is we're taking comment.
I do. I understand the process. I sat on boards before. I sat on the Nevada State Board of Education, and so I understand your process very well.
Well, we can't change law just sitting here. I mean, we could talk about it and make adjustments as best we can, but it still has to go through all the legislative process. So we did, absolutely take into consideration. We want to help, move things forward in a way that reflects goodwill for, good sanitation and safety for the general public. We're all on the same page. So
I was under the impression that you were here changing law. That's what the law committee was for, was about. You changed the NRS through those various committee meetings you had. So that was the purpose. And then you came here today to present. If I'm wrong, let me know, and I'll apologize.
Well, that's
but you came here for those laws. You made a proposition that you were going to change those laws that you already had. And you had subcommittees working on those changes. We as GQ Public, we made our oppositions known, and today we made them known. But what I'm saying, none of those things were taken in consideration because we made statements on the things that we did not approve of. But yet at the end of this meeting, I'm not saying you specifically, I'm saying the board made the determination that they would go ahead as status quo, what you had already decided.
Actually, what we're doing is we're in the process of voting on a motion before the board, which we haven't voted on yet. And all we're doing with this vote, whether it passes or not, is these are proposed changes to the NRSs that we are going to recommend to the next legislative session. It doesn't.
I understand
it won't. And even at that point, it won't even be law until it passes the legislature. Just as a point of clarification.
I understand the process.
Okay. All right.
I understand.
Okay. Was there anything? Did anybody else have any other questions? Thank you.
I'm Sandy Dunham, Dunham, from the Academy of Hair Design, and I wanted to comment on the proposal of the reduction of hours. I was at the ACTS convention this past weekend and talked to the ACTS legislator and many other school owners, in addition to the board members. And I think we would be very premature in reducing our hours to 1,600 when we don't even know what the department's going to propose or what the department's going to be willing to fund. And I think that the proposal was made due to government funding. I think we're not in the government funding business, we're in the training business, and I think I think it's premature to start reducing hours in one program, which would be the Cosmo, when we don't even know what the government's going to do at this point. I don't feel we should start lowering our standards until we know if this is going to become a national standard. That's my comment. And I liked when Gary asked about giving him the authority to keep you apprised and then maybe make a determination and not go in and try to reduce the hours at this point.
Okay.
Did I make myself clear?
You did. Thank you.
Thank you.
Any further comment from the public? Okay, I'll entertain that vote then. We have a motion before the board and several seconds to move the agenda item number 17 forward to for the proposed changes to the NRSs, apart from the one NAC, correct? All right. All those in favor say aye.
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 All those opposed? That motion carries. Okay. Item number 18. Discussion for the proposed changes to the Nevada Revised Statutes, Chapter 644.470 concerning the use of salicylic acid.
I just want to give a little background on this. I don't know all the background because I wasn't involved in all the there was a committee that Mr. Leader chaired and had discussion about this with prior boards, prior meetings. And the only thing I wanted to give the board an update on, and which I've included in the packet, is as of March 2015, the FDA has proposed and passed regulations that any concentration of salicylic acid over 2% would be available by prescription only. That they're going to regulate it down to the only over-the-counter, so the only thing that a non-medical professional will be able to buy is 2% or less. And the other clarification is that salicylic acid can be used today in cosmetology salons. It just cannot be used at the strength level and for the intent of peeling the skin, because that's illegal under our current laws. So that's the only kind of background I wanted to get. Now I'll turn it over to the board for discussion.
Okay. Any board members? Mr. Leader, I know you're very passionate about this subject. Would you like to start us off?
I really appreciate you including the FDA study, and I just want to remind everyone that the top of that study says contains non-binding recommendations. So those recommendations may be subject to change. And as an esthetician, we would like to see the use of stronger percentages of salicylic acid allowed in licensed establishments by licensees.
Can I ask, do you use it to peel the skin? Is that what you use?
Salicylic acid is a natural sanitizing effect to the skin. So it's ideally suited to help flush the follicle of debris, tighten the follicle. It is a secondary use to enable a micro peel for the skin surface. That's not necessarily the intended use.
So if I'm not mistaken, the reason I asked for this to be put on here is because you had, before I got on the board, done this work on it, and you wanted to have some NRS changes attached to this. Was that not correct, or some legal changes being made? And I wanted this to be forwarded and incorporated along with our recommendations, and that's why I had this brought on to the as an agenda item.
That is correct. The aesthetics subcommittee, if you will, did ample research. We did make a proposal to the board, which was approved unanimously by the board a couple of years ago. It is the prudent advice of Mr. Landry that we don't make a change with reflective of the prohibited use of salicylic acid for the use of peeling the skin, because then, depending on the recommendation of the FDA, the law may in fact need to be changed again.
Okay, because I had wanted to make a motion that your recommendations that the aesthetic committee came up with be included with the packet that we present to the legislature for appropriate changes. Did you want to do that?
We would still propose that salicylic acid be removed from a prohibited list of ingredients. Yes.
So this is so if I make a motion that says to take your recommendations from your committee that the board has already approved and all that work's been done, I just want to move that work forward so that you get the changes necessary that you work so hard to get. And is that correct?
Yeah, I mean, it was certainly a group effort. The committee did its own research, but as it stands right now in NRS 644.470, nothing in this chapter permits the application of salicylic acid for the purpose of peeling the skin. And we would like to have salicylic acid redacted from that NRS, yes.
And that's what's on your committee recommendations that we would be moving forward, correct?
That has been the committee recommendation since, I believe, February of 2010.
Right. Okay, so I'd like to make a motion that we take the...
Ask one more question real quick, if you don't mind. Exfoliating versus peeling skin. Should we change that word, peeling skin, to exfoliating? No?
Well, what he was saying is that we just redact the NRS, right? So could you read for our benefit the way that would read?
The way that NRS 644.470 would read is nothing in this chapter, and then we would move down to number 2, permits the local application of carbolic acid or corrosive sublimates or their derivatives or compounds, resorcinol, or any other corrosive substance for the purpose of peeling skin. Any implantation of permanent pigment into the skin is prohibited.
Okay.
And just so the board's clear, even with removal of salicylic acid from that section, the use of salicylic acid or any corrosive substance to peel the skin is strictly against cosmetology law in the state of Nevada. So exfoliation is allowed, but the actual peeling, using the term peeling of skin and doing skin peels, is an illegal activity within the state, has been, and from my own belief, it probably will continue to be a prohibited practice for any cosmetology profession.
It's regulated under the medical profession, yes?
That is correct.
Okay.
Skin peels, as they're called, are only allowed by medical professionals. Exfoliation is always allowed by by estheticians and cosmetologists.
Licensed medical professionals.
Licensed medical professionals, okay. Yes.
So, Mr. Nixdorf, you're about to propose a motion.
Yeah. I would like that the work that was done by the Aesthetics Committee on this be moved forward, because the board approved it, the board moved to approve it, and I would like to see that activity be carried forward to the end result. I don't have it in front of me what that exactly is, but I know that...
I'm sure there's quite a few different sets of minutes about it.
Yeah,
yes.
I'm sure there is. So I just want to see that be carried forward just the same way that the Law Review Committee's work is forward. I think that his work on that should be recognized, and that it be moved forward in the process.
Is there a second?
I will second that.
Having a motion and a second before the board, I'd like any further comments from the board. No? Okay, we'll have that vote then. All those in favor say aye.
Aye.
Aye. Those opposed? That motion carries. Okay. Let's see here. Discussion regarding board travel and reimbursement policy for board members. No, not really. Mr. Landry?
Yeah, this was a carryover from the last meeting. This is on the agenda so that the board can give staff direct input as to the approved travel policies for both staff travel and board travel, and also for any reimbursement, to make sure that we have something that's approved at a board meeting and that we're all following it. And the various areas that would require board comment, suggestion, or approval is the means and method of travel to be consistent with the State Administrative Manual, Section 0200, which covers travel of all state agencies as well as state employees, and to get clear direction on the reimbursement for travel day, prep day, check signing, and any other authorized activities by the board, to make sure that we're very clear on what the dollar amounts are and what the length of time allowed for each is.
Okay. Would anybody like to propose a motion? Anything? Anyone?
I'll make a motion, Mr. President, to approve Agenda Item 19, the travel and reimbursement policy.
I'll second.
Okay, having a motion and a second before the board. Any further discussion? Okay, I'll have that vote then. All those in favor say aye.
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 And those opposed? That motion carries.
One additional thing that the board needs to do, so that covers all of the written part. The only other thing is to make sure I left blanks specifically so the board could vote on that for the reimbursement for travel day, prep day, and check signing, making sure that I understand exactly what the board wants to do. The amount paid and the duration involved, because there was discussion that some of the activities, it didn't matter what the duration was. Other activities like board meetings, less. And again, I don't have anything written. I don't have anything approved at board meetings. I'm just trying to get what the intent of the board is. 4 hours or less, more than 4 hours. What are the different rates and what are the different dollars that are going to be paid out, so that we're very clear. And then I'll have a published travel policy and reimbursement manual that we can then follow at the office.
I like the idea of half a day's 75 and a whole day's 150. I don't know how anybody else feels about that, but I felt that was fair.
I think that sounds acceptable.
I don't know what you normally get for check signing.
We get 150 for check signing.
I'd like to discuss the half day versus full day. When I'm taking a day to be on a board and I show up at 9 and it goes for 4 hours and it's 1 o'clock, my day is shot. I don't have the opportunity to
turn it into
meaningful employment at the end of the day. So I don't know. There's not much difference between a half a day and a full day for me. So I don't know that that's necessarily correct for me.
I don't have a problem with the 150 either, because I kind of agree with you. Once you spend half a day, and then you've got travel on top of that. So like for me, I've got another hour added on. So I'm really going over the 4 hours.
I mean, we have this meeting coming up in 2 weeks where we're going to spend a half an hour, maybe 45 minutes on a meeting, and we'll have some travel time involved and so on and so forth. And I can see that might be a half-day thing. But once you hit the 4 hour mark, once I get past noon, there's no opportunity for me to come back to work, really. And
right, the day's pretty much over for you at that point.
Why not just change the half-day to 2 hours? 2 hours. If you're just going to bip over there to do something, then 75 would be sufficient.
That would be more agreeable to me, because then I can, you can take the morning off and then work the afternoon, and that all works.
So the designation would be less than 2 hours, would be at half the rate of pay, and then for a board meeting day. Okay. Any further discussion?
Mr. President, I also wanted to add that under the procedure item, there's a blank for the travel expense form being submitted, and I just would recommend maybe 30 days, within 30 days.
Okay. And any further discussion, comments, anyone? So then,
just one question, Mr.
Do we need to motion this for you to?
Yeah, just a motion. In my assumption, I'm trying to pick up to make sure I get clear. Any activity of 2 hours or less is $75. Any activity of more than 2 hours is $150. Okay, so just so because I can then write it down and make it very clear on policy.
I think it was specific to like board meeting. Okay. The salary is based on a full day, but I understand Mr. Nixdorf's point. If you've spent even 4 hours, your day is pretty much done. So I think the designation is under 2, like check signing, and then either any time over that. Because same thing with the following meeting in 2 weeks. We're going to gather together, get to where we need to go for the meeting, have the meeting, and then after it's done, travel back. So by the time you're all done, that's about 2 hours anyway. So, I mean, just as a point of clarification.
Perfect. That's great.
Any other comments? So let's clarify this before we make a motion.
So travel day, are we still going to go with what we've been doing? Do we
Yes,
still?
everything's $150 except for 2 hours. Under 2 hours is $75. So your prep day, your travel day, and your board meeting day would be $150. Anytime we have to do something that's under 2 hours, it would be $75. If it goes over 2 hours, then it would be the $150.
And that would include check signing.
Correct.
Okay, are we designating it for check signing, or are we still talking about meetings?
That's what I'm asking, because check signing is that, how long does it take to do the check signing? It's under 2 hours.
It's
right?
definitely under 2 hours.
So do we want to designate that as $75?
Do you want to designate that as
I
$75?
don't know. You're the one that's getting paid. I suppose someday I will be paid too.
Yeah,
So
you're supposed to be the next president, all things considered, unless I get assassinated beforehand.
So I'm voting for a price decrease for myself here. Yeah, I think $75. I would go for $75. I think that's...
So the designation for the fees is on a travel day, we'll get the full per diem. On the board meeting days, under 2 hours, it'll be half, as well as for check signing. And then anything over 2 hours is the full. Is that correct?
Correct.
Okay, I'd love to hear that in the form of a motion.
I'd like to make a motion. The travel day would be $150, prep day $150. Any hours over 2 hours would be at $150. Anything under 2 hours would be at $75.
Is there a second?
I'll second that.
Having a motion and a second before the board, is there any further discussion?
I just wanted to add that would then need to be submitted within 30 days. Of that
And submitted within 30 days.
I was going to ask that because that's, if you look at the second page of the policy, that it's above the A, travel status, it says there's a blank within how many days of travel that the form is to be submitted. So I think that's what Mr. Leader wants to make sure says 30.
Okay.
And so that would mean you have 30 days from the board meeting or from the work to submit the
to
claim.
get reimbursement for your, okay. All right, any further discussion?
And then also, I think, just to clarify, the travel day and the preparation day are not necessarily the same. Those are two separate days. So,
correct.
okay, I just want to make sure, because I don't know that that was clear in the past.
Yeah, it's, you get a,
Oh.
yes. So having a motion before the board and a second, any further discussion? Okay, I'll take that vote then. All those in favor say aye.
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 Those opposed? That motion carries. All right, Mr. Landry, looks like you got about 18 minutes to get through this whole thing. No pressure.
I can actually get through it in 1 minute because basically all of the information from the executive director's report we're now providing in standardized format. We expect to do this before some changes from the last meeting. Per Mr. Leader's comment, we've taken off Reno and Las Vegas and made it north and south. So it's consistent with representing the entire state, not two metropolitan areas. Everything that we're doing now, we do have daily reporting, so we're able to track that and see when there are changes coming up, so that all the numbers you see here are just roll-ups for for what's going on monthly. We have noted both from a licensing, testing, and inspection operation. I think we're doing excellent job. I think staff is doing a great job on all three fronts. There's always room for improvement. We're always looking to improve, but that is one area that I think that we're doing very well in. Any questions that the board members would have on specific items on anything dealing with the finances, I can either answer them now to the best of my ability, or if I have to do research, or just as a part of my regular weekly updates. Anytime that there's questions about anything on here, be more than willing to answer the board members on a one-on-one basis. We also are providing reporting on what traffic we're getting to the website, and that has been consistent and improving. And we look forward to having much more. Just one of the things we're watching out for from a reciprocity standpoint, we're trying to correlate if there's a correlation between the people looking at the website, like we get a lot of visitors from California on our website, to see if that's also a trend in reciprocity applications. So we're trying to predict where our staffing requirements would be and what we'd have to be working on to see if we see an uptick in particular areas. We not only get what I'm reporting to you, which is gross visits, but we can actually look at where they're looking on the website. So when we see a lot of hits to the reciprocity page, and we're going to be beefing that up over the next month, we can then, like I said, we'll be better prepared to handle those when they eventually come across the front counter.
Do we get many requests, people looking at the law section we put in? Is that?
We do, and that's actually one of the areas that we're going to be, we've translated the law information bulletin into 3 languages. We have it English, Spanish, and Vietnamese. We're planning on having that same, we're going to start with the sanitation section of the law and do the same thing, translate the sanitation sections into Spanish and Vietnamese so that we can better service our licensees, so that when they come before the board and say they don't understand it, we want to make sure that's never going to be the case. We want to make sure they all understand what the law, in terms of sanitation and infection prevention, we want to make sure they understand that.
Thank you.
Perfect. Thank you. Anybody have any questions for Mr. Landry? Mr. Leader, I'm sure there's a punctuation somewhere you found, yes?
So impossible.
Poor Mr. Leader.
I just wanted to point out, Mr. Landry, it seems like on the testing summary that we're averaging approximately a 25% fail rate. Is that about correct?
That's about correct.
Okay. And I also wanted to double check on the licensing summary. Are we going to have enough instructors for the schools? Because the instructors seem a little low, the number of licensed instructors.
Those you're only seeing the licensed instructors who've renewed for that particular month. So to get a better view of, some instructors, we may have a concentration. I don't know. To be specific, I don't know the total number of instructors that would re-up and relicense this year. But if that is a concern, we can have that as a continuing report when we get to an annual basis. I could always compare annually what we did this year versus last year, and then in each licensing category, so that we know we're generally growing in all licensing categories. Or we're growing in overall licenses, but by category, we could take and analyze that to see that year over year that we're seeing a proportionate increase in instructors to match with the number of students, the enrollments that we're getting.
And is there a requirement under NRS or NAC or just a policy of the board that requires a certain number of instructors per the number of students?
It's actually in NRS and NAC both, and there is a required minimum number of instructors for I don't know it off the top of my head, but for having X number of students, and if you have more than that, you have to have 1 instructor per Y number of increased students. But that is codified by both law and regulation.
And the inspectors are trained to look for that during their school inspections?
Absolutely.
Did you roll out the FAIR inspection process? Did that roll out in April?
The FAIR inspection process is actually rolling out in May. We were doing quite a few other things that we're going through. The translation from Versa to GL Solutions is taking up a bit more of my time than I anticipated, but it's good time spent because it is going through every process that we do and making sure that we're taking out any roadblocks that would impede us with the new technology. But our plan is to roll out the FAIR process in May. And just to bring the rest of the board members up to speed on, just as a reminder, the FAIR process is where we're going to do less inspections for salons that have, and establishments that have stellar records, have never been fined or assessed a citation, and to focus our efforts on going to those salons that need help and learning to do better sanitation and infection prevention techniques, that we're going to visit them more often.
And then finally, just lastly, do we have a policy for having the final orders prepared after the citations have been heard, or after the respondents have been come before the board?
I'm not sure what you mean by a policy. We have the state has laws, NRSs that cover what has to occur as far as final orders going out. I don't know what Ms. Bradley could probably speak better to the required timing on any of that as far as what the law stipulates.
The law requires 60 days.
60. Okay, thank
Yeah, it's in 233B, and so you have 60 days to send it out in writing. But normally you also rule here from the bench, so to speak. So, I mean, they know what the decision is. It's just a matter of getting the written order. And the policy, I mean, we don't have a formal one, but I keep notes of what you've done. And if I have questions about my notes, I check with Monica or read the minutes, and then we draft the order. So sometimes I have waited to get the minutes. I did do that, I know, at least once, but. And then I draft them, I email them to Monica, and then she sends them out to the licensees after they're signed by the president, so that way the board has a copy.
Any further questions for Mr. Landry? Okay, I'll entertain a motion.
Mr. President, I'll make a motion to accept the executive director's report, which includes the items as listed on our agenda.
I'll second that.
Having a motion and a second before the board, any further discussion? Okay, I'll take that vote. All those in favor say aye.
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 Aye. Those opposed? That motion carries.
Mr. Chairman, I'd like to request that we open the law subcommittee item open one more time. I have a brief comment that requires some action on our part.
Okay. Back to 17.
Mr. Landry, you were at all the meetings of the law subcommittee. You are clearly informed as to the intent of all of the proposed changes that we make. I'd like to make a motion that we authorize you to negotiate in our best interests because those negotiations are fluid, and I would hate for you to have to lose something because you have to get authority from us. So my motion is to give you authority to negotiate in our best interest as laid out by the intent of all the meetings.
I'll second that.
Having a motion and a second before the board, any further discussion? Okay, I'll take that vote then. All those in favor say aye.
Aye.
Aye. Those opposed? That motion carries.
And a comment on that particular motion, if something comes up serious enough where I don't feel comfortable making that decision, we can call an emergency board meeting, and I would coordinate that with Sarah on getting the agenda posted in the correct amount of time. We can actually have telephone conference meetings where we allow the public to dial in also. So if it, I've never been through a legislative session from end to end. So as we go through this, if there is something that comes up that would require emergency action by the board or something that I don't feel comfortable in representing, I would make sure that we, that we convene a meeting to discuss that.
Thank you.
Perfect. Thank you, Mr. Landry. Okay, agenda item 21. Comments from the board members and future agenda items. Ms. Benaldi, I believe you had something to propose.
Yeah, I'd like to propose that we take another look at Mr. Landry's salary. I'd like a complete package of his compensation to be presented, as well as comparables in the market for his job position in the private and public sector.
Perfect. So noted.
Mr. President, I also wanted to just make a comment, and perhaps Mr. Landry could confirm this, but in terms of our inspection department, Mr. Landry, estheticians with a closed door are not necessarily exempt from having an inspector open that door. Is that correct?
That's correct. We do try and
observe some modesty of the client.
Protocol and all that. We would request the licensee to open the door so that we could take a look at it, not necessarily during services being performed. So we try and work our schedule around that to be as unobtrusive. That's our desire in any, not just estheticians, but in all salons, to be unobtrusive. We have a job to do, and we are here to protect the public, but we don't want to be disruptive to business.
But estheticians do understand that their door can be opened by the inspector and inspected during the time of a service.
I believe that's specified in NRS. I would assume that they would be understanding and knowledgeable of the requirements of NRS Chapter 644.
In a continuum to that, if an inspector has gone into a salon and multiple times, and they've have these closed doors, whether they're not there or they haven't inspected or they've had a client, is there a record that they can go back? I mean, is there a record kept of somebody who is not inspected time and time again?
All inspectors make notes on their inspection because we don't use the same inspector for, we have multiple inspectors, so that the next time an inspector comes in or on the next scheduled date, they would make sure that, that they would be noted that they didn't have access to a particular room. If we see that as a pattern happening, we take action. We would open an investigation at that point.
Okay, thank you.
Any other comments by board members for future agenda items or any other thing? No? Okay. Item 22, comments from the general public.
Excuse me.
Yes.
Hi, this is Pamela Fitzgerald. Comment on the question Alex asked. What we do as inspectors, we're not intrusive, but if we go to a salon, if we go there and they're doing a service, God forbid a bikini wax, we don't just go, or coming in, we'll usually go to the person in charge and say, can you go get that person's license out, or can you call them and have them give us a license? Pertaining to what April said, if we go to a salon and we've been there more than once, more than twice, we can't get in, we'll call the esthetician and say, hey, we're going to be there, and can you please let us in to inspect the room? So we do inspect the room if the door is closed. Alex, leader.
Thank you.
Thank you, Ms.
Did I
Fitzgerald.
answer questions?
Yes, thank you.
All righty.
Is there any member of the public there in Vegas who'd like to come forward and speak? Now's the opportunity. Anyone at all? Okay. Having nobody step forward from the public for general comment, the last item on the agenda is adjournment. It says for possible action. Would somebody like to make a motion so this is all official and stuff?
I will make a motion to adjourn.
Do I have a second?
I'll second.
So I have a motion and a second before the board. Any further comments, cares, concerns? No? All right, I'll take that vote. Then all those in favor say aye.
Aye.
Aye. Those opposed? That motion carries. And we are adjourned. Thank you.